welcome back to Tampa City Council. If we can get roll call, please.
Yes. Carlson. Hurtak.
Here.
Clendenin.
Here.
Henderson. Vieira.
Here.
Miranda.
Here.
And Maniscalco.
Here.
We have a physical quorum.
All right, we left off with the 10 a.m. public hearings. We already made a motion to open all public hearings, so we're going to go to item number 36. Ms. Weld, if you want to start it off. Huh? Oh, and before we begin, it's a quasi-judicial hearing, so if you are going to speak on items number 36 or 37, please stand, raise your right hand, and we'll swear you in.
Do you swear or affirm that the testimony that you are about to provide is the truth and nothing but the truth? I do. Thank you.
Yes.
If there have been any ex parte, I'm sorry.
Turn on the microphone. Thank you. I thought I had pressed the button. Martin Shelby, City Council Attorney. Good afternoon, City Council. On DEI 1-23-247, the property located 406-412 West Paris Street, item number 36 for this review hearing, have there been any ex parte verbal communications, and if so, would you please disclose them now for the record? Councilman. Mr. Chairman.
I received a phone call to support this property, and my response was, go to the website and email City Council, and that was it. That was the extent of the conversation.
Okay, thank you. Any others? Okay, seeing none, a question then for Councilwoman Hurtak. Ms. Hurtak, I understand, well, first of all, let me ask you, have you had any contact with any party in this matter?
No, not since this was filed.
Okay, and let me ask you this. I believe that your spouse is on the board of one of the neighborhood associations, is it
Old Seminole
Heights Neighborhood Association? And have you discussed this matter at all with him?
No,
Okay, and do either of you have a financial interest in this matter?
no,
And are you able to be fair and impartial, and would you base your decision solely on the evidence at this hearing?
yes.
Well, thank you very much then.
Okay? Yes, ma'am.
Thank you, council. For the record, my name is Kate Wells with the legal department, and with me this afternoon is Eric Cotton, the city's zoning administrator. And also, I've handed out proposed procedures for today's hearing. They are consistent with the process this council has followed in the past for other review hearings where the applicant is someone other than the owner of the property at issue. So we're not proposing anything different in process than what council has followed in the past. Item 36 is a review hearing from a decision by Mr. Cotton with respect to an application for design exception, DE1 23-247, for the properties located at 406, 408, 410, and 412 West Paris Street. The purpose of today's hearing is not to establish the build-to line. Instead, the purpose of today's hearing is to decide whether to affirm or overturn Mr. Cotton's decision approving the design exception which granted relief from the strict application of the code with respect to the build-to line for each parcel. I wanted to just mention for the record the hearing procedures that I've provided to council. A copy of those proposed procedures were provided to Mr. Leinhard and to Ms. Corbett on January 19th. And on January 22nd, they were provided with copies of the record on the design exception 1. And just to be clear, and those documents have been uploaded to Excella. It includes a copy of the application for design exception. It includes the notice that was required at the time the application was filed. It includes a copy of the city's decision letter dated November 14th, 2023, as well as public comment that was received during the open record period on the design exception. The city received documents from Mr. Leinhard, as well as from an individual named Sterling McLemore. I also included copies of the relevant code sections. I thought it was important for all the parties to this proceeding, as well as council, to have access to those code sections in the agenda. It includes a copy of Section 27-60, which is the alternative design criteria under which Mr. Cotton issued his letter. It includes a copy of Section 2761, which is the review procedures that we're operating under on today, and Section 27-211, the Greater Seminole Heights Vision, and then finally a copy of Section 27-159, permitted projections into required yards. Section 27-61 identifies those administrative decisions which may be appealed to City Council. This includes decisions by the zoning administrator, which are often referred to as an administrative review permit or an AR permit. And I just want to put something on the Elmo so everybody can see this. I don't know when it's going to follow up, but I just, as we talk about today's hearing and the process, I thought it would be helpful to have this. So the standard of review is set forth in Section 27-61, subsection J3. And you will see City Council, in reviewing an AR permit, applies a de novo standard of review, and City Council is not limited to the record upon which the AR permit was based. Instead, City Council may receive new evidence and is required to follow all applicable ordinances in arriving at its decision. For this item, the applicable code section includes Section 27-211, as I mentioned, the Greater Seminole Heights Vision, and then the alternative design exception criteria in Section 27-60. Mr. Shelby, I don't know if now is the time to address the housekeeping measures that were raised by Mr. Leinhardt. There was an email that he sent, I believe, on the 26th of January, and I don't know if you would like him to come up and raise those requests?
If you wish to take the time now for him to do that, if that's his desire, now would be the time if he wishes to do so.
I think that would be the better approach.
Thank you.
Do you have a copy of that, or do you want me to?
Please state your name, sir.
Marcus Leinhardt, 409 West Paris Street. Okay. I sent an email to request a handful of things in order to ensure that I have the appropriate time and access to the people that are integral to the decision that you're going to make today. So number one, I asked that Ms. Wells here add 127-211.21A to the record as a code that we would be reviewing today. That is something that has been asked. The city asked of the builder to provide a build-to line per that. It's not part of the ones that she was saying is applicable to this, but it's extremely applicable to that, so I would like that added to the record.
I'm sorry if I can interrupt. Do you intend to do that during your presentation?
My understanding of the process is that I requested this, and then every one of you are gonna say, are you gonna approve the request or not?
Well, the question is...
Will that be added to the record as one of the codes that we'll be reviewing today?
Well, the question is, do you intend to enter that?
Yes, I
or
do.
to address that?
Yes, I do.
Well, at that time, you can... Do you want to address
If I may,
that?
just to clarify, the reason I didn't call it out directly on the review procedures is a copy of 27-211 was included with the agenda. It's part of the record, so it's already in there.
Okay, just making sure
Thank
we're
you.
covered. All right. Two, I understand that I have the ability to cross-examine for 5 minutes. Due to the number of challenges that we have with this property from very beginning to now, I would request that I have the ability to interview each person that I've identified here for 5 to 10 minutes. I think that this is a reasonable amount of time to actually walk through the process and understand, are we making the right decision or not with this design exception. I've called out to talk to Kate Wells, Eric Cotton, Heather Bonds, Cassia Newsom, JC, Cammie Corbett, and Jacob Egan. They are all relevant to the process, and I would expect equal access in front of you to talk to them and interview them in my cross-examination.
And you're asking for 5 minutes per person?
5 to 10 minutes per person,
Per
depending
person.
upon.
Okay, and Ms. Wells, would you want to address that, please?
Thank you. Typically, attorneys are not subject to cross-examination. We're not fact witnesses, so I would object to the request to cross-examine myself as well as Ms. Corbett. And then the review hearing, the only witness the city is presenting is Eric Cotton. It is his decision that is being appealed and is subject to today's hearing. So anyone else that was identified that may have been involved in prior permitting decisions for these parcels, they're not part of the city's presentation, so they wouldn't be subject to cross-examination.
I'd like to rebut that. The fact that the city chose not to include them in the presentation doesn't mean that I shouldn't have the ability to speak to them and they shouldn't answer the questions that I have for them. It's extremely applicable to the case in front of us.
Councilman Vieira.
Yes, sir. Yeah, no, I wanted to just echo what Ms. Wells said, that usually in an underlying case, it's very problematic to have attorneys who were involved in the case as witnesses to be deposed, or to be subject to cross-examination, et cetera, just given issues of attorney-client privilege, work product, et cetera. I mean, my view is with the, if I may, you know, my view would be, I mean, if this gentleman wishes to bring witnesses who are not lawyers in the subject case, that's his right. And if he wants to cross-examine witnesses that the city of Tampa takes, he has the full right to do that. Am I not correct? I mean, there's no time limit. I mean, so long as it's not abused, I would think.
Well, the question is, the people who are named are not witnesses of the city. And of course, in a review hearing, in these quasi-judicial proceedings, there is no subpoena power for him to be able, let's say if this was litigation, to be able to subpoena a witness to come in to testify for his position. That witness not being called by the city, that witness not being present, Ms. Wells's position is that there is no opportunity for him to cross-examine.
Sure.
And
what I mean is if he wants to bring in his own witness.
Oh, if he wants to bring in.
That's all I'm saying.
Oh, absolutely. He could bring
And
his own witnesses.
And if there is a witness put by the other side, he wants to reasonably cross-examine, I think that's fine. But attorneys,
So, just a point of clarification, the design exception for Onyx and East was written by Kami Corbett. She is an integral part to this process. She happens to be their lawyer. That's not my fault that they decided to pay $500 an hour to a lawyer. I don't have legal representation here today, but I should be able to do that because she wrote the design exception that he then ruled on. I don't understand how the fact that she's a lawyer would preclude me from having that conversation.
Councilmember Hurtak, you were on first?
Oh, no, again, I mean, if Ms. Corbett wrote that particular provision, it was, my particular view would be it was interpreted by Mr. Cotton, and he would have the requisite knowledge on it for cross-examination. Again, just very problematic to depose an attorney who's on a case, about the case where they're representing a client. It's just something that is not done for a reason. And again, sir, I totally understand your preference in this regard and your passion, et cetera, but just something, at least in my experience, it's not done. And again, I don't think I'm making the decision, just speaking on behalf of Luis Eduardo Vieira.
No, but the thing is, ultimately, if he's making this request, council is going to have to make a determination. Does Ms. Corbett, I cannot see her, but I know she's, oh, there you are, right there, you moved. Sir, yes, please.
Shane Costello of Hillward Henderson. I represent the property owner and applicant here. My partner is Ms. Corbett. I see no reason to alter from the city's standard procedure here. The petitioner has 15 minutes to present his case. He can call what witnesses he sees fit to present his case in his 15 minutes. He can cross-examine. He can use his time to cross-examine any witnesses that are presented by the city and the applicant. And that's a fair process, and there's sufficient time for everyone. As was mentioned, he has no ability to subpoena witnesses that are not here. He needs to bring his witnesses in his case and present them in his case.
Thank you very much. Councilmember Hurtak, you have your mic on, and then Councilmember Carlson, I think you have your hand up.
Yeah, so am I hearing you say that before Mr. Cotton got involved, there were other city staff members involved?
Yeah,
That's where you want?
People who reviewed the initial permit process. JC was also part of the process. The basis for me asking for this is because
Well, if you can, I'm sorry.
Yeah,
I don't know whether that's appropriate at this point before you make your case.
I'm just curious
As to,
what he was trying to answer. He was answering the question I had.
Okay, we'll see how it goes.
all the people that I've named have very specific parts in this process that got us here today. I believe that I should be able to ask them the questions. JC was part of a conversation and meeting, and I'd like to hear the results of it because I think it is impactful to the decision and can influence the decision of the city. I'd like that brought before you, and in order to have that, I documented the evidence. It's in the hard copies I'll hand you in a little bit here. You can see it. I would prefer he speak on his behalf. Kate Wells has also been part of many meetings with Hillward Henderson and Onyx and East through this entire process here. I'd like to understand her part in the process and the conversations they had, because I, as a private citizen, was provided a memo that I should have contact with nobody. I documented where she's told people that they should not talk to me. However, they've continued to engage in conversations with the law firm. I have that through meeting requests. I have that through other public documentation from public records requests. Therefore, it is relevant to the process, and they should be able to answer what was the content of those meetings, because I could not speak to anybody but a design exception. The entire process. Has the city, their law firm, Hill Ward, Henderson, and Onyx and East, have they had conversations about this design exception? I think that's perfectly fine to ask, and we should be able to get that answer.
Councilmember Carlson, you got your hand up? Or no? Yeah. Oh, go ahead.
Marty, just a question of law. In the case, in the lawsuit against former city council member John Dingfelder, the city attorney at the time said that there's no attorney-client privilege, and so I wonder, could you explain the difference between a lawsuit and this in terms of the right someone may have to interview? In that case, the city attorney and all the attorneys involved in the city were openly deposed for hours and delivered what Dingfelder thought was confidential information. In this case, is there some special protection of the city attorney's office which ensures confidentiality, or is it all open to public scrutiny?
This is not a judicial proceeding, Councilman. I'm sorry, down my back to you. This is not a judicial proceeding. This is a quasi-judicial hearing. It's a review hearing. I don't want to be able to compare this to that particular proceeding. It is normally, with regard to being a witness, I believe, as Ms. Wells stated, she is not a fact witness relative to what is relevant in this case. At least that is her position. Certainly, Mr. Leinhardt can make his presentation and present whatever evidence that he feels is relevant. Certainly, he's pro se. He's not an attorney, but still, there's an opportunity for cross-examination. There's an opportunity for rebuttal. So I would suggest that with regard to, there are witnesses, I believe, who are present, and then there are witnesses he had on that list who are not present. But with regard to cross-examining an attorney who is actually representing a client is a rather unusual request. I don't believe they would have attorney-client privilege as well, at least the attorney who is representing the property owner. And again, with regard to litigation strategy and the like, I would suspect that the attorney, and I can't speak for the city attorney, but it would be inappropriate for the city attorney to allow her assistants to be able to discuss a case where the city could very well be a party to litigation in this matter. So my suggestion is, counsel, let me just read to you as we continue what your rules state with request for additional time. And that is in your rules of procedure, Rule 6B, it says, request for additional time may only be granted if the participant making the request establishes to the satisfaction of counsel that additional time is necessary to afford procedural due process. Council members shall, by majority vote, grant or deny the request and determine the additional time necessary, if any. In the event a participant in a quasi-judicial hearing is given additional time to make a presentation, then the petitioner may request additional time for purposes of rebuttal as necessary to afford procedural due process. So if we could just let Mr. Leinhardt finish his presentation, is that your request? Is that the gist of your request in its entirety?
Correct. No, I have one more, two more things to bring, just to ensure that you fully understand what I've asked for and the challenges in the process here, so I wanted to make sure that was brought to light. In Eric Cotton's decision, because I can't speak to anybody, I've requested through Kate Wells. Eric has told me that he can't talk to me about it. I said it is applied by policy, not code. I've asked for the written policy several times. I have not received it. I asked for it in advance of this meeting so I could better understand the decision and represent my rights, my property rights, my interests of my family here on level ground with the person that made the decision. City has not provided me the policy, the written policy that was applied in the decision. I just want to make sure you know that has been asked for over a month and I've not gotten any answer. Ms. Wells says the information is in the decision. I can show you the email that was sent to me on that. So therefore, when we base something on something like code, you can point to the code. we should be able to point to the policy, and that has not been supplied to me yet. So I would like you to be fully aware of that I was not provided all the information about the decision today. And that was the choice of your legal staff, or the city's legal staff.
Councilman Miranda?
I can only say that, speaking for myself and more likely my other colleagues, I haven't spoken to anyone, you,
No,
Corbett, Mr. Cotton, any attorney, none of them. So this is not a court of law. This is a quasi-judicial hearing. And we're going to hear it that way. I'm not going to get evidence on an attorney and a client. That could be in a court of law. If you want to say that something was happening that you didn't like, you certainly have the right to appeal to anywhere you want. But we're not lawyers. I'm not, and I'm not a judge. I'm applying whatever was said in the hearing, de novo, all new to yourself. And if you want to convolute this thing,
I'm not
no,
convoluting.
I'm not saying you are, but
I just
what
asked
you're
for, I just
doing
asked
it,
for the, I just asked for the
you're
written
putting
policy.
everyone here in a situation where I don't want to extend this beside, this is a normal, not an abnormal thing that we do. This is what we do and how we do it. And you have the right to do whatever you like. I'm not saying you don't, but I want to hear it just as a quasi-judicial hearing.
Yeah.
If I
So,
can,
just to
Yes, sir,
clarify.
Mr. Shelby.
no, do you want, may he speak?
Go ahead, sir.
So just to clarify, I asked for the policy that was applied, that is part of the decision that the city rendered. I asked for what that policy was. I don't know how that's convoluting it. It is actually part of the document we're gonna talk about today. That was my objection. I asked for clarity and transparency in the process. I didn't get it. I thought you should be informed of that.
Mr. Chairman, if I can.
Yes, sir, Mr. Shelby.
Mr. Leinhardt's position and objection is noted for the record, and my suggestion is if he wishes to renew that objection down the road, and if he needs additional time, based on what transpires, he could make that request again before that period, consistent with what this rule is, and then council can make that decision. But I believe it would be appropriate for you to go forward with this hearing.
That's fine.
And then if there's an opportunity to address, or a need, as you see it, to address these issues down the road, then you can renew your objection.
Councilmember Hurtak, Councilmember Clinton.
I have a question for Ms. Wells. This is the second time today I've heard something where there's a difference between policy and code. It was also brought up in public comment today regarding a different matter. So what is the difference between policy and code?
I will allow Eric Cotton to address that in his presentation.
Okay, are both of those written?
I'm going to let Eric Cotton address that in his presentation. I'm not here as a fact witness. I'm here to just walk counsel.
But I'm not asking, I'm so sorry.
So, but Mr. Cotton will be addressing that in his presentation.
But I'm just asking in general, because again, we just had someone in public comment today ask the same thing about a different case. So I'm just asking as a general thing for the city, what is the difference between policy and code?
And that's a question that, after the testimony, you can raise questions of the witnesses. My suggestion, by the way, and I just want to make sure there's no objection, Mr. Costello, is that correct? Did I get the name right?
Nothing further on this.
Okay, but I just wanted to make sure that, for the parties involved, that it's agreed upon that if city council members have questions of fact witnesses, they can ask those questions as they have in the past, in the normally situations. Is that correct?
Absolutely, and the hearing procedures allow for that. What I would ask, though, is when Mr. Cotton makes his presentation, if he can complete his presentation in full before taking any questions. I think that might be a little easier, because oftentimes council will start asking questions and you're anticipating where the presentation is going. So with that, I'll turn it over to Mr. Cotton.
Councilman Clinton.
Well, I just want to clear one thing up, because it appears as though Mr. Leinhardt said that he didn't get information that would adequately prepare him to present today because he didn't get a copy of that policy. Is that something that he needed? What is the status of that? In other words, if he isn't able to prepare a case, shouldn't that be something we could provide for him if he requested that information?
It is my understanding, in talking to Carl Brody, an assistant city attorney in our office that handles public records requests, that all responsive records have been provided. What I would suggest is if a document has not been provided, perhaps that document does not exist.
Does not exist. Okay,
And I think Mr. Cotton will be addressing that in
Okay.
his presentation.
asked and answered. Thank you.
Thank you.
All right, so we go to item number 4, which is the procedural history of the case by staff. Correct, Mr. Cotton?
And if we can, Mr. Chairman,
Yes.
Forgive me, I just want to go to number 2 and just say, make the request that you receive and file any ex parte written documents that have been provided and made available to the public up until this point.
Motion from Councilmember Viera, do we have a second? Second from Councilmember Clendenin, all in favor? Aye, any opposed? Go ahead, sir.
Eric Cotton, Development Coordination, I have been sworn. Again, just to reiterate, this is DE 123-247. So design exception for the properties at 406 through 412 West Paris Street in Seminole Heights. Again, the summary of the request, the appellant is Marcus Leinhard. The property owner, again, this is again, as Ms. Wells had indicated, this is a third-party review. Property owner is Onyx and East. The original DE1 applicant was Onyx and East. Again, the address is the range of 406 to 412 West Paris Street. The zoning is SHRS, which is Seminole Heights Residential Single Family, and the design exception was to establish the build-to line for the 4 properties at 406, 408, 410, and 412 West Paris Street. So just a quick aerial of the photo of the site. South side of Paris, this is Lynn, this is Ola, and these are the 4 properties in question, starting at 406, 408, 410, 412, in the order they come. So the next slide is the design criteria that we review when we receive a request for a design exception. Council has seen these criteria before, and basically doesn't interfere with the rights of others, reasonable allowance of the use, achieves the intent of both Chapter 27 and the Tampa Comprehensive Plan, is a minimal request, and is consistent with the standards that are set forth in the submitted plans for the property. Specifically to the setback requests, these are the criteria, and it talks about such requests clearly demonstrate the exception is warranted, and it gives some examples, such as the 5 examples there, but that's not a limitation of what staff will look at or what the applicant can claim when they apply for a design exception.
Can you leave that there for just one more second?
Yes, sir.
Thank you.
You're welcome. So again, property zoned SHRS, Seminole Heights Residential Single Family, per 27-11.2.1. Standards for the zoning district: minimum lot size is 50 feet, minimum lot width is 50 feet, minimum lot size is 5,000 square feet. Setbacks for the interior and the rear are similar. As you can see, these are standard setbacks for like the RS50 zoning district. The front and a street side are based on a build-to line. So the build-to line is, as defined by code, is where the building wall has to be set. So that's the front wall of the structure, not including any porch and eaves. It is established at time of permitting. When somebody comes in and asks for a permit, they provide the build-to line is reviewed by the permitting office, and through that, the permitting process. Again, the front facade is structured, is supposed to be placed at that site. It can maybe varied through an alternative design process, which is the basis of the design exception that was applied for by Onyx and East. Specifically, design exceptions allow for special districts. SHRS the Seminole Heights is a special district by code, and allows for the design and dimension standards to be modified. So the next question, I guess, would be, how do we establish what the build-to line is? And so there's 2 ways. The build-to line is based on the average of the lots of the properties on either side. That's how it has been interpreted since Seminole Heights was adopted back in 2010. So in this example, you have a structure built at 21 feet. This is a vacant lot here. So you have, and this where the pen is, would be the property coming in for the permit. They're coming in to say, I want to build a single-family home here. How do you determine what that build-to line is? By policy, because the SHRS is most similar to the RS50 and standards and setbacks, we've historically applied for the front yard on a vacant lot when you're trying to determine what the average is for a lot coming in for permits. It's 20 feet for the vacant lot. The existing house is at 21 feet. The build-to line would be 20 and a half feet. That's what the new structure would, that's what the new structure would be required to build at. For properties where there is truly homes built on either side, again, this one is coming in for a permit to build. This house is at 27 feet, this is at 25 feet. The average of these two lots would be 26. That's what the BTL would be established at. Seminole Heights is a residential building form that was adopted by council when Seminole Heights was adopted. And depending upon where you are in Seminole Heights is the style of home you're supposed to build to. As you can see, the majority of Seminole Heights is either pink or yellow. Pink is your traditional craftsman style house, and the yellow is eclectic. So specifically for these properties, again, here's the site right there on Paris. It's yellow, so it's eclectic. They are able to build a multitude of different styles of homes as long as they comply with what's allowed in the code. Eclectic includes craftsman, prairie, national folk. It does not include like Spanish Mediterranean or Mediterranean revival or a ranch style house. But again, this is the property in question, platted in 1925. You can see there was an alley that has since been vacated that ran in the T shape. It was vacated both north and south and east-west. But just to orient you, this would be 406, 408, 410, 412. This lot here is developed and faces Lynn. So I got ahead of myself. Here's the eclectic style of homes. Again, this is what was shown on that colored map. And in there, these are the style of homes that you can build in eclectic. You can do Spanish eclectic, but you can, the majority of people tend to build, in Seminole Heights, you see a lot of craftsmen or national folk, because that's what I think the majority of the style of homes are at. That's what people tend to build in Seminole Heights. So going into the nuts and bolts of the request. So question came through. The application was for a design exception. It was for all 4 lots, 06, 08, 10, and 12. Sorry to keep repeating myself on the numbers. So on this one, and I don't know how clear this is on the screen, but this is a prairie style home. The applicant proposed a BTL of 20 feet. There's a house next door that's existing at 404. It's roughly back 35 feet. So this house we determined, so it was when we were going through the process, or I was going through the process for the design exception and determining what the BTL would be based on their request. I looked at 406, 406 and 408 was built upon, 410 was built upon, 408 and 412. So I went down the row of the homes when I was looking at these. This was determined, 406 was determined to be 27.5 feet. 408 was a craftsman style home. The required BTL based on the calculation would be 23.75. The applicant requested a 15-foot build-to line. That was approved based on the fact that craftsman requires a detached garage as part of the design. They have a detached garage in order to meet the setbacks for the garage, as well as meeting the setbacks, and eligible to make the garage usable. They would, there has to be a minimal amount of space in between the two. This is a tighter site, it's only about 96 feet deep. So they came through and they asked for a little bit of relief from the front. So instead of being at a vacant lot of 20 feet, which was what the SHRS would sort of default to, we allowed it to be moved forward 5 feet in order to provide the required building separation and access to the garage in the back. The same thing was on 40410 West Paris. Same request, it was for a craftsman style home. This is the detached garage. Property was moved forward in order to provide easier access and better maneuverability for the garage that's on the property. 412 West Paris, the required BTL is 15 feet. They proposed 30. The determination by staff or by me was 27.5 feet. Again, that's a prairie design. So in summary, 406 West Paris is at 27.5. 408 and 410 are set at 15 feet for the determined BTL, and 412 West Paris is set at 27.5. And this last line is the minimum amount of garage, the minimum porches that you would be allowed to have on the site. Those are allowed to encroach past the build-to line. And that concludes my presentation.
So I have a question. Leave that,
Yes,
that
sir.
sheet up. So 406 West Paris Street, it says 27.5 feet. 412 is 27.5 feet, but the two houses in the center are at 15 feet.
Correct.
Are they trying to squeeze two houses in a spot that could be for one house because the others are 27.5? Is that what I'm understanding or no?
No, sir. So Seminole Heights, some of the lots are smaller than others, and it was the style of home that was driving part of the discussion for, part of the need. And again, this is a craftsman-style home. It has a detached garage. So in order to provide building separation and maneuverability to get in and out of that garage, the request was to move the house forward 5 feet to allow for that adjustment.
Okay, thank you. Councilmember Hurta.
Yes, ma'am.
Are garages required for craftsman homes?
I believe they are. I believe they have to be detached. I would honestly have to look at the code.
So
But
there aren't any houses in Seminole Heights that are craftsman style that don't have garages?
I would imagine, given the age of Seminole Heights, yes, there are craftsman style homes without garages.
Like newer ones?
I can't answer that question. I don't know.
Not to give testimony, but I can think of many, including my own. So, I
Fair
know,
enough.
but, so I want to ask.
Yes, ma'am.
So you're saying that when you looked at this, there are 5 buildable parcels on that front Paris Street?
There's 4.
No, including the one that's already there. You said at 404?
But that's not part of this. That was an
No,
existing house.
but
Okay, yes,
in
ma'am.
order to determine a build-to line,
Yes,
you
ma'am.
start with 35 feet, which was the current house on the street, is what you said.
Yes, ma'am.
So, and the goal to the build-to line is to make everything pretty flush and uniform.
The goal of the build-to line is to provide a
Continuity.
consistent street face.
Well, so you have 35 feet, 27 and a half, 15, 15, and 27 and a half.
Yes, ma'am.
Do you really consider that to be consistent?
Well,
No, we can't have any audience. Yeah, thank
I
you.
mean, there's a difference here, but for 20 feet from one house to another.
Well, when we examine build-to lines, when they come to us for an alternative design, we look at other issues on the property besides just the street face. So for instance, we were looking at the design of the home and the detached structures that they were proposing as part of their development.
But, so to me, the biggest question is the question you can't answer, is are craftsmen required to have garages? Because it seems to me that the reason this house was moved forward is because they wanted a garage,
That would be correct, yes.
but not that garages are required.
So the build-to line, the build-to form, or the residential building form for craftsmen, shown on the Elmo, talks about garages. As though it says it's not typically attached to the building. And if attached, so it doesn't say it's required, but that is something that would be, if you have a garage, it's normally detached.
Correct, but that would mean that you would have to have the size of a lot appropriate to fit a garage.
Correct, but I can't comment on the design that the applicant was proposing. That's what they proposed, that's what we reviewed.
But my question remains. Someone came and asked for something that was larger that can fit on the lot, and you gave them the exception to do that.
Based on the evidence that they submitted to us, yes. It's not atypical, I mean, council has seen numerous PDs that come through where people ask for reduced setbacks, and they would be granted. The Variance Review Board routinely reviews variances for reduced setbacks. It's the same kind of concept. This is an administrative decision based on what the applicant proposed. Staff does not go back to the applicant and say, you need to build something different. This is what they chose to build. This is what we react to.
And then I had one more question, because in the emails and things that were in the record, there was an email from a Sterling McLemore who said he owns a property directly behind the project, and that they built a garage right on top of the survey stakes. What was the,
The required setback for a detached structure in Seminole Heights is 3 feet.
was that followed in this?
I don't know, I don't do inspections for the city. My function as a zoning administrator, I can't confirm if it was or not. I don't have the answer for you.
Okay, is there anyone here today that does have the answer to that?
No, ma'am.
Is there a way that we can have someone that can answer that today?
I think, Kate Wells, for the record, I think it's important that the focus of this hearing be on the design exception and the relief that was granted by way of the Bill 2 line where those were set. As soon as we start talking about permitting issues and other issues, my concern is that we're going beyond the scope of today's hearing.
But Ms. Wells, it's very clear that the reason this was asked for was for a garage. And so my question is, were they able to fit the garage in the proper
I can't testify to
No.
that.
space?
On the submitted plan, it's compliant with the code.
Okay, thank you.
That's all I can say to that.
Thank you very much. Councilmember Clendenin, your hand was up.
Yes, so in our previous discussion prior to the testimony, there was discussion about policy, and you mentioned policy several times. Where is that derived from?
Well, again, when the code is silent, when Chapter 27, when the SHRS districts were adopted by council, there was no, the Bill 2 line was determined to be, you have 3 lots typically, and you're coming in, there's going to be a house on either side. Well, there are lots such as these where there's no structure on either side of the house. So by policy, it was determined to be, SHRS is most similar to the RS50 zoning district in minimum size of 5,000 square feet and 50 feet of frontage, and rear setback 20, sides are 7. It was determined that by policy, when you don't have anything on either side, you would default to a 20-foot setback, given the fact that it's most similar in size to RS50.
I'm still not clear about this mysterious policy. Did God hand that down? I mean, where
It
did
was
this policy come from?
determined under the previous zoning administrator. When Ms. Coyle was here, we had discussed that with her, and that was the determination that was agreed upon. It was never, no, it has not, I looked, I could not find a written policy for that, but it is policy. You can't have policies that are unwritten. And that was the determination made so that you would have, because if not, then there would be no standard for vacant lots.
It would seem as, and land development is so complicated and there's so much money involved that, and we have these issues, I mean, granted, I've only been here since May, but time and time again, we have issues come before us with very similar circumstances that we have here. Maybe because this is Seminole Heights, it's a little bit different. But because you also used the word historically applied, but that doesn't have a point of reference. In other words, my question is, how would a homeowner, an investor, or anybody be able to develop or have predictability in their neighborhood with a policy that they can't point to, or if staff is saying historically applied, because that information doesn't live in the public realm. So how would you have, if you're a neighbor, how would you have expectations of what that policy is?
Well, even for the neighbor or for a developer, I mean, it's just a phone call. Phone call or an email, you could pick up the phone and call the city and say, hey, I see a house being built, what's the required setback?
But say I live in a neighborhood and all of a sudden there's something being developed next to me, and we have a certain expectation of what that neighborhood looks like. Because policy could just be changed by, like you say, it was a previous administrator, another administrator comes in and could change policy, right?
That would be correct. We try not to show consistency throughout the years.
Yeah.
I mean, our code is a living code. It's been, the code that we have now was adopted originally in '84 at Chapter 43A. As you know, we're going through code reform in the next couple of years.
Right.
Seminole Heights was adopted in 2010. So this issue has been around since 2010.
I'll pontificate upon this later when it's appropriate, so I'll just stop there.
Okay.
Thank you.
Yes, sir, Councilmember Carlson.
I don't know if this is a question for the attorneys, but considering that whole line of thinking, isn't land use policy supposed to be approved by city council?
The code is approved by council, but there's interpretations in chapter 27. That power is granted by council to the zoning administrator or designees on many different subjects in the code.
What's the, could you also tell us what's the threshold what threshold would have had to been hit for this exception to come before council?
Well, they would have had two options. They could have applied for a plan development and come to council as a rezoning. And that would, or they applied for the design exception and
But what's
third party.
Sorry, because I kind of mixed the two questions. But just if it was, I don't know the answer to the question, that's why I'm asking. If it was 2 feet more off, would that have triggered it coming to council? Like, what's the boundary under which it would have come to council?
Staff uses their professional judgment and the basis of the code and the development in the neighborhood to make those kinds of decisions.
And also, when staff is making a decision like that, is there any notice at all to adjacent neighborhood?
Yeah, no public notice goes out for design exception ones that reduce setbacks.
And did you get and consider any neighbor feedback?
We received 2 letters, one from Mr. McLemore and one from Mr. Leinhardt.
And was there any, how did that weigh into your decision?
We review what's submitted to us, but we don't make decisions based on the number of letters we receive and the number of letters we don't receive. Again, staff uses its judgment. I've been doing this for almost 30 years, 24 with the city. So there's basis for my decisions based on previous decisions made by the city. And the city means, previous employees, previous zoning administrators and such that have worked here.
And how do you, so you said that you use other factors besides just the front measurement. How do you decide which ones to weigh and which ones are the most important of the criteria they use? So they wanted to put a garage in, and have the safety space and everything. You had to change the setback. How do you weigh which of the criteria is the most important?
Each case stands on its own. We don't have, it's like, somebody could come in another part of Seminole Heights and request the same kind of request, and it may be determined to be inconsistent. I can't speculate because I don't have anything to compare this to at this point.
All right, thank you.
Thank you very much. Anybody else? Does that conclude your entire presentation under the procedural history?
Yes, sir.
All right, so at this point, we go to the presentation by the aggrieved persons / petitioner representative for 15 minutes. Yes, sir. You've been sworn in, so go ahead.
Can I just take a moment? I have a fair amount of documentation I wanted to give to you so you can follow along. Because a lot of what I want to assert and talk about is all from public record.
Yeah, hold the clock. Don't start his time yet. Where's the documentation? Mr. Shelby will distribute it. Thank you.
So kind of explain how it goes, just so everybody has.
He'll take it.
Oh.
Yeah, he'll take it and distribute.
All right. This will walk along the presentation. This has documentation of each step of my presentation based on emails, surveys, everything else that weighed into it, so you can follow along and understand the statements I'm making are based on fact, public record. This is the presentation, and then this is also the documentation for all the questions that I'll ask to the people that I wanted to ask to. If I don't get to ask them, I want to do part of public record, so you understand. Lays out the majority of the questions that I'll ask today, too, for each one of the representatives.
And Mr. Leinhardt, do you have a copy as well for the clerk and for the attorneys?
Wait, go back to the microphone.
I'm sorry.
So I can hear you. I'm sorry. It has to be all on the record.
I gave a digital copy to the clerk this morning. She
Yes.
downloaded and has it on a thumb drive. I gave it to her. If you would like me to leave a paper copy, I can do that as well. There's enough for everybody.
And for the attorneys, do you have copies for them as well? or-
I think I have one for Ms. Wells, because that was called out, but,
Okay.
you
and
know,
it's-
I mean, if they need it, I mean, I guess that's, I didn't know that they were required to have it.
Pardon? You you have one more? Okay, good.
Yeah. I don't know.
That's one. That's two. That's three. And this is four. They all go down.
Thank
What, two more?
No, one
One
more.
more?
I have mine.
That's one, I would appreciate it if you have one.
It's good at that time.
Thank you.
No, I already canceled. Yes, go ahead.
Could I ask that, could you tell us, do you have any, I saw that you compiled all this, do you have, besides being a constituent that has an issue, do you have any professional background in any of this that you want to state for the record?
I personally do not. My wife is an urban planner for the Hillsborough County.
Okay, thank you.
All right, please state your name. Go ahead, sir.
And again, the time, Madam Clerk, is presently, it's 15 minutes, sir.
All right. Okay, Marcus Leinhardt, 409 West Paris Street. All right, in order to tee this up here, what I wanted to do is first start out with showing you the neighborhood. We talked about a fair amount of things here about how does this fit into the neighborhood is one of the governing things that Kate and Mr. Cotton walked us through today. So this is West Paris Street. You can see on the right-hand side, that's the side, the north side that I live on. You can see how far away the houses are from the street. On the left-hand side, you start to see where the Onyx and East development is. You start to see how close they are to that small street. So to give you context, where numbers don't do it, here's a picture of what it looks like. So that is the 15-foot setback, and the other side is a 30-foot setback. So that's from the middle of the road. That's what I see when I walk out of the house every single day. And then you can see alongside here how small that setback with the garage is. Just fits on the lot. All right. And then if we look at, walk through the neighborhood, this is around here. So this street is actually Ola, right? So Ola actually had no ability to establish the build-to line. I have documentation that proves how the city established that when there's nothing to be built. Notice how these houses fit alongside each other and the relationship to the street. Little variance between some of them, but perfectly normal, fits into the neighborhood. And then, second here. Here's Hannah. Notice his houses on both sides of the street. See how they interact with each other? Fairly limited variation, straight down the path. You notice the difference in these streets that I'm demonstrating here today and the street that was my street, right, with the Onyx and East development. And then one last one here. This is Lynn, another development where there was no way Domain Homes could have actually set a build-to line because there's nothing on the same side facing the street, right? So the houses on the left there, 4 of them, all have the exact same relationship with the street and to the other side of the street, aligned with the overall arching goals of the Seminole Heights Overlay District. So you can see the difference when set appropriately versus what we're talking about today. And then, just for a little bit of context here, here's our street. To the left there are the first 2 houses on the street that should be factored in the build-to line. You can see that they're way far back, but in the distance you see how the other houses loom over the rest of the neighborhood. Those are the first 2 houses, 402 and 404. See how far back they are? There's 404. Now, if you go to the front build-to line of 404 and you look straight across, that's what your view is. You see how this chokes off the street, splits it in 2. That's what she's gonna see when she walks out her front door, how the street's done. You don't see that anywhere else in the neighborhood or the broader area within Seminole Heights. That's my house, standing in the middle of the street. That's what I look across the street from when I pivot around. You notice the difference? This is the one next to it, and my neighbors, what their built-to line looks like from the middle of the street. So you can see the difference in there. So just wanted to orient you. Sometimes we look through pictures, right? A little easier to understand what this actually means to the people in the neighborhood.
Do you have a garage, a detached garage as part of your house or
No, actually, so we built, we actually own 2 properties on the street. 411 West Paris, we renovated that. We went through the design process with that. We actually had a person come on, check the width of our pillar to make sure it was okay. Fits inside the neighborhood. We then built a house 5 years ago, interacted with the city to understand what build-to line we should establish. We had a constraint. Similar size lot as Onyx and East is on, we couldn't fit a garage in there. We asked to move our build-to line forward. They told us exactly where that should be. We couldn't have a garage. We couldn't have a pool in the back because we had to deal with the constraints that the city put forth. All right. Okay. All right, so essentially, I guess I told my name a couple times here in Marcus, right? My family lives at 409 West Paris. We're directly across from 408 and 410 West Paris. I was the one who originally raised concerns about this development, right? And I raised concerns because they started building across the street, and it alarmed me how close they were to my property line and the center of the street. Oops. The development by Onyx and East at 406, 408, 410, and 412 West Paris directly and negatively impacts my family, my forever home, our rental property, and our property rights. Approving the design exception will make this impact permanent and sets a precedent for future development on the street, neighborhood, and the entire Seminole Heights. So, again, a view of the house. Now, what I did here is I showed you all the build-to lines of the houses in the neighborhood. You notice how side to side, street to street, they fit in there. The only dip on the top there is an old house that's set back fairly far. There's 2 new development houses, 2 new houses that were developed on that street. They'll be brought in line when they tear that one down and push it back, right? We can see how it works as a whole when the code's applied appropriately. Here's the variation. We talked about this a little bit earlier, but you can see the variation house to house. It's bigger than anywhere else on that street. 12.5 feet house to house variation. On the top side, 9 feet was the biggest variation. All right, so why are we here? How did it happen? We're here in a design exception on something that's been built. Let's hear that again. We're here talking about an exception, not before the process, not before figuring out how this all fits in there, but after it's been constructed. Now, as I go through the presentation, take note how the developer started when the stop work order was issued, the design exception was filed, and what the houses look like today. The builder decided to take risk on their part to continue to build and further their property. They didn't stop building to get the design exception that was required to get the certificate of occupancy. So Onyx and East is participating in the design exception process to legitimize the development because the houses that stand out, they should have never been built. Flat out, they should have never been built. Each share joint responsibility in the current situation and therefore have a vested interest in an outcome, right? So the city and Onyx and East both benefit from getting this design exception approved. So until now, they've controlled the narrative, the conversation, the process. Today I actually get an opportunity to speak. So how did it all start? After the stop work order was issued, Abby Feely, Eric Cotton required that they had to submit a design exception in order to get a certificate of occupancy. Kind of read that, they'd be evaluated if the houses weren't there, so on and so forth. So at the end of the day, is the exception warranted? So what Eric referred to earlier today clearly demonstrates an exception is warranted due to unique circumstances of the property. Grand trees, existing buildings. So what we've heard today is I wanted a garage and the plan had a garage on it. I don't know how extenuating of circumstance that is, but it doesn't seem like something that would warrant a design exception. And has the criteria been met? No, it interferes with rights of others. It doesn't provide a reasonable allowance. It's not the minimal allowance to provide an exception. It doesn't add up, right? So not only is it not warranted, the decision doesn't meet any of the criteria that it should. All right, background timeline. Now, this is relevant, and I digress because it's not specifically about the decision, but you have to understand where this came from. They went through a permitting process. During that process, the city asked Onyx and East, Bowler Engineering, for justification of a build-to line. During that process, you can look here. They reference a specific way to determine the build-to line. Add up all the houses and divide by the number of houses, right? The documentation I can show you guys in a second here. So if you do that, there's 2 houses on the street. That sets the build-to line for all the other ones. They specifically asked for it. Bowler Engineering never answered it. Instead, what they did is they started to represent their plans, putting 3 houses next to each other and indicating under separate permit. The only way you can get a permit is actually have your building application approved. So if you're reviewing the plan and your plan shows under separate permit on the 2 adjacent houses, one which doesn't even exist today, one that wasn't under a permit, how do you review that? The builder misrepresented information during that process. During that process, it was then approved, right? So if you look through the packet, it pulls that out and it shows you how it was represented. It was represented on each one of their building permits. So if you look at the timeline from the lot split, design exception, and when it was permitted, I called out there under separate permit. You can see all the documents that the builder, their engineering team, put on there and misrepresented information to the city, which then allowed for this process to take place, the permit to get approved. All right, so right here, blew up the plan. You can see under separate permit. That's on the 408 application, and it is also on the 4010, the 406, all of them. So they purposely misled the city in this process. If you look through the documentation here, you can see where Bowler never answered, even though they were specifically asked to answer to that question. They just ended up putting it on there to satisfy the requirement, even though you can't assert that a build-to line is present by things that don't exist. All right, and then 406 and 412, the 2 empty lots were never approved, their building plan has been locked. So to assert that that was under separate permit would be completely factually false. All right, so why did Bowler Engineering never answer the questions about the build-to line? So Keisha, one of the City of Tampa people I wanted to talk to, specifically called this out in the communication to Bowler Engineering. 127.211.21A. Front setbacks are determined by a build-to line. Identify a build-to line of adjacent structures, east and west, front wall principal, not front porch, or the proposed construction on the same side street. Add the measurements, divide by the number of homes on the street, and that is a build-to line. They asked them for that evidence so they could review the plans and set the build-to line. That was never supplied. Instead, they put under separate permit and represented on them as a 15-foot build-to line. All right, so what ends up happening, they start building, right? Got the permit approved, they start building. I call, email, city council, I say this doesn't look right. Eric Cotton starts to get involved in the process, the city starts to look into it, right? And this is where we want to look, 1 second here, is what happened post that. So Eric, through this process, ultimately ends up issuing a stop work order because of what I just described to you earlier. In the document here, Eric emails Abby, the situation I want to discuss with you is to formulate a response to one of my emails. Let me know whenever you have free time this upcoming week. The 2 are passed. Heather and Kenesha were under construction. They were approved at 15 feet. The approval was based on a site plan that showed the adjacent property at 15 feet, but they were labeled as proposed. I think he meant to say under permit. The other 2 are caught. So through right there, that's how it started to get approved. That's how they're jointly invested in getting this decision here. We go through there further, and we can go to the process where Eric starts to approve the stop work order. And instead of applying policy or code or policy, he starts to talk about the code and the verbiage. So in talking to a variety of people within his department, he said, okay, the stop work order would be based on this. Okay, so it would be the violation of the section 27-211.21. Not sure of the phrasing, but something like, they submitted building plans that reflected incorrect information for the termination of the build-to line as required by that. the required build to line is based on the existing setbacks of the properties on either side. When there's no existing building directly adjacent to the property, the next property in the block would be utilized. In this case, it would be 404 West Paris. So they walked through this process, right? So there was incorrect information submitted and errors on the city's part. Then the stop work order gets set. Here it is. In this one, he also calls out that code, not policy, that code. So multiple times in this process, we've talked about the code, not policy, undocumented policy. And at the time of the stop work order, this is the condition of the houses. Do you mind if I continue, or is this, I mean?
You have 30 seconds left. My question is, these photos are from June 13th. What is the condition of the houses now?
They're built.
Okay.
Yeah, actually, well, we saw it in the video. They're 100% constructed. They have a private provider. They've gone through all their inspections. They're just waiting for this design exception to be approved, so then they can go sell their houses.
Yes, sir.
I mean, if the aggrieved party needs more time, I'd be amenable to a motion for 5 more minutes. If now I'll ask this before making a motion to you, sir. Do you believe that that's enough to get you through?
It probably isn't, but I think like
Okay, but
in
you'll live
general,
with it.
you're probably going to get the gist of like
Yeah.
at the end of the day, we have a design exception in front of us, which has very little, if no merit, right?
And yet, and if I may, but because your time's about up, so I want to first make that motion.
We have a motion from Councilman Vieira to add 5 minutes. We have a second from Councilmember Hurtak. All in favor? Aye. And now the other side will have the same opportunity should they want for more time as well. So go ahead, sir. Please set the clock for 5 more minutes.
Right. So this one shows like the Bowler engineering document that was, the city asked them for the response, it references the exact same code. Bowler never responded, right? We walked through there, and then Jacob Egan responded to one of the emails, basically said, oh, we did set the build to a line. And it says, adjacent buildings just have a 15-foot setback dated on a C301 plan under separate permit, right? That's how they justified it. And then I think why, I'm going to tell you right now, well, my opinion is the reason why we're here and the reason why we're trying to excuse this design exception and approve it is because JC, the head building official, sent an email to the legal department in Tampa, and it said, we'd like to discuss in our next legal meeting, as this may have unintended consequences than I thought. We came across this conflict twice. So multiple times these errors have happened at 408 West Paris, which have violations that are zoning-based, Chapter 27 violations. However, very specific to enforce what we can actually do once the permit's issued. After issuance, the violations are cited. Not building code, the applicant can't file for disciplinary action against myself, inspector, or plan reviewers. However, the plans are issued and approved through the review process, you can't do anything. He set up meetings with the legal department. That's why I've asked for him to be here today, to understand what the decision was. Because if the city is afraid of getting sued, because Cammie Corbett, Onyx Indies, has sent them a letter indicating they want to sue them if they can't continue building the properties, and the city says we can't do anything once the permit's out there, then that's why we get a design exception that is going to be extremely impactful to my house, my financial investment, my neighborhood. And that's why we're here today. So like the backstory is that. And that's why we have what I believe was fairly shaky testimony about why it should be approved. There is no reason to be approved. You don't have to have a garage. Like you don't have to, like you just because somebody has a plan doesn't mean you have to adhere to the plan. Oh, you know that lot's too small. Why don't you make the house smaller? Why don't you not have the garage? There's various different ways. It doesn't have to be whatever's put in front of you, you just approve. The reason why we're trying to approve it is because they exist. We can say we're not, but we are. It is because they exist that we're here today. And that's why we're trying to approve it. And that's why there isn't an explanation for why the garage is required. All right, so that's basically, I guess, I'll wind up my testimony there. There is a treasure trove of information and documentation, all the processes, the communications between the law firm, the city, Eric Cotton, his team, and others, right? So I believe that you can understand why I'm in front of you today and why we should not approve this design appeal.
Thank you very much, sir. At this time, we'll move to the presentation by the property owner or representative. Yes, sir.
I just wanted to, this isn't just anything substantive, just commend you on putting this together. This took a lot of time and just, again, just duly noted. Thank you.
Thank you.
All right, yes, ma'am, please state your name, or yes, sir, sorry.
Shane Costello, Hill Ward Henderson, here on behalf of the applicant and property owner. We also have some things we'd like to pass out, and I have a PowerPoint. Is it on the? Where did they put it on?
We have enough.
Yeah, I think so.
Okay, we have
it's
the
already up.
presentation here, they'll bring it up on the big screen. Go ahead.
We're ready
state
to
your
begin.
name.
Shane Costello, Hill Ward Henderson, on behalf of the property owner and applicant. Let me just begin by saying I appreciate and respect the sentiments of the petitioner. We have a disagreement. We have a disagreement on some of the facts, and principally, we have a disagreement on the application of the Land Development Code and Florida law. Here today, we are here on a alternative design exception. We are requesting council to affirm the decision made by city staff. The city staff determined the application meets the applicable criteria for the design exception with respect to the build two lines, the BTLs. As was mentioned, this is a quasi-judicial hearing. The city staff's determination of compliance is competent substantial evidence in support of meeting the criteria of the design exception. On the other hand, the argument of the petitioner for the increased build two lines, that's advocacy. It is not, he's not a planner. His opinions are not evidence. And we also have a disagreement on the interpretation of the code, which I will get into in a moment. In fact, based on the application of the code language, the only viable argument under Florida law is that the build two lines actually need to be less than what they've been established at per the design exception. But today we are here to support the decision of city staff. At all times here, the property owner has worked with the city staff to work through these issues and work cooperatively with them on this matter. These are the four lots at issue: 406, 408, 410, and 412 West Paris. They are all separately platted lots, and they're all vacant lots. I want to briefly cover some of the relevant factual history here. The city approved the building permit applications for 408 and 410. 408, building permit approved November 1st, 2022. 410, approval March 7th, 2023. The review process was an ordinary review process. It took several months, and the permits were issued and approved, and my client commenced with building pursuant to the city permits. We've also submitted building permits in April of 2023 for 406 and 412, and those permits have not been issued. It is now almost a year later. Stop work order that petitioner mentioned in his presentation. It was issued on June 13th, 2023. My client, by that time, had made significant progress in expenditures and reliance on those building permits that had been issued. At 408, the foundation, frame, roof, windows, doors, and mechanical, electrical, and plumbing were also in progress. At 410, The foundation, frame, roof, and windows had been framed in, and at that point, 68% of the construction cost had been expended. You have on your screen 408 is on the left and 410 is on the right. These were taken by the city building official on June 13th when the stop work order was issued. Shows where we were at the time the stop work order was issued in June 2023. The stop work order was based on the Build 2 line issue that we were here about today. The Build 2 line issue is a zoning issue. It is not a building issue. That stop work order was deemed unenforceable by the city because it's a zoning issue and not a building issue. The city cannot enforce a stop work order on a zoning issue. That being said, the property owner did stop work for a period of 2 months while we worked through this issue with the city. 2 months later, we commenced construction pursuant to the approved building permits. So again, despite that stop work order being legally unenforceable, my client stopped for 2 months to work with the city on this issue. The construction of 408 and 410 has been completed since December 2023, and we do not yet have certificates of occupancy while we await the decision here. This slide shows the completed homes at 408 and 410. The vacant lots on either side are still waiting on the building permits. Now let's look at what the code says and what the law says with respect to this issue. This is the code provision in the Seminole Heights Special District, and at subsection 5, it provides that the BTL has to be determined by average of BTL of adjacent structures on either side of the lot with the same street front orientation. That's it. That's the only language in your code that applies to determine the BTL for these lots. Again, I have that language quoted on your screen. Notably, and Mr. Cotton said this exactly, the code is silent on what happens when there's no adjacent structures on either side of the lot with the same street front orientation. It's silent. Now, Florida law for over 50 years has held, and it recently as 2020 by the 2nd District Court of Appeal, that zoning regulations are in derogation of private rights of ownership. And therefore, if there's any ambiguity or question, they must be strictly construed in favor of the property owner and the unrestricted use of property. What does that mean? This gets into the code versus policy that you heard from Mr. Leinert, and the irony of it is that the way Florida law works, if the code doesn't regulate it, it can't be regulated. The city cannot enforce an unclear or non-existent regulation to restrict or limit the free use of property. This BTL, a BTL or a setback, same thing, it's a restriction or limitation on the free use of property. So there is no legally enforceable BTL restriction under the city's code. Nothing in the code that specifies where the BTL for those lots needs to be, because there are no adjacent structures. So we're not here today advocating for a lesser BTL, but this is important for the council to consider in the entire context of this decision. The property owners under Florida law have a right to take the position that the BTL needs to be lesser, but we are working with the city and supporting their design exception determination. The petitioner in his petition has some discussion on his interpretation of the code. And what he advocates for is that the city should use the one structure with the 35-foot Build 2 line setback and apply that down the rest of the block for 35 feet across. Well, that is plainly contrary to the language of the code. It says average. How do you get an average taking one lot. Can't do it. It also says structures on either side of the lot. Structures. It's plural. So the petitioner's position ignores the plain language of your code. There is no reasonable interpretation where you can conclude that you can take one structure on one lot and apply it for the rest of the block under the code. In the petition that you've received, the paper petition that you've received, the petitioner also argues that adjacent should mean nearby and not just the lots on either side. Well, first of all, you have to read the code as a whole. And it says adjacent structures on either side of the lot. So that modifies the term adjacent because it's talking about the structures on either side of the lot. It means next to. Also, if adjacent just means nearby, where does it stop? 1 block, 2 blocks? Again, then you don't have a clear restriction. You don't have, it's ambiguous. Where do you stop it? The zoning code, we've been through the zoning code. It repeatedly uses the word adjacent. Adjacent street, adjacent sidewalk, adjacent lot, adjacent structure. It always means next to. Finally, your code, right at the very beginning of the code, says that the city official is the final authority on the interpretation and meaning of the word in question. And here the city applies adjacent to mean the lots that are next to the subject lot. So there is nothing in the code that specifies what to be done here where you have vacant lots. The petitioner has also advocated in his petition that there's a concern about the precedential effect of this design exception. It's akin to a slippery slope argument. History and experience teaches us to be wary of slippery slope arguments. They're often not based on fact and law, and they prey on irrational fears, and that is the case here. This circumstance is a unique set of circumstances. You heard from Mr. Cotton all the specific facts that went into this particular determination, so it's unlikely to happen again. Also, there's a simple solution here. Amend the code. Your code doesn't say what's supposed to happen when there's a vacant lot on the other side. So you can amend it to clarify it, and then this decision doesn't have any precedential effect whatsoever. The alternative, if this design exception is not approved, is potentially establishing case law precedent that there is no enforceable BTL here whatsoever, and all 4 homes can be 15 feet or less from the street. Design exceptions. Design exceptions in the Seminole Heights Special District are common. Within a 1-mile radius, and this is all within the documents we've submitted, within a 1-mile radius of these subject properties, for structures built since 2017, so only the last 6 or 7 years, 69 structures have an approved design exception, and 59 of those relate to setbacks or a build-to line. So the city approval of design exceptions is not an uncommon situation. In fact, the petitioner's own home received a design exception for a side yard setback in 2018, reducing the side yard setback. Urban Design actually found it inconsistent, but it was approved. Here, the staff reviewed and determined that this design exception met the criteria in the code. These 4 homes are in accordance with the design forms of the Seminole Heights Special District, Prairie and Craftsman homes. And the average BTL for the block is just about 24 feet when you take the 2 interior lots that have already been built at 15 feet and then the 2 exterior at 27.5. There's justification for this design exception. The build-to lines are reasonable given this unique set of circumstances and the lack of adjacent structures and a code that applies to them. It's also consistent with the pattern of historic development and the surrounding block average of the build-to lines, which I'm going to get to in a moment. The city staff had to balance design criteria, lot sizes, home styles, garage placement, and access when considering these. And the city staff also found that it maintained the character and compatibility with the surrounding neighborhood. We've looked at actually this is part of the city's determination, it looked at the surrounding blocks build-to lines. And as you can see, the subject block is consistent with the 500 block north and south. One thing that I want to point out to here is that if adjacent means nearby, as the petitioner argues, then it makes sense to look at these other blocks. And so his own position is conflicting. These other blocks demonstrate consistency and compatibility with the neighborhood. This is a rendering of the new construction. The two in the middle have already been built at 408, 410. The construction meets the design style required in Seminole Heights, and it's compatible and maintains the character of the area. This is an overview. You can note the style again here in the roof lines, in line with the historic area of Seminole Heights. Here we have the design exception that the owner requested, then what the city approved, and then what the petitioner advocates for. Now, the legal basis, there's a legal basis for the owner to take the position.
We can add 5 more minutes to the clock.
Thank you. I can proceed?
Yes, go
Thank
ahead.
you. As I indicated, there's a legal basis for the owner to take the position that there can be no BTL here and that there is no need for a design exception. But we submitted to the city and complied, and we asked for the build-to lines that are shown in front of you. And the city, what the city approved is in the middle, and what the petitioner argues is at the end. And what you can see is that what the city has approved here is a middle ground. It is already a compromise between the two positions of the parties. Finally, I want to talk about Florida Statute 553.792B. This was enacted by the legislature last year. This statute provides that once a building permit is issued and there's been construction, the city cannot, municipality or the county, cannot require removal of or changes to the structure based upon a zoning code reason. So these two lots at 408 and 410 that have been constructed pursuant to the city's issued building permits, the city cannot now take action under this Florida statute, cannot now take action to require those structures to be changed or removed. So in conclusion, there's no factual or legal support for petitioner's argument for a 35-foot BTL here. There's no reasonable interpretation of the code that supports it. The design exception application and approval by staff meets the criteria in the code, so we request that this council affirm staff's decision. Thank you.
Thank you very much. Councilmember Clendenin, you had your mic on?
I did. So that was, it was an interesting presentation. I mean, all the way up until your last assertion about Florida Florida statutes. You kind of like had me confused because a lot of the things you present, I don't necessarily think were consistent with what you were trying to apply. But I do have to take note of your acclamation or your declaration of what adjacent is. Adjacent, it's my understanding adjacent isn't touching, that adjacent, and in fact I believe this is coming from my background, I'm used to that word. Adjacent is not necessarily next to, but it is near. And I think it actually, there's something that says that it doesn't have to touch. My other question is, what was on this property before it was vacant? And who, was it this owner that's developed this? Are they the ones that split the lots and demolished? Was there a structure there pre-existing?
There were 3 lots that were owned by one, but they were platted as 3 separate lots.
They were
as
all
Mr.
empty
Cotton-
lots for like,
As Mr. Cotton showed you.
was there a house there, Mr. Cotton? And what was and how far back was that house?
Let me just, Eric Cotton Development Coordination, I'll just show council the plat. Excuse me.
I mean, because a big part of the argument is that you can't measure on a vacant lot, but was there something that was measurable, historically measurable on this property?
Well, this is the 1925 plat. Eric Cotton Development Coordination. This is the 1925
Yeah,
plat.
I understand that.
So in Seminole Heights,
But was there a house here?
there was a house on lot 23. This is for us. No, excuse me, I take that back. There was a house on lot 26. There was a house there. The other 3 lots were vacant. So the development was a single home with 3 vacant lots made up the zoning lot.
Do you have anything to display that, where the house was? What the setback of that house was?
I do have the aerial, and you can see the aerial, the house actually straddles the last 2 lots. And if you can, I can blow that up for council.
Okay, so it's set back quite a ways.
Yes, sir.
So even further than the other houses that are on the existing. So if we were to use development pattern, historical development pattern on that block, we're not just talking about a vacant plot. That there was a house there. The development pattern on that block was set back significantly from Paris Street. Okay. Yeah, and again, I mean, I would love, I mean, I'm not going to enter evidence, but again, my understanding of adjacent is not your understanding of adjacent.
Adjacent structures on either side of the lot.
But,
Okay.
but I don't think that necessarily is a, I don't think I can come to an agreement unless proven otherwise, that this is what is the definition, what is. I think adjacent is, I think adjacent can refer to some nearby. I think the assertion that adjacent isn't necessarily touching is an accurate or reasonable assertion, that adjacent can also mean nearby.
Well, that's not how your staff interprets that provision.
Well, I'm not staff.
No, but if I can, Martin Shelby, City
Yeah.
Council Attorney. Councilman, that might be a question for your staff, because
Okay.
as you heard, that
Is there something written in city policy of the meaning of adjacent? Is it written?
Eric Cotton Development Coordination, no, sir. It's not a defined term in chapter 27. So it's by code, we would look back at the definition of Merriam-Webster's ninth edition as amended through, over the years.
Thank you. I appreciate that. Thank you.
All right. Thank you very much, sir. Anybody else? No? All right. At this time, we will go to cross-examination by the petitioner / aggrieved person. Sir, if you'd like to go ahead, we have 5 minutes set for each side. Who do you wish to cross-examine first?
I think I can only, just for clarification.
Yeah.
All right, for clarification, earlier in the process, I asked to talk to a handful of people for a specified period of time for each of them. Am I only allowed to, right now, talk to one person for 5 minutes? Was that the decision that was
You
made?
can talk to as many people within the 5 minutes.
Oh,
But the question is, he's going to renew his request to speak to the attorneys. That's the question.
I mean, Jacob Egan's in the room here. He could, I have a question for him. Is he available? Cammy's there. Kate's there. Eric's there. JC is not here. But I guess do I only really have 5 minutes to talk to all my people for questions? So that's why I just want to clarify.
I mean, of the people that have been requested to cross-examine, I mean, I just see Mr. Cotton as the one person. Because we discussed about the attorneys, Mr. Shelby, what is your advice or direction there about cross-examining the variety of attorneys?
Well, certainly, 5 minutes, if that's how long you want to take for Mr. Cotton, is certainly the first person you could do that. With regard to the attorneys, I believe both attorneys have objected to that. Their objections are noted for the record, and your objection or your request is noted for the record as well. So at this point in time, my recommendation would be
That's
that
fine.
you...
I'll use the 5 minutes and
All right.
we'll go from there.
Well, the question
Just-
is, you have an opportunity, with regard to Mr. Cotton, he is a fact witness,
Right.
he has testified. If it was your intention to cross-examine him, you have that opportunity. Do you
Right,
understand that, sir?
So I also asked to talk to Jacob Egan. I believe he's in attendance today.
Who's that? Is that somebody for...
He's Onyx and East, right? So I could ask him
Well,
a
why
question.
don't we hear from Mr. Costello, his attorney?
Thank you. This is cross-examination. It's cross-exam of someone who testified. Mr. Egan has not testified. This is an opportunity to cross-examine witnesses who have testified.
Therefore, Mr. Cotton.
And then just a reminder again, just for the purpose of the record, Mr. Leinhardt, and I'm sure you understand that, but I just want to make it very clear that this is not a deposition, this is not a discovery, this is not fact-finding.
Yeah, no, that's fair.
And what you have is you have the opportunity to, at this point in time, the fact witness who has testified, who has provided evidence is Mr. Cotton. If it was your intention to, let me just finish, sir. If it was your intention to do so, now would be the opportune time.
Yeah, I would do that. The only reason why I asked why I said Jacob Egan, they filed for private provider, right? He is the one that is fully responsible for the people that actually do the actions, Bowler Engineering, all the people that make his buildings, and those people asserted certain things that he should be responsible and speak to, such as falsifying information on the building permit process. And I'd like to understand what his take on that is and what responsibility he bears. He, in signing the document that was submitted to the city, says that everybody has proper insurance and we're perfectly fine with our coverage. So I wanted to understand what responsibility does he have in this process of the actions of the people that submitted information to the city, which the permit was approved from. That was the reason for that question. So I'll move on to Mr. Cotton.
Mr. Cotton, if you'd like to be, come up, yes?
And, I mean, and if I may, I was going back to Mr. Shelby because a question was asked. I want to make sure, I mean, is it your opinion, right, that, I would assume so, that the objection of counsel on being deposed is reasonable and consistent with Florida law? Is that so?
Yes.
Okay, that's all. Thank you.
No, I don't believe it's counsel's position, or I didn't see any desires. Does counsel have any desire to take action to compel people to do that over objection?
Okay, just, again, just making sure, because the petitioner, just explain it to him, because again, yes, sir, thank you.
I appreciate it.
Let's kind of get back on track.
Yeah, no problem.
So this is cross-examination in accordance with the procedures for the hearing. So, Mr. Shelby? Yeah, so you have 5 minutes of cross-examination for witnesses that have already testified. And so you've got 5 minutes when you start. And, I would say use that time well. Again, it's not time to introduce anything else. This is just cross-examination by our procedures.
Again, Martin Shelby, City Council Attorney. I'm going to ask the petitioner, Mr. Leinhardt, to address your questions forward into the microphone to council members, and then allow Mr. Cotton to respond through the chair to council members as well. Thank you.
Stand by 1 second. I believe, Mr. Carlson, you had a question?
Mr. Shelby, or City Attorney, Councilmember Vieira's question, as I heard it, is about your legal opinion regarding the cross-examination of attorneys. And as I heard the answer, you said that council has not proposed it, but what's the legal opinion? Can you just state affirmly that your interpretation of Florida law is that it's not allowed, and so we shouldn't consider it?
I have not researched that in anticipation of this hearing today. I would say that normally, particularly with this council, attorneys have not been cross-examined when they are not fact witnesses, when they are representing clients. And also, it would be most unusual, and my suggestion would be to note the objection for the record and allow the case to proceed, because I don't want to make an opinion that creates error that cannot be cured.
All right.
Proceed with the cross-examination. Go ahead.
Mr. Cotton, what exactly is the extenuating circumstance that would warrant a design exception? in this hearing?
Eric Cotton, Development Coordination, as outlined in the approval letter, the discussion revolved around, for the two that were subject for 410 and for 408 and 410, which I believe are the two properties that are at issue here, was the depth of the lot and the desire to have a garage as shown on their permit plan.
So the garage is the extenuating circumstance.
That was what the applicant proposed, so that's what we reacted to, yes.
Okay. How many design exception appeal processes have you been part of?
Appeals, I would guess in the maybe 30.
Okay.
I don't
And how
have
many
an
design
exact number.
exception processes, like this year, have you been part of?
I honestly don't know the answer to that question.
Okay. Okay. How much familiarity do you have with the Seminole Heights?
Excuse me, sir. Direct your question
Oh,
to
I'm
the
sorry.
chair forward, please, so
All
it's pick it up by the microphone, and the finders of fact can hear what you're saying.
Fair enough. Okay. All right. So you talked about the extenuating circumstance that we're here for the design exception. In your written decision here, you said the site has been designed to have a detached one-car garage, an oversized garage. So is an oversized garage an extenuating circumstance?
Again, that's what the applicant applied for. That's what staff would have reviewed.
Okay. So in your review, you want to say an oversized garage on what the applicant has explained as a undersized lot per Seminole Heights standards would not be, is something that won't be warranted as an extenuating circumstance. You would say that an oversized garage is an extenuating circumstance, the need for that.
Can you repeat the question one more time
Yeah.
for me?
If the applicant has explained that the lots are less than 5,000 square feet, smaller than the traditional lot size in Seminole Heights, the minimum, right? And the applicant says, I would like to build an oversized garage on an undersized lot. You would say that is an extenuating circumstance which the city should agree that that is a reasonable decision.
There is no minimum garage size in the city. So an applicant proposes what they propose, and staff evaluates what that proposal is.
But you said in your decision, written decision, which other people will look at, an oversized garage, okay? The placement of the garage and primary structure is impacted by the craftsman style home, lot dimensions. You also go on to say, when taking into consideration the requirement to have a garage, is it a requirement to have a garage?
To answer that question based on my previous testimony today would be no.
Okay. And then, now, on 408 West Paris, you talk about the ability for a car to drive in and out of the garage, and the difference between the garage and the principal structure is 8 feet. Is that the minimum? Is that a reasonable amount of space that should be between a principal structure and a garage?
The code requirement is 5 feet wall to wall, and I believe 3 feet eave to eave. The applicant was asking for a garage, and its safety issues would require a easier maneuverability for the person to be able to back out of the garage.
Right, so 8 feet is the minimum that you would need then?
The way that was designed, I'm not a transportation engineer.
I know, it's in here because you allude to the ability to drive around the driveway, and that's why we have to move the buildings forward to 15 feet. You specifically called out on 410, it is 20 feet, but on 408, it's an 8 feet difference. So if 8 feet's the minimum, then I would look at 408 and say, if 8's the minimum and I'm gonna approve this design exception, and then I look at 410 West Paris, which has 20, I would say, well, that house can be 12 feet further back. That could be at 27 feet, and you still have the same exact circulation. Why the difference in discrepancy? Because you've called out the numbers on these oversized garages and alluded to the ability to drive around the driveway and park the garage. I don't understand how those are comparable, because you're conflating two different numbers and saying that is the minimum allowable. The minimum allowable would be 8. So can you tell me why 20 is the minimum allowable between the principal structure and the garage?
I believe on 410, if I recall, that was a 2-car garage, and the design of the building was to provide 2-car access.
On the plan, it is the exact same size, 21 feet 3 inches by 21 feet 3 inches on 408 and 410, the exact same oversized garage on an undersized lot. Can you explain why one would have to be 20 feet between the garage and the principal structure, and one is okay to be 8 feet.
I cannot explain to you why there's a difference on that.
Because it's influencing your decision to justify the 15-foot build-to line. That's why
Thank-
I would like the clarification.
Thank you very much. All right, next up, we have cross-examination by the property owner or their representative. Please state your name.
Shane Costello, Hill Ward Henderson for the property owner. Mr. Cotton, are design exceptions common in the Seminole Heights district
Yes, sir, they're common throughout the city.
and specifically for Seminole Heights district?
Yes, sir.
And specifically for things like setbacks and build-to lines?
Yes, sir.
Did the city staff review the design exception for compliance with the criteria in 27-60E5 of the code?
Yes, it did.
Okay. And did the city staff determine that the design exception that was approved complied with this criteria?
Yes, we did.
Okay. And that was taking all the facts and circumstances here into account?
Excuse me. Yes, sir.
Thank you. No further questions.
Thank you very much. At this time, we'll go to public comment. If anybody in the public that has not spoken wishes to speak, you have 3 minutes. Please state your name, and that's it. We'll go from there. Yes, sir. Please state your name.
Good afternoon. My name is Marco Perilla. I go by Tony. I'm on the Land Use Committee of South Seminole Heights Civic Association. And what's happening in Old Seminole Heights could easily happen in our neighborhood. Sorry about the chicken scratch.
Sorry. Can we zoom
When's
it
that
out?
going to,
It's too close.
something that no one has brought up, and I think is very important over here.
All right. Great.
Okay.
Move it up. There we go.
Right there. You have the new house, and you have the new house, you have Parish Street. Over here is an existing house near the corner. No one has mentioned the ugliness of this thing, the 30-foot difference between the front of the new house to the front of the existing house. 30 feet. That's from that wall to just about where this lady's standing over. 30 feet. I'll get that out of your way and come to this. Page 1 of 63, which is our special district overlay rules, regulations. Page 1. The builder does not comply with section 27-211, part B. The structural orientation, general site layout, spatial relationship are not precedent within the established block and surrounding area. These houses encourage an environment of visual blight. Drive by to see why I and many other neighbors are complaining. All structures there, the new structure, should be torn down, removed from the property, and in so doing, preserve the favorable environment of Seminole Heights neighborhood. I don't call a difference of 30 feet consistent. What we're talking about over here in B. I've measured in the past 3 months distances of homes in my neighborhood on 4 different streets, and the difference, the biggest difference I ever had was a 5-foot difference. Most of them 2 to 3 feet. Now I'll call that consistent. So in approving the design exception, that means we're going to leave these ugly houses all the way to the street. We're going to say that it's okay to be inconsistent with page 1. That's the purpose. The purpose of this overlay. So what I'm asking, well, there was a question asked to Mr. Cotton earlier. what is this averaging all about? What are we trying to accomplish? His statement was, consistent face to the street. Your words, sir. But I don't call a difference of 30 feet consistent. I would like for y'all to please go by what's written over here to save our neighborhood, to stay looking nice. Please vote against the design exception to these buildings. Thank you.
Thank you very much, sir. All right, next speaker. Yes, ma'am, please state your name.
My name is Michelle Mann. I am the homeowner at 404 West Paris Street, directly adjacent to the 4 lots that are considered being built. I am the only homeowner on that south side of the street that actually faces the street. 402 West Paris Street actually faces Ola, even though the side of their home does have a significant setback. I do not know the measurements. The home that faces Lynn at the other end of the street also has that same setback. I will say that this directly impacts my view. I will also say that the builder obviously built the 2 center lots out first so that they could have this setback from the street. And because then they knew that they would have the 2 empty lots on either side. Even in the builder's presentation, where he showed other, quote, adjacent properties on north, there was nothing that was at 15 feet. They were 23, 27. There is no other home in this area that has a 15-foot setback from the street. It does affect my home. It affects the property value of my home. And please understand that I only have so long to be there. I have owned this home for 45 years. I only have so much longer to be there. Then my home's going to be bulldozed down too, and another home's going to be built there. What setback will that home have? 402 faces Ola. Now you're going to have a large setback also on the lot next to me, which is currently not built. So while I don't have any laws or anything like that, I do want to tell you that it is directly affecting my lot. Also, if you want to know what was on the lot previously, I can testify to that. There was 1 home and a garage, and that was set back 35 feet, at least, perhaps more. So I don't see how we can, if you're going to use that old house that was there that was torn down, there you go. I can testify to that. So I would ask that this not be allowed. A 15-foot setback is nowhere else in Seminole Heights, in old Seminole Heights. Thank you very much.
At this time, are there any additional staff comments before I go to rebuttal from the aggrieved person / petitioner? Sir, if you would like to have rebuttal, you have 5 minutes, and from there, if there are no other questions, I would ask for a motion to close the public hearing. Yes, sir. Go ahead. Please state your name.
Marcus Leinhardt, 409 West Paris. Appreciate all your time today. I know it's been kind of an interesting journey, so thanks for giving me some levity as we've gone through this process here. In the end, we've laid out a handful of things, but the design exception today has to be weighed upon on what a design exception is approved or denied on. At the end of the day, is the exception warranted? I believe it has been firmly communicated that there is no extenuating circumstance that would warrant a design exception. The need for an oversized garage on an undersized lot is not an extenuating circumstance which to reshape an entire street, and have a lasting decision which can be done. I know the law firm that represented Oxenese talked about the slippery slope. I'll communicate to you what the slippery slope is and how it's not so slippery. 501 West Paris is an empty lot. If you listen to the rationale here, this is next to a street, 20 feet, next to the other house. Now that can go there. That is the same size lot as that they're building on. So therefore, why wouldn't they get the exact same exception to put an oversized garage on there and put the build-to line at 15 feet? My neighbor at 413 West Paris is going to tear down their house and build a new house, which they're gonna rent out. Where's that build-to line get set to? Same size lot, 4,250 square feet. Do they want a garage in the back of their house? Do they want an adjacent structure? Well, then it goes to 15 feet. Slippery slope is not a slippery slope. Michelle moves out of the house. 404 West Paris, that gets torn down. Where's the build-to line set to? You're setting precedent. It's not a slippery slope, it's a reality. So throughout this process, it's not warranted. It will have a lasting impact. And it impacts my family, my financial investment. The largest investment that my family will ever make is in the houses that we buy. I'm negatively impacted. My investment is negatively impacted. I own 2 houses on that street. I redeveloped both of those houses in accordance with the code that I've been given and the constraints of the lot which I've built upon. I ask you to deny this design exception because it is not warranted. The builder decided not to adhere to any of the constraints they were given. It is not my fault. It is not my decision as a citizen to ensure the developer makes money. That is their choice. That is an at-risk business. My job as a citizen is to make sure my neighborhood is taken care of and that all the developments adhere to that. Be an active participant in the process, right? I'm not here to ensure that they make money. That is not my job. And I should not be negatively impacted through the process that has occurred today. And I ask you to disapprove this design exception. Thank you.
Thank you very much. If there's nothing further, Councilmember Carlson, do you want to say something?
I just wanted to, if Marty allows me, I would like to ask the petitioner's specific rebuttal to some of the comments made by the other side, by Mr. Costello.
If you have questions, that would be appropriate.
Yeah. So, Mr.
Mind you, Mr. Carlson, that the petitioner has the burden and he would have the last word ultimately, so the final say, I should say, before you close the hearing. So go ahead.
I just wanted to hear, I wanted to hear his argument against some of the things that were presented before. Is that okay? Mr. Costello, he presented that by the time the stop order, work order came, the buildings were about 60% done, something like that. Do you have any response to that?
I'd say that, I mean, if you look at the pictures and just for clarity, I emailed after the stop work order every single day of the progress of those houses because to my understanding that they weren't supposed to be improved upon during a stop work order. So I have a pretty good idea of what it was. In one house, they had no drywall up, right? So I don't know how 68%, like I don't know what that's based on.
How long was it from the time you made a complaint until the stop work order?
It was over 2 weeks. And I can show you the pictures of what it looked like. The house that was directly in front of me at 408 West Paris didn't even have a roof on it.
Oh, so you think it was a lot less than 60%?
Yeah, when I submitted my complaint, it was a lot less than 60%.
And then it was presented that the stop work order was deemed unenforceable by the city. Were you aware of that? That was in the presentation that we got.
Yeah, so through my interactions and emails, I asked very many times why they continue to build on the lot. What was communicated to me is that they had the right to secure their building, and that was like put a garage door on it, do all these things, right? That was what was communicated to me.
So another point that was made is that it's the average of the adjacent structures, and what they presented is that the code is silent where no adjacent structures on either side of the lot with the same street for orientation. Do you have any response to that?
Yeah, here, excuse me for 1 second. So, like, adjacent means nearby. So let me, like, I went out there, I did Google, what is the definition in Webster's dictionary. I actually pulled up the the US government geographical map, and they have definitions around words that they use when they map things out and what it means. What?
Can you put it up?
Put it up there on the overhead.
So here it says, is that good enough?
Hey,
There you go.
could you tell us where this is from again?
1 second here. I have to find where the paper is, but I had the cover side, but it's from the US government, and it was correlated to maps and surveys. And then they broke down the definition of the words that they use in there. What?
Can you just read it to us?
Yeah, so adjacent, lying near, close to, sometimes continuous, neighboring. The term adjacent implies that the two objects or parcels of land are not widely separated, though they may not actually touch, while adjoining implies they are so joined and united to each other that no third object or parcel of land intervenes. Also see a but.
And then another argument that was made was that the city cannot enforce an unclear or non-existent regulation to restrict or limit the free use of property. So this is the difference between code and policy. Do you have any response to that?
When I went to build my house at 409 West Paris, they enforced the code. Eric and his staff highlighted the code that should be enforced to determine the build-to line multiple times and asked the builder to respond to it. So to say that we can't establish a build-to line, I think is a leap too far, and I don't entertain that as something that the ability to say, oh, we can just not establish any build-to line, like is what they were asserting, and I think that's completely false. Like there's rules and regulations which we follow. I've been subject to them twice with the city of Tampa.
And they also presented a picture which shows from what I can tell, the frontage to be the same with all four houses, but two of them are not built. Is it your understanding that they intend to have the setback on 406 and 412 to be the same as 408 and 410?
So when they submitted all four plans in Acela, all four plans had 15-foot build-to lines. That was their intent, to build 4 houses at 15 feet. I guess I would ask, like, the lawyer who presented in front of you today, he appears to have knowledge of the code, Florida state statute as it relates to this, right? What would determine a 15-foot build-to line in that? It's a vacuum, which they said, no adjacent structures. So we just randomly pick a number and we put a house there.
Thank you very much. Wait, yeah, Councilmember Miranda? Turn on the microphone.
It is, I'm sorry. It was on, but I was, the petitioner mentioned Florida, the individual representing the developer mentioned something that Florida statute 553.792B. Does any city council attorney or attorney for the city understand or know what that means?
Martin Shelby, City Council Attorney. I have that put in front of me, the 2B, and the actual verbatim quote is, after the local enforcing agency issues a permit, the local enforcing agency may not make or require any substantive changes to the plans or specifications except changes required for compliance with the Florida Building Code, the Florida Fire Prevention Code, or the Life Safety Code, or local amendments thereto. If a local enforcing agency makes or requires substantive changes to the plans or specifications after a permit is issued, the local enforcing agency must identify the specific plan features that do not comply with the applicable codes, identify the specific code chapters and sections upon which the finding is based, and provide the information to the permit holder in writing. That is the actual verbatim language.
What does that mean in this case?
I suspect the best thing to do is to ask staff what that would mean, unless you want to inquire of the attorney who made the assertion. But you have subject matter expert, but you don't have somebody from building permits today. I believe Mr. Cotton said he's only involved with zoning and not with permitting.
Point of information.
Yes.
It's my understanding by the criteria that was set for us with this, about the purpose of this hearing, was just the review of the denial of, or the design exception. And so that would be a separate case.
Well, not necessarily relevant to your, not relevant to your decision per se, but may be relevant to the resolution of whatever comes
Well,
of it.
but after we say,
Whatever your decision is.
I don't think that that would be applicable to the decision that we make today based on the criteria that was set forth to us about, this was a design exception case.
No, this was not within the criteria that was discussed earlier by Ms. Wells, that much
Yeah,
is
that's,
true.
so I mean, and a lot of this, because that's, I've sort of tried to keep these arguments fenced to the point of this hearing was whether we were going to uphold the decision of the city official on the design exception or overturn,
Yes.
period.
Yes, and as with all hearings, after you close the hearing, you're going to have to make your decision based on the competent substantial evidence, having the criteria in front of you, citing to the criteria, and making findings of fact that support the basis for your decision based on the criteria.
So when I heard that come from the representative of the property owner, it sounded like you better not do this or else, but it wasn't necessarily like a warning shot. It wasn't necessarily relevant to the decision that we make today.
Well, it certainly is not in the criteria with which you make your decision
Thank you.
based on the
Thank you.
parameters you've been given.
Does that answer your question?
That's what I wanted to.
We have a motion.
That's why I asked the question. I mean,
Thank
it's,
We have a motion to close from Councilmember Hurtak. Was that a second from Councilmember Clendenin? All in favor? Aye. The hearing is now closed. What is the pleasure of the council? Yes, sir. Go ahead, sir.
I've made a couple of points earlier about the meeting, and I really appreciate the criteria that was put up about adjacent, because I came from government, and that was kind of our government definition of it as well. So I appreciate that clarification about what adjacent means. I concur with that. A couple of other observations, and we talked about policy, we talked about historically applied and what that means versus this. 2 points I want to make. That one, and I implied this again when I spoke earlier, about when the property owner's representative made their testimony. They presented a lot of information, but a lot of it didn't appear to me to be consistent with information that we would use to find in their favor. One of those examples, in fact, it was highlighted in public comment, was the setbacks, not just on this block, but all these other adjacent blocks. I mean, clearly, all these other setbacks were much greater than what we're talking about today. So again, it didn't seem consistent with what y'all were looking for if you're looking for justification for a 50-foot setback. The other concern I have about equitable treatment under the law, the aggrieved person testified that when they built their house, they wanted to do certain things, and they were denied that opportunity because of these setbacks and these opportunities. So the criteria that was used for this one property in the same block directly across the street clearly is very different than the criteria is being used for, or being asked for by these design exceptions right across the street. So I have concern about equitable treatment under the law, that one side of the street was treated differently than the other.
If I can.
Yes.
And I'm sorry to interrupt you, and forgive me for doing that. It's not my intention to break your train of thought.
No.
But
It's implying that I actually have a consistent train of thought.
I want to acknowledge that for the record. But let me say this, though. With regard to your criteria, equitable treatment is not within your criteria.
Right.
So
Well,
here's my suggestion. It is offered to you for the purposes of fact that may factor into your criteria, that when you review the criteria, those, rather than looking at the equity of the actions, look at what the facts are and whether the facts, as you find them to be, are applicable to something that fosters a decision.
And the last and closing point on that point was that he constructed his house with these build-to lines and within this confines that would be expected in this neighborhood, and would not require a design exception.
And if you wish as a council to make that as a finding of fact to include in your motion, if that's council's decision, or whatever decision you make, a finding of fact that makes a point one way or the other with regard to the criteria is what is looked for in the record to support your decision.
Okay, and I believe one of my other council persons is going to make those findings of facts, and those are just the statements that I wanted to make. Thank you.
What I'm going to ask as a
Yes.
general rule, to talk about policy at this point in stage is to derail the purpose of this hearing. You are now finders of fact. You've been provided with the law, the code, and now it's a basis of acting as a jury in that sense of applying the facts to the law to determine what your decision is.
I heard and understand.
Councilmember Hurtak, then Councilmember Carlson.
Thank you. I'm going to go ahead and make a motion to overturn the zoning administrator's decision and deny the DE1 application based on looking at the review criteria for design exception 1, which is section 21-60, that the exception does in fact interfere with the rights of others as provided in this chapter and testified to by both the next door neighbor and the across the street neighbor, that it does not provide a reasonable allowance of use under the specified circumstances of each application. And I'm going to quote my former fellow Variance Review Board member, Dustin Pasteur, whose famous quote was, "No one is owed a pool." And I'm just going to trade this for garages are a want, not a requirement. I'm going to go on to the next criteria. This does not achieve the general intent of this chapter and the Tampa Comprehensive Plan as shown by one of the members from South Seminole Heights who showed the overlay code and what the general intent was. And it is not the minimum possible exception. Under the specific circumstances, without the garage, a much smaller exception could have been made and more reasonable at that.
Do we have a second?
Second.
Second from Councilmember Clendenin.
27.
I'm sorry. Sorry to interrupt.
2760.
But I heard Mr. Clendenin, are there things, and any council member can say whatever position they wish, but if there's anybody who wants to amend or add to facts or statements of the law regarding the motion, it would be appropriate to do so. It's not the sole ownership of the motion, it's ultimately the decision of this board.
Anything you want to add?
Yes, as was brought forth to us was applicable code criteria at section 27-211, subparagraph 227, 211, subparagraph B, and that was the Seminole Heights overlay district about setbacks.
So we have a motion from,
Make with regard to that.
That the Seminole Heights overlay district, accordance with that code, the criteria was setback, and this does not meet that criteria.
we have a motion from Councilmember Hurtak, a second from Councilmember Clendenin with some additional information. Roll call vote.
Hurtak,
Yes.
Clendenin,
Yes.
Henderson is absent, Vieira,
No.
Miranda,
No.
Carlson. Yes. And Maniscalco.
Yes.
Motion carried with Vieira and Miranda voting no and Henderson being absent.
Can we take a 5-minute recess?
Before you break, council, stop, I'm sorry, before you call recess, Mr. Chairman, just be advised that this matter is subject to review, and I would advise you to not discuss this matter publicly or amongst yourselves especially. Thank you.
We are in recess for 5 minutes.
VRB 23-66 for the property at 701 West Hillsborough Avenue. I just handed Mr. Shelby, and he'll be distributing to council sample motions as well as rules of procedure. They will follow the same format as in the prior hearing that just concluded. So the petitioner in this case is Worldwide Auto Systems Corp. Worldwide had applied for a variance to the VRB, well, 3 variances actually. The first one was to increase allowable sign square footage from 62.5 square feet to 151.1 square feet. The second variance request was to allow 2 additional building signs and 1 that doesn't face a public right-of-way. And then third and finally, to allow 100% of window sign coverage when the code allows only 25% of a window to be covered. So the Variance Review Board granted the first 2 variances. So they granted the variance to allow sign square footage to go from 62.5 square feet that's allowable on this property to 151.1 square feet. And they also allowed 2 additional building signs for a total of 3 signs. 2 signs which would face the right-of-way along Hillsborough Avenue and 1 sign that would not face the public right-of-way. So the third variance, the one that was denied, was to allow, or the request was for 100% of the windows to be covered with signage. And again, the code allows only 25%. So the Variance Review Board denied that variance based on the fact that they did not believe that the applicant had shown a hardship, which Josh will go over, or staff will go over in a moment, is the criteria upon which a variance may be granted. So the Variance Review Board felt that the granting of the first 2 variances eliminated any hardship on this property. And so the applicant or the petitioner is now seeking council's review of the denial of that third variance only. Again, the code sections that guide you in this case are 27-80, application of the variance power, which I believe, again, staff will describe to you in more detail. Section 27-61J3, which is your review hearing criteria, and then 27-289.3, which is the code section that describes allowable signs, and again, places that restriction limiting window sign coverage to only 25% of the window. Again, I have provided council with sample motions and rules of procedure. Your standard of review for these proceedings can be found in section 27-61J3 of the code. This provides for a de novo review, which means that council may accept new evidence, take public testimony, and then determine whether the petitioner meets the variance criteria according to City of Tampa Code section 27-80. Staff, Josh Blackman, will provide an overview of the application and further comments on the VRB decision. And then City Council may take, after hearing evidence at the hearing, one of 2 actions. City Council may either affirm the decision by the VRB and thereby deny the request for the variance, or City Council may overturn the decision by the VRB and grant the request for the variance. I'll now turn it over to staff, Mr. Josh Blackman.
If I can, Ms.
Yes.
Johnson-Velez, I'm sorry to interrupt, but council, before we begin, I just want to ask council to receive and file any ex parte communications written that have been made available to the public. A motion and vote.
Motion from Councilmember Clendenin. Do we have a second? Second from Councilmember Miranda. All in favor?
Aye.
Aye.
And just a reminder, if there have been any verbal ex parte communications, please disclose them at this time. I see none. Thank you.
Josh Blackman, in the zoning division, and I have been sworn in. I think for the presentation.
Is this your first time in front of council?
This is my first time in front of council,
Welcome.
yes. Thank you. Okay. Okay, so this is the appeal of VRB 2366. The owner is Charos Property LLC. The applicant is Worldwide Auto Systems and Anna Diaz. The property is located at 701 West Hillsborough Avenue, and the zoning is commercial general. So the variance request is broken up into, like I said, 3 components. The first was to increase the allowable sign square footage from 62.5 square feet to 151.1 square feet, and that one was approved. The second was to allow 2 additional building signs, and one of them does not face the public right-of-way. That one was also approved. And third is to allow 100% of the window sign covering when only 25% is allowed, and that one was denied. The code sections for this was 27-289 3B6A and 27-289 3B6B1 and 27-289.3 A5B6. Here is an aerial of the site, and you can see the property highlighted in that orange dashed line. Here's a photo with the window signs as they exist today. And here is a photo without the window signs. On the left-hand side, you'll see the site plan with the locations of those 3 signs that were approved. On the right side, you'll see the elevations with the building signs, in addition to the locations of the window signs. This is just a zoomed-in version of the site plan and another zoomed-in version of the elevations. The development review comments came back either consistent or consistent with conditions except for zoning. It was inconsistent because the square footage allowed was the 62.5 square feet when the applicant is asking for 151.1 square feet, which is 2.42 times the amount allowable. 1 sign is allowed per single occupancy per parcel is allowable. The applicant was asking for 3 signs, and 1 of those was not facing the public right-of-way. And finally, only 25% of the window area is allowed. The applicant was asking for 100%. This is for your reference. This is what the variance review board uses to determine what a variance or what the hardship is. Per the applicant has to answer each one of those 5 hardship criteria questions. And this is what the applicant provided as a response to those 5 hardship criteria questions. So for VRB 2366, the Variance Review Board made a determination on November 14th, 2023, and they made 2 separate motions. The first motion was to approve the increase in square footage for the signs and to allow an additional sign with 1 not facing the public right-of-way. That motion was passed 5-0. The second motion was for the window covering signs, and that motion was denied, and the motion carried 5-0 as well. And that concludes staff's presentation.
Thank you very much, sir. All right. At this time, anything from you, Mr. Cotton? No? All right, we go to the presentation by the applicant or the petitioner here. Ma'am, you've been here for a while. Were you sworn in earlier?
Yes.
Okay, go ahead. Please state your name. You have 15 minutes.
Okay. My name is Ana Diaz. As a local business, my main objective is to serve to the local community through the sales of goods and services. In addition to creating opportunities for professional growth and living wage for workers. Window signs are a visual communication between a small business and the community, which generates more trust in the business-customer relationship. It is important to keep in mind that people in the community spend little time, only seconds, to read and interpret a sign. So the image is the main attraction. A sign must be understood in a couple of seconds, and this is provided by the image. Local businesses are usually owned by people who live in the community, who are less likely to live and are more interested in the future of the community. So we need the community to come to us and buy from local business in order for us as a company to create jobs and compete with the big chains and online businesses. We also are affected by the fact that the shop is about the 10% of the total area of the property and is located toward to the back, away from the sidewalk. So if we are allowed more than 25% window coverage, it would help us much better, and we would have more opportunity to serve it to the community. On the one hand, window signs do not affect the value of surrounding property. On other hand, they beautify the neighborhood. Proof of this is the change that the property has undergone since we bought the property. The property is clean and tidy. The neighbors have accepted us, and we want to offer the best possible service and comfort to foster trust and mutual support between residents and business. In conclusion, covering only the 25% of the window take away a lot of our visibility, and the community will not know in detail what we do. Thank you.
Thank you very much.
You're welcome.
Any questions by city council at this time? I see none. At this time, we have it open for public comment. Would anybody wish to speak on this item? You have 3 minutes. Is there anybody registered? Okay. Is there any additional staff comment? Yes, ma'am.
Susan Johnson, Velez, Legal Department. I believe you have a copy of the applicant's petition, and it does appear that she might be intending to modify her request. The board, the VRB considered 100% window coverage, and her application, when I looked at it, appears to be changing her request to reduce that percentage a little bit. You know, council should still consider the hardship criteria, but the application on the front does seem to reduce the request.
Yes, ma'am.
I'm sorry.
Wait.
Forgive me. I didn't quite understand exactly what she's requesting today.
Yes, so I was just gonna ask the applicant.
Oh,
Yeah, ma'am, if you could come back up.
Yes, can you repeat that, please?
Yes, how much of the window did you want to cover?
Okay, I have the picture here, the real picture
Put it
for
on
now.
the overhead so we can see.
Upside down.
That's upside down.
Upside down?
No, the other way.
No. Reverse, reverse.
That's okay, you are not the
Old
first.
fashioned.
That's okay, it's very common, no worries.
There we go.
Okay. I was doing my calculation. I want 100% because it's very small property, but something is something. The front here belongs to the 65% of the property. That is why I'm willing to remove the side, the window side or the side.
Okay,
just
So if
wanna
you
have
allow
the
me the
front.
65%, it's going to be very helpful for us.
Okay.
okay, thank you.
You're welcome.
So you just want to keep it where the phone number is at
Yeah,
that front side, and the
because-
side, you want to keep it blank?
Honesty, from the bottom of my heart, we bought a property a year ago. I'm so tired because to be right in the life sometimes it's very hard. Nobody asked for permission to put the sign to window cover for nothing, but I enter with the permit, I have to do right. Even the company who put my sign, they have everything in front. But what I'm going to do? Nothing. I have to comply. I need to be in compliance. I'm very clear. But to don't spend more money, to be right, I am willing to remove all the signs. Don't worry. It's going to be in blank. That is not going to be a problem.
Councilman Moran.
Two things. Thank God that the building is way back. You got a lot of parking in the front for your customers.
Yeah,
Think of
but
it that
see,
way.
you don't allow me to show the customer what I do. How
But
am I
you
going
gotta
to
think-
move forward?
You gotta think for the future. I think you're gonna do well, so if
I
you
don't
if
have
you
to
build
move
it in the front,
future.
you got more parking.
I am very close to retirement.
But anyway, what you're looking at here is you want 3 panels out of 5 panels, or 3/5.
Yes,
of
we
100.
have 6. I'm willing to remove 2 because it's going to belong the 65%. It's going to be very careful.
Okay. All right. Would you like to add anything else? No? Okay, may I get a motion to close?
So moved.
Motion to close from Councilman Miranda, second from Councilman Vieira, all in favor? Aye. Would anybody like to make a motion? We have sample motions, or if anybody would like to add to it?
I don't even know what I did with the motion thing here. I got it, I found it, thank you.
I'll make a motion.
Can I just ask a question?
Go ahead.
Ms. Johnson Velez, what do we do about the 65%?
Thank you.
Motion to reopen.
We have a motion to reopen from Councilmember Clendenin, Same Councilmember Viera, all in favor?
Aye.
Aye. Go ahead.
Susan Johnson Velez, so what council needs to consider is whether the hardship criteria and other criteria in the code have been met, because that is what the VRB is, has to base it on. So if you determine that there is a hardship that justifies a 40% increase in the percentage of window coverage that's allowable, then council may, make a different decision. However,
Thank you.
okay, you're welcome, thank you.
Can you say that? So the VRB already granted 2 of the hardships, right?
Correct, they did, 2 out of the 3, that's correct.
And, wow. And so they would be permitted to basically have a sign in one window. Would that be, basically would be their?
Whatever the percentage is, I don't know the total square feet, but
Yeah.
yes, that is what the code allows, is a maximum of 25%.
And can I ask the, do you mind if I ask her the?
Do whatever you want.
Can you come up again, please? Can I ask you a question? Could you clearly state what your declared hardship is on this?
Could you repeat that?
Could you state what the hardship, what you want us to consider as far as a hardship?
Yes. Sometimes we have the sign and people don't read. People need the visual communication. People need the imaging. That is my experience for 50 years. I had a shop before for more than more than 10 years in Florida, and they don't read the sign. They go to the imaging. And we are brand new in Tampa. We really need that. It's the only way to the neighborhood see us, and that we are doing. I understand the code. I understand that I need to be in compliance, but that is not going to damage at all the neighborhood. It's going to make beautiful. People like to see that.
Thank you.
You're welcome.
Yes.
If I
Since
may, and I'm
they-
not coming to
okay.
anyone's right or wrong, but this is a different type of operation.
Should we close? Are you asking a question?
No, I'm just making, I'm rambling so we can understand how I ramble.
Motion to close?
We're open, right?
Yeah, we're open.
So what I'm saying is that when you look at any one of these stores, discount stores, or any one of these so-called automobile supply shops, there's not one that doesn't have something in the window. Look at all of them. And this would be not 100%, it would be 3/5, because you're knocking down 2 panels, there's 5 panels, so 5 of 5 is 100, so it'd be 3/5 of what's there now, of what we saw. The 2 panels would be open. I'm not here to her defense or to her rightness or wrongness, but if you go down and look at any auto supply shop, all of them, they have signs in the window.
May I put you a good sample? I'm defending my business. I don't like cars, but I own an auto repair. I'm going to tell you. I'm going to put a real sample from the bottom of my heart, very honest. When I'm looking for a beauty salon in Tampa. I don't have time yet. See, if I don't see at the window the side with the African lady, and they has the Dominican lady doing the blow dry, I don't go inside. Even they say beauty salon, I need to see what I need. If people see like that, I'm putting in the population side.
I would go in if it had anything in the sign.
Because you don't move the economy, say. You are like my son.
Okay. Motion closed from Councilmember Hurtak.
I'm sorry.
Yes.
Susan Johnson, Les Legal Department. I just wanted to clarify, because I do remind the VRB every meeting that we have that council should consider this application standalone on its merits, because we don't know the situation with other businesses and so forth. So you need to consider this application on its merits for this property only. Thank you.
Motion to close from Councilmember Clendenin,
Second.
Councilmember Hurtak. All in favor?
Aye.
Aye. What is the pleasure of council? Go ahead. Yes, ma'am.
I'm just gonna give a comment, but I don't see a sense of hardship here. I see that 2 signs were already approved, and to add more signage, I mean, this goes with the property. So then whatever's there next can also cover windows. So to me, there was not enough competent substantial evidence to overturn the VRB's decision.
Okay, anybody wish to make a motion?
Yeah, more comment. I kind of concur, and I feel for it, but I keep thinking that this is one of those things that every business would like a lot of signs. I mean, if I owned a business, I'd want to sign the heck out of it because, of course, that's good for business, you know, but it's not necessarily good for the community. It's not necessarily good for what we're trying to build and the reason why we have code. The reason why we have these rules and regulations is because we have certain expectations. So I think the VRB was very generous in providing the variances that they granted already. And I think this is kind of I think the signs that you be permitted, you know, you'll still be able to get your message out. And obviously, you know, you seem to be a good person. You provide a good service, and I really wish your business well.
Councilmember Carlson? No, it's closed. It's closed.
Oh, my time is closed. Okay.
Yeah, just similar to what my colleague said. When I was growing up, I worked summers in my uncle's store, which was the same kind of store, changing tires and rotation and all that stuff. And it's really hard work, and you want to try to do the best marketing you can. But looking at the designs that are on the windows, those designs were professionally designed. They were very high quality. About a whole bunch of it was behind benches, so you couldn't even see it. And I think that with a professional designer like that, you can design to the code and still be effective. And so I don't see a hardship. I'll be the bad guy and just say I move to uphold the Variance Review Board's denial of the proposed variance request in VRB 23-66 for the property located at 701 West Hillsborough Avenue because the petitioner failed to provide competent substantial evidence of a hardship according to the standards set forth in Code Section 27-80. And the main reason is what it just said, which is there was no competent substantial evidence presented that there's a hardship.
We have a motion, Councilmember Carlson, second Councilmember Hurtak, roll call vote.
Clendenin.
Yes.
Henderson's absent. Vieira.
No.
Miranda.
No.
Carlson.
Yes.
Hurtak.
Yes.
And Maniscalco.
No.
Motion failed due to a lack of majority vote.
Actually, it didn't fail. Well,
Was five.
3-3.
3-3. Tie vote. Tie vote. Rule 6H, if a motion in a quasi-judicial matter fails to receive at least 4 votes, the motion fails, and if another motion in order is not made, the public hearing shall be automatically reopened and continued to a time certain at the next regularly scheduled council meeting. So you were correct, Madam Clerk, the motion did fail.
Anybody
But now
wanna
the
make
hearing
another
the hearing is now reopened and to be continued.
Yeah, if I may? Yes. Yeah, I mean, by virtue of the vote, it's futile to make any further motions, I would think, and we have to go to the next meeting.
And that motion, time and place and location, Madam Clerk, would be?
The next meeting is February 15th, 2024 at 10 o'clock a.m., 315 East Kennedy Boulevard, 3rd floor, Tampa, Florida, 33602.
May we have a vote on second on that? Second. A second and a vote. What?
We have a motion from Councilmember.
No, you don't, well, it's automatically been reopened. If you want to do it, if you want to make it for the record to reopen it, that's fine too, but either way, it'll come back.
We have a motion to continue this to February 15th by Councilmember Miranda, second from Councilmember Clendenin. All in favor? Aye. Aye.
And
Okay.
I'll inform Councilwoman Henderson's office to be prepared to vote on the 15th.
Yes, and they can, she can watch the record and review it. Thank you very much.
Thank you.
Okay. Let's go to administration update. Chief Bennett, you might be online. Oh.
No, it's okay.
Good afternoon, Council. I'm Eric Hayden with TNI. Chief Bennett is actually detained. He can't be here, so he asked me to actually show you a CIP map viewer update, if that's okay.
Go ahead, sir. Go ahead.
All right, perfect. Let me set up the PC real quick.
We have it up. Go ahead, sir.
All right, good.
Yep.
All right. First of all, Chief Bennett was in conversations past with council, has overheard different types of enhancement types of requests. One of the things he wanted to do was try to bring some of these requests to you fast, do it really quickly. So he worked with our GIS teams, and he actually got one of the main updates in, which that was adding a filter so you can actually look at projects, on our CIP tables, you can actually look at projects based on cost. So you can actually filter down to say cost, like projects over a certain amount of money, under a certain amount of money, and that way you won't see all projects at all time. These little filters work in conjunction with the other filters, so you can actually do neighborhoods, districts, the same thing that you've always been able to do. This is on the public-facing side on tampa.gov. And let's see if I can actually show you a little quick demo here. And forgive me, the screen here, okay, there you go. If you look at the bottom left-hand side of the web page, this is just the link to the CIP viewer. The two fields that are brand new are here, project cost estimate. So if you were to put in a number here, such as $1 million, you'll notice on the right, the projects actually go down from the total number of projects to the number of projects from 1 million and up. So there's 127 active projects. You can make that number anything you want up to $1 billion. I think the $1 billion is the top of this particular limit. But he wants to show you how, basically how simple this was, and he was also very appreciative of the TNI GIS team to actually put these changes in so quickly. You'll see going between 1 million and 2 million is 45 projects, that kind of thing. It just helps make it enhances the viewer so that other people can actually use it and get information a little quicker without polluting with all types of information that they're not really particularly looking for. Okay, Chief Bennett just wanted to make sure we got this in front of you, just to let you know that we are hearing you, and Chief Bennett's hearing you, and he wanted to make sure that this enhances the view for the public, enhances the view for all internal as well, that we can actually look at it internal side. Any questions or so forth? And if that's good, I'm happy to shut it down.
Thank you very much, sir.
Perfect.
All right. Yes.
I just wanted to say that this is very nice, and I appreciate TNI's ability to do this. Hopefully, the public sees this and is able to use it more clearly. Thank you.
You're very welcome.
Can you just tell the public how to find it?
Absolutely. On the main tampa.gov website, if we go backwards, it's actually right about the middle of the page, and you'll see Jane Castor. Right over here, you'll see this capital improvement projects viewer, and that's on the tampa.gov website, first page. All right?
Thank you very much.
You're very welcome.
Have a great afternoon.
You
Next
too.
up is item number 40, and then we will go to 44, and then back to 39. All right. Mr. Romero,
Yes, sir. You good there?
let's talk about bonding capacity of the city.
Let's. I don't know how to close. Oh, maybe I do. Thanks.
We have you have a PowerPoint with this, correct?
I do, yes, sir.
Okay.
And if I could have that presentation up. Oh, I'm sorry. Good afternoon, Council. Dennis Rogero, Chief Financial Officer. If you can let me know when you see the presentation. You see it? Yeah. What's this then? All right, I'll just look up. Again, this is our bonding capacity and financing overview presentation. It's a great deal of information, as you've already seen, but very valuable information, giving council and the public the entirety of our debt universe, from citywide over the course of many decades down to individual projects. We're going to run the gamut from a very wide net down to particular projects. We enjoyed preparing it. We look forward to presenting it. So thanks for having us here today. And you see our agenda. We'll start with an update and outlook of the municipal debt market. These are interesting times. They remain interesting times after all, and this will provide a nice context as to the environment we're dealing in with as we try to finance projects. We'll then cover it's up there. We'll then cover our credit ratings, our very wide view of all of our debt, as I said, citywide, principal and interest, and then into more detailed discussions. And then at the bottom, any questions or further discussion that you all would like. Here are our presenters, and we'll be trading off on the different subjects throughout this presentation. I'll introduce them quickly, and you'll see them very, very soon. Ms. Molly Clark, Senior Managing Director of Public Resources Advisory Group, affectionately known as PRAG. Mr. Jerry Ford, President, Ford and Associates Incorporated, and my apologies for missing Mr. Will Reed, who will also be here from Ford Associates to discuss our water and wastewater financing. Council probably recalls that we have a very successful history with all of these professionals and their organizations. And truth be told, the tremendous success that we have enjoyed is due in great part to their efforts. So we're happy to have them here today, happy to continue working with them. And having said that, I'll pass it over to Mr. Ford to provide that overview. And again, just giving some insight into the many, many factors that they take into account, that we take into account in the municipal market. There he is. Mr. Ford, thanks. Now how to advance?
I do not.
It's right there.
Very good. Thank you. Good afternoon. Thank you for your time. I'm going to spend just a couple of minutes giving you a brief recap of the market and tell you where we are today. Let me make note that some of the data in your presentation is from January 11th, which is when this was put in. The market's been in flux since then, so we're going to talk about that just a little bit. So following a period of extended relative market stability and very, very low rates, the landscape changed significantly starting after the first quarter of 2022.
I'm sorry to interrupt you, Jay. Do you have the presentation on your screen?
We have it on our screen.
There it is. I apologize.
Very good. In large part due to inflationary pressures from March of 22 through the end of July of 23, the Fed embarked on its most aggressive rate tightening in its history. It went from 25 basis points, or 1/4%, which was the upper end of the Fed funds rate target. For those of you who may not be familiar, the Fed has a target range. It ranges, at that point in time, it ranged from 0% to 0.25%. Today, it's at 5.25% to 5.5%. That is the upper end of that target range. They did that 11 times. And as 2023 opened, most economists and most market prognosticators expected a recession. That recession didn't happen, but fears of that were exacerbated by 2 bank failures in March of 23, followed by another a few weeks later. As you remember, that caused a lot of turmoil in the markets. Congress, as it does frequently, battled over the debt ceiling. That resulted in the downgrade of the United States credit rating by the rating agencies. Tone improved during the summer of last year with increases in consumer services spending, followed in the third quarter by the fastest GDP growth that we'd had since mid-21. In the fourth quarter, real GDP grew at 3.3%, well above market predictions. That started to get the market's attention. Stock market started moving forward. The 10-year, the growth in inflation lessened during that time. It's continued to do so to today. The 10-year started at about 4% earlier in the year in 2023. It got as high as 5% in the mid-October range, and then it fell back below 4% by the end of the year. It finished today at about a 388, by the way. So beginning of the year, the Dow was at 33,136. It sat at 32.4 in mid-October. It went up to 37.8 in December, and today it closed somewhere in the area of 38,450. So things are moving. The chart that you see in front of you now shows you yields from a service called municipal market data. and they track yields, AAA yields, AAA like your water and wastewater debt across the country, large sophisticated issuers. And this shows you 1-year rates, 10-year rates, 20-year rates, and 30-year rates. And as you can see from that example, that the yield curve was what we call inverted. That is, yields in 1 year were higher than they were in 2 and 3 and 4 years. In fact, you had to go out beyond 15 years before rates got in excess of where they were in 1 year. That still remains the case today. Rates peaked in that October timeframe and then started coming down. By the end of the year, they had come down significantly, and then during the first part of January, they started to ebb back up just a bit. And the last 2 days, we've seen significant drops in the rates again, so they're about where they started at the beginning of this graph. So what does this tell us about where the market's going to be when we get ready to go to market with your next transaction? Well, nobody can say for certain. We always say that people who use crystal balls end up eating glass at some point in time, so we simply don't know what's going to happen. However, what we do know is that there are some positive signs for the market and some positive signs for the economy. The Fed met, as you know, on Wednesday. The Fed met Open Market Committee, and there were 2 really significant things that came out of that meeting. The first was, for the first time in many, many, many of their meetings, there was no further discussion of tightening. Tightening comments came off the board. The other thing that's going on is that economists have basically been in agreement that there will be several rate cuts this year. About 20% of them felt like it would come by the March meeting. A large group felt that it would come by April, with more coming after that. In its comments after the meeting the other day, the Fed made it very clear that it did not see its ability to start cutting rates until we were sustainably approaching the 2% inflation level. So it says, yeah, we're going to get you there, but not yet. That was enough to spur the market and spur the rallies in the muni market over the last couple of days. So what we think is we're heading into a period here of relative stability and improvement in the muni market. The muni market today is outperforming the treasury market. When people buy municipal bonds, they buy them because they're tax exempt, and they look at that return on those bonds in terms of what the taxable value would be against, say, a treasury bond. Right now, those yields are very, very low, and there's a wider gap between tax-exempt interest rates and taxable interest rates than there normally is. So we're trading very rich to the market. How long that continues, I don't know. But next time we're back up here, we'll be able to update you on that. So that is where the market stands right now, and that is what we see going forward. Thank you for your time.
Thank you very much, sir.
Thank you, sir. You want your laptop? Yeah.
That's very interesting. You know, the fears of a recession a year ago, you know, you see the tech sector, how it's rebounded, how the Dow Jones has hit another record high. It's just, you know, the fears of recession that didn't happen in 2023. Doesn't mean it's not going to, however. But thank you very much.
Yes, and thank you again, Mr. Ford. And if I could have the presentation up again. There we go. And now we'll enter our financing overview. I'm going to start with our ratings, as we said. And we'll begin with these ratings. Council and the public have seen various versions of this throughout the years, but it really is such a positive story. I always think it's worth reiterating to make us aware, to help us reflect on the very hard work that we've done over the course of the years to cement these very, very good credit ratings. You see 2 credit ratings since 2019. They're highlighted in green. As you've heard, the water and sewer bonds were rated AAA, or upgraded, AAA by Moody's, bringing all 3 across the board, Moody's, Fitch, and Standard & Poor's, or S&P on the right, to the highest levels attainable. One other locality in the state of Florida enjoys that pedestal, and only 5 others in the United States are that high. That is very, very rare air. Our non-ad valorem revenue bond was upgraded pardon me, to AA1 recently, and again, very, very rich, just, you see that, and then on the far right again, Standard & Poor's, S&P, AAA, the highest you can get. So as always, and I hope to continue every time we talk about it, congratulating council, congratulating the mayor, congratulating my team, internal, external. These are wonderful rates. Oh, before I forget, an honorable mention for stormwater bonds, and you see that's why it's italicized, asterisks, and bolded. It wasn't an upgrade, but when we did our last issue towards the end of last year, we decided to get an additional credit rating. Our initial one was simply Moody's, and we're glad we did because S&P over on the far right gave us a rating higher than the one we already had. Again, a very, very strong credit that benefits us in the market. And what's all this lead to? Well, if I can direct your attention back to the top in the issuer credit rating. You've heard us talk about this before. Basically, this is our version of the FICO score, and it is very, very good. Again, cross all the way to the right, S&P, AAA, the highest you can get. Moody's and Fitch are the second highest that you can attain. Our overall credit worthiness as a city is stellar. And the result of all that, you see here, when we're comparing ourselves to peer cities. You see that Tampa is tied for number 2 with our friends up the road in Orlando. Very, very strong ratings across the board. You see Arlington and Minneapolis tied for number 1. I often liken this to the Olympics. These are all very, very good ratings, but very, very thin margins if you want that gold, if you want that silver, if you want that bronze, and you see where we are now. Very, very rare air. And of course, that's to our benefit. Some of what the rating agencies have said over to the right: strong governance, very strong budget flexibility, proactive risk management. We're very proactive here, both in financial management and risk management. And again, as we've heard many, many times, ample budget reserves or fund balance. And again, my thanks and my compliments to City Council for continuing to prioritize our fund balance. I won't go through each of these slides. Again, these are accolades that the rating agencies have given us very recently. This is from October 24th. Standard & Poor's, again, the best you can get for our FICO score and our non-ad valorem revenue bonds. Robust economy, broad and diverse metropolitan statistical area. It has been hard work, I won't lie, but we do have many advantages, as you know, from just being in the Tampa Bay region. So many more than so many other localities in the state and in the country. Manageable debt burden, well-funded pension plans. We have fantastically funded pension plans, the fire and police pension and the general employees pension. Always paying what we are calculating is due. No pension holidays, things like that. Not everybody does that. Here's Fitch, financial resilience, ample reserves, again, control over expenditures. Moody's rating, strong financial position, prudent management, large economic base, again, and a varied economic base. And I certainly won't read through this, but again, that the water and water credit rating, it does warrant its own slide, and you see the wonderful things they've said about the water and wastewater rating. Again, the highest you can get for each rating agency. We're going to pan out now and cast a very, very wide net to our total city financing. Just a little bit of a guide first, and that's why we put this slide in here. It resembles somewhat, I think, how the public and council are used to seeing our finances. Basically, general fund, enterprise fund. They're called a few different things in the financing and debt world, and they're made up of a few different things, but they generally fall into that category. You see governmental debt, non-ad valorem. What's that mean? Non-property tax, right? Mostly general fund revenues. Again, no ad valorem taxes, some utility services taxes, but also community investment taxes. The CIT is becoming more and more of a discussion point as it sunsets and as talk surfaces about getting it on the November referendum this year. and stormwater assessments. Again, the stormwater issuance we did last year, late last year. And of course, the enterprise debt, no surprise there, water and sewer, and anticipating solid waste debt later this year. And here you see these components compared to each other and their dollar amounts. Enterprise, this is just principal, not interest. We'll get to interest. Enterprise, a little over $730 million. The non-ad valorem, a little under $385 million. And then you see the CIT and stormwater components. We are not going to talk extensively about CIT or stormwater because, again, CIT sunsets. Regardless of what happens with the continuation, this CIT component, this 30-year component, is going away. Stormwater, we have issued all the debt we anticipate issuing for stormwater, so we don't anticipate any future debt for the stormwater program. So we'll primarily be concentrating on that blue piece of the pie and the orange piece of the pie. Go Gators. I did not go to the University of Florida. But, so the non-ad valorem and the enterprise are where we'll get to. So our bonding capacity. You see these total about $3.1 billion in capacity, and again, divided by governmental and enterprise. You also see an array of caveats associated with these figures. I've got approximately in there twice, and then you see the estimates are based on assumptions which are subject and expected to change. You just heard Mr. Ford talk about the vagaries and the ups and downs, if you will, of the municipal market, and there's so many other ups and downs. Here are some of the variables. Ratings, of course. If our ratings go down, we are likely not to have this much bonding capacity. If they go up, perhaps we get more bonding capacity. You heard Mr. Ford talk about interest rates. The same thing there. Market availability. If we decided tomorrow we wanted to issue $1 billion worth of governmental debt, that's great. Does the market want $1 billion of our governmental debt? If we've got to sell it, somebody's got to buy it, and that market availability will play into what our capacity is. If we pay off existing debt, we are constantly paying off existing debt, that may raise our capacity, and then you've got does not include all factors, because there are so many factors affecting this. This is a point in time. It's very, very positive, as I'll show you, but it's nothing to write in stone. So if you put these together, $3.1 billion in capacity, well, how much could we borrow? Well, here is a continuation of that information and what we currently have obligated ourselves to now. You see, starting on the left there, category governmental, our bonding capacity that we just talked about, $1.3 billion. And then you see below that our governmental bonds outstanding, a little over $500 million. It's a good time to mention the current proportion. They're both 41%. That's entirely coincidental. That's not a plan. That's just how it shook out when we did the calculations. So of the 1.3 capacity, we have bonded less than half of that. Okay, and you see the current bonding potential to the far right, a little over $765 million. And the same carries through for the enterprise component. There's that bonding capacity that we referenced in the previous slide, $1.8 billion. We have a little over $730 million in principal outstanding. Again, 41%. We have bonded less than half of our capacity. Another caveat I'll throw out there, when we talk about capacity, and this is an important distinction, it's not necessarily what the city can afford, okay? Because really what the city can afford in debt is up to the mayor and city council, based on priorities, based on timing, based on new revenues, potential new revenues, things like that. So we've got our capacity, and then when the rubber meets the road, what can we afford? That's really up to the mayor and city council. And carrying that discussion forward into this slide, I'm sorry, sir, did you? I apologize. Did you have a question?
He wants to ask you a question now. Councilman?
It seems to be applicable to, I'm sorry to interrupt you, but.
No, not at all.
I'm not clear, when you talk about the capacity, and I get what you just said, reference what we can afford versus capacity. Can you give a little bit more clarity what you mean when you say capacity, as you're defining these numbers?
Yes, given all those variables, and of course, the financial advisors are here to talk about even more detail if you like, but given all those variables, we've got this much room.
Now, are you saying that capacity is what, if we wanted to sell, that's what we could sell?
Yes.
Okay,
Yes.
so it's sellable debt.
We could bond more, yes.
Yes,
And I'm sorry
sellable
if I didn't
debt.
make that clear.
Okay, yeah, I assume that's what it was. One last question, the CTI, that CIT, that 37 million, is that, will that 37 million will be paid off by the time this
Yes, it sunsets.
CIT sunsets? Okay, very good, thank you.
Councilman Moran.
Thank you, but,
Yes, sir.
and I appreciate what you're saying and try to understand everything because I'm not an expert on finance. However, everything is based on today's standard of living. Yet we are involved, the citizens of the United States of America, owe over $1 trillion. That's not me saying it, that's what the facts are. When you look at the bonding capacity, again, I'm going on saying it again, it's based on today's climate of finance. But when you go back just a few years, in our earlier second term, there was no money. Everything went south. There was no raises for about 5 or 6 years, and it extended into Buckhorn's first couple of years. So what I'm saying is, when you talk about bonding and lending and borrowing, it's the same thing, based on the climate of the country at that point in time in history. As you well know, you said it, that we were looking at something much greater to happen on the negative side in this country, and it didn't materialize because I think that the feds and those that know a lot much more than I do raise the interest rates every so often. So what? You stop spending. But what we're doing again is the country spending more than what we earn. So this country's in debt over $35 trillion. And I don't want to tell you what the interest is on that. So I don't want to get to that point. And when we talk about the CIT and later on, I'll make some suggestions that I believe are beneficial to the welfare of every citizen of the city of Tampa. But that just, I want to bring it up that this is a point in time of today. Next week, it may be something else.
It's true.
No. So I'll go to you next. So I'm looking at this like a FICO score. You mentioned FICO score, which it's not based like on personal credit, but we're at 41% capacity of credit to available, debt to available credit, right? You went to this chart here. Thank you for bringing it up. You read my mind. We have, the AAA ratings in many categories, AA plus. For example, I'm very careful with my credit. I have a bunch of available credit, but I don't carry credit card debt. I pay everything on time, and I have a FICO score of 800 and something, which I do. And I'm very proud of that, because I'm responsible. If I wanted to, I could go and say, bond everything, or no, max out the credit cards. Now, in this case, the more we bond and the more we fill that debt to available credit ratio, these numbers will drop. We will get to higher interest rates, and it affects our borrowing power, spending power, what taxpayers are paying and whatnot. The questions that I have, and this is going to roll into the fire discussion after, is bonding is expensive. But sometimes you have to do it, and we bonded a lot on large projects, HANA and whatnot, that's fine. What do we have available in CIT spending that hasn't been tapped into before it sunsets? I know there's discussion of maybe, it getting renewed, and I hope it does. Do we have any available CIT money?
It's obligated, sir.
It's obligated. So anything that we do moving forward has to be bonded out.
It does. Now, I will say this, the budget is a plan.
Yeah.
The capital improvement plan is a plan. We have obligations for what we anticipate will be the remaining community investment tax funding. We could change those obligations.
Okay, now, if we bond $100 million in something, we're paying back essentially $200 million, give or take, right? If we're able to, can we take out a short-term loan? Does the city as a municipality have the ability, we have the collateral, I don't know how the government is looked at in terms of, if I take a personal loan or want a credit line or something, can we take out a loan for $50 million, $100 million at X amount, percentage, whatever, we have the high rating, so we're gonna get the most competitive or the more competitive rates. I'm all over the place, but let's say the CIT, you say it's obligated, but that's a plan. The CIT gets renewed at the ballot this year, and we know, hey, we have another 30 years in the future, and we want to go and take a loan out, a short-term loan, to, build fire stations. Could we get a better rate and save the taxpayers money, knowing that we would be using the anticipated future, I'm saying if the CIT gets renewed, to pay back those loans at a quicker rate, and therefore saving money instead of going into it like a 30-year bond or something like that? Does it make sense? Am I rambling?
Oh, no, you're not rambling to my ears, sir. No, I appreciate you asking these questions, and if I could back up and answer some of the questions and then defer to the financial advisors. The scenario you described is actually what we anticipate we're going to do should council approve to go forward on fire station and fire facility financing. We will do a short-term issuance, a line of credit, a bank note, et cetera, because we're not going to need all that, and as you'll see on item number 4, $115 million all at once.
Okay.
We're going to need it over time, and we don't want to indebt ourselves before we're ready to spend the money. So that's actually how in real life it's going to happen. We're going to do short-term issuances. The tipping point comes, will it be more advantageous to us, and will we save money by paying off that short-term loan in its entirety based on how much money we want to appropriate and the interest rates, et cetera, or will it be more advantageous for us to roll that short-term debt and what will probably be a few short-term debts over the years into one long 30-year bond, given again, market, our ratings on the particular bond issue, market availability, the interest rates, et cetera, et cetera. So that's a long way of saying we intend, should council approve it, to issue short-term debt.
Now, when we do this kind of
Yes, sir.
debt issuance, or we bond something, are we locked in at that interest rate, or does it fluctuate? Is it like an adjustable rate mortgage compared to a fixed rate? How does it work? Because we're talking huge number. This is not a $500,000 house.
Yeah, I don't anticipate we'll do an adjustable rate, but we have some advantages, and again, the financial advisors can expound on it, especially if we issue short-term debt. Then when we roll it into a long-term issuance, if we decide that's advantageous, we have an ability to do that for potentially a lower interest rate.
Okay, and then the last point, I know that it's been done in the past, but where it's like interest-only payments or no interest, no payments for 30 years. We will completely avoid those scenarios, correct?
As
long
as I'm standing right here.
That's happened,
Yes.
in the 90s here, and we got, we got hit with a big lump sum. So, okay, that answers my questions. Councilman Vera, so
Thank you, sir. Appreciate you. And a couple of questions, and I want to make sure I have a lot of points to make on the next item as it applies to this issue. So I'll make sure to have that separation and everything. I did want to point out with regards to my friend Councilman Miranda talked about our national debt, which is about $34 trillion. What the federal government does is an abomination. It is. If you look at the annual deficit today of what they spend that they don't have, it exceeds the amount of more than exceeds the amount of the 1993 entire budget. Just blows your mind what the tools that Washington has with interest on the debt, which I think is about $800 billion a year, give or take, something of that nature. This is something that's clearly distinct from what the folks in Washington do. I think this is good to see for the public, right? We've had some, and when I refer to bonding, I mean the spending process of government on big projects, which involves, as Councilman Maniscalco made reference to in a question that I was spoken to also on the same subject this morning, And as you said, Mr. Rajero, it's short-term debt, there's payments, there's bonding on some parts of it. It's a very complicated process, right, that can't be simplified. But I want to make sure on a couple of points for the sake of the public, because again, we've bonded, done that financial process, I hate to use the word bond, whatever, on a lot of things. $100 million for Hannah, $45 million for a park. The park, I think, is going to be a wonderful asset. Nothing bad on the park, but now we're getting into the weeds, which is good. It's a good discussion because I think it actually supports the spending that we're looking at doing. But in our discussions and with these slides that you're showing, is it not true that the debt, that the ratio between the City of Tampa's debt and our City of Tampa budget is at its second lowest level in a quarter century?
Yes, sir, and this was the, if it comes back up, this is the slide that perfectly illustrates that. For nearly a quarter century, as you said, you know, the amount of total, and again, this is just principal, not interest, the amount of principal compared to our total budget has, I would say, gone down dramatically.
Sure. And I'm going to ask when the fire comes up for applications of these principles to the fire issue, because I don't want to mix the two issues, right? But from what I'm seeing, correct me if I'm wrong, number one, we're not at any sort of historic debt level as a percentage of our budget. We're not, is that correct?
Correct, yes, sir.
Thank you, sir. We're not in any way at risk of harming our stellar, amazing credit rating. Is that correct?
Not at this time.
Okay. Yeah, and I wrote down some questions that I think are best left for the second fire issue. But yeah, just wanted to make those points, and thank you, sir.
And I didn't mean to conflate the issues, but item number 44 is a perfect example of what the chair was describing.
Councilmember Hurtak, Councilmember Clendenin, Councilmember Miranda.
I was going to save my questions, but since people are digging in. Going back to this slide, 67.9%, it's really impressive how we brought that down. But obviously we had a problem in 2000. And then, you know, the recession made it worse, but we were able to pay that off. As someone who really looks at my own personal budget and what we borrow versus what we use, what's a percentage of principal to budget that we should stay within the confines of? Because I think we could all agree on this, at least on this dais, that 211% is just way too much. But what will keep us with the ratings we want and just safety space in case we do hit another recession? And I think that's kind of the crux of this entire thing is, for me, is this percentage. Where should we stay?
No, it's understood. That's a great question. I cannot answer that. I don't know if some of our finance professionals can answer that. Now, I will say this. While they mull this over and decide who's going to draw the short straw, I wasn't here in 2000. I don't know. I don't want to go on record saying that was an unmanageable amount of debt, but it certainly appears a lot compared to to where we've gone. And maybe this will play into their answer. I would also say less than the entire budget is a good level of debt, especially when you look at the past. But that's going to take more expertise than I, and we'll see. Anybody want to get up and feel that, or
just a range?
And if I may, I don't want to put anybody unnecessarily on the spot. Can we come back and provide an answer to that question in terms of what is viewed as the, for lack of a better word, ideal debt ratio?
Well, again, it doesn't have to be ideal, but like where we sit in comfort, because I believe that has a lot to do with with the next item.
I understood. Yes.
So again, I'm not looking for oh my God, we can't go over 100, but by and large, in order to keep our ratings and in order to keep a sound financial house, in their y'all's professional opinion, like, do we just make sure we're below 120%? What's a decent benchmark? Again, as we look forward, I think part of this is making sure that we're doing the right thing without hamstringing future councils and administrations to this debt, which it seems like in 2000 probably did hamstring them a bit.
It was quite a bit.
I remember it well.
If it's easier, we can go through and address this when we discuss each of the credits individually, because each of the credits will have.
Wait, come on.
Yeah, sorry, you have to speak into the mic.
If it's okay with council, we'd like to address this when we discuss each credit in more detail, because
Okay.
each credit will have a different aspect as far as what's gonna drive the particulars over what.
Thanks.
What works.
Okay.
Councilmember Clendenin, Miranda?
Thank you.
No?
Oh, yeah, I mean, you were actually right on where I was going initially, but I have a couple more things on that topic. So I think one thing we haven't talked about is the cost of incurring debt. The one-time charge, there's a lot of fingers in those pockets. So the cost, let's say the average, we issue $1 million in debt. What is that overhead cost for a short-term issuance of $1 million and a long-term issuance of $1 million? What's like the one-time hit we take to be able to pay the piper, pay all the Wall Street people, pay all the people that got their fingers in the pockets?
Understood. 1 million short-term versus long-term.
Yes.
Is that your question?
Right.
I'm
Ms.
Molly Clark with Public
Okay.
Resources Advisory Group. And really it depends, again, as Will said, we'll speak to each credit on a credit by credit basis. So your question depends on the market conditions generally at the time you're issuing the debt, and it depends on the credit you're issuing the debt for. So there's not really, in fact, right now, a one-year rate, Jerry mentioned during his opening remarks, the yield curve is inverted, which means a one-year rate, we're actually at a higher rate in 1 year than we are out, I think, as far as 7 to 8 years at this point. So right now, if you did short-term debt a year, you may pay a higher rate of interest, the rate.
Not the interest, the overhead cost, like the cost is baked in to issue that debt, the overhead. So there's costs that we roll in, the closing costs, for lack of a better word. I don't know what the.
If you're looking at again, it depends on the different fees. A bank facility may at sometimes be less cost to the city than a long-term bond issue. In a bank deal, you don't have a disclosure document and you're not getting ratings for that particular financing. And so you're saving the cost of not having to publish a disclosure document, not having to pay the rating agencies. But at the same time, if a short-term financing doesn't really work for that project, you don't want to save money in the wrong way. And again, I realize I'm being fairly ambiguous and not giving you numbers right now, but like that slide earlier in the presentation, with our bullets, with the number of different caveats when we discussed bonding capacity generally, there are so many different caveats at any point in time, market conditions, credit-wise, and that's why we look at each financing in a very detailed process on a case-by-case basis every single time.
So right now, the city wants to sell a $100 million bond. What would we be paying in fees for that $100 million bond sale?
Just to clarify, if I may, fees not, I too thought you meant interest, but fees, not interest.
Fees, right?
Okay.
Fees to your professionals. Why don't we say $4 a bond, so $400,000 on a $100 million deal.
So just
and that's your legal counsel, that's your financial advisor.
Wall Street, that's paying.
That's the rating agencies. Your underwriter's fee is different. So that's maybe, underwriter's fees have come down quite a bit. We'll call that $3 a bond, $350 maybe. So all in, maybe you're at $700,000 to $750,000. These are back of the envelope numbers. But we look at it on a cost per bond. We'll look at the value of a basis point and what you're paying these professionals.
So you're saying it's less than 1%?
Yes. Yeah.
Overhead, yes. I don't know why anecdotally I was always told that these overheads were like in the 4 and 5% range.
No, and financing costs have come down quite a bit in the past couple of decades. So, but under 1% is absolutely fair to say. On a general standard credit, if you're issuing something complicated and unusual that's hard to sell, the underwriter's discount might be higher. The cost of your legal counsel may be higher if the documentation is involved and brand new. But for the vast majority of anything I can think of that the city has.
So well-established city, good credit ratings,
absolutely,
less than 1%.
Yeah.
So, and I just want to make sure that when we talk about this debt issuance, you know, we say we have what, 1, 2, 3, a little over $3 billion in capacity, but, right, is that something like that? Is that what I remember off the top of my head? So, but if that actually really only if you're talking about status quo today, but if you start selling that debt, that it starts to invert. So it really isn't there, because all of a sudden we'd get to junk bond status if we were selling $3 billion in debt.
You start to sort of eat away at your own credit worthiness.
Right. So our capacity, the more debt we sell, our capacity. So really, there's some kind of weird curve.
There's a tipping point.
Yeah.
And I think that's where Councilwoman Hurtak was going.
Yeah.
And if I could just expand a little, I too, now this is, again, it's a word I'm looking for, is when I run into discussions, whether it's, thank you very much, thank you. When I run into discussions, you know, whether it's out in the community, homeowner associations, things like that, I have also heard that rule of thumb of 4 or 5%. Right. But what I think it is, I think it's conflating our interest cost. Right. And then over time, as the discussion continues, this is just conjecture on my part, but I think they get merged, like the fee for the professionals gets conflated with our interest costs associated with it. Because I've heard the same thing, and you hear it's not nearly.
So that 1% we're talking about, just again, not to hold you to a 1% figure, let's say that 1%, does that get rolled in and we're paying interest on that as well, or is that a fee that we pay right up front?
Yeah, we'll roll all of that,
so it gets rolled
typically roll all that. And if I could just expand or clarify what Ms. Clark was saying, when she, and if...
By the way, this is a great college level class in bonding, so thank you.
Great. Well, no, I appreciate, as always, I appreciate y'all, your attention and your input and your questions. If you look at this slide I've got up, if I could reference that, can you all see it? Mm-hmm. You know, one of the caveats is, and you heard, I think, both Mr. Reed and Ms. Clark say is, well, it depends on the credit, because you know you see that orange there, that's enterprise, okay? That's water and wastewater, and the water and wastewater credit with the best you can get across the board by all three of the guerrilla rating agencies, that's going to be a little bit different than the non-ad valorem or their governmental debt, whose ratings across the board are not that high, for instance. And again, market availability. Who wants to buy water and sewer bonds when the rate structure is locked in for the next umpty-ump years? Versus a non-ad valorem, well, we're pledging that we'll pay this, but we're not tying it to a property tax, the non-ad valorem. So I'm probably just reiterating unnecessarily what you heard, but that's what it means, you know, when it depends on the credit and of course the time, et cetera, et cetera. This is an interesting illustration, we thought, because it does show our reduction in debt over time. But further to both your points, and as Ms. Clark said, there is a tipping point where you're cannibalizing your own credit worthiness.
Mm-hmm. Okay, thank you so much. I appreciate
yes, you're very welcome.
Just very quickly on what you just mentioned on governmental and enterprise funds. Mm-hmm. On your page 23, and I'm not going to belabor the point too much more, the principal for the total governmental and enterprise is $1.267 billion. Mm-hmm.
I'm sorry. I'm sorry. For governmental, the principal is, and I don't mean to correct you, the principal for governmental is 500.
No, I'm saying the total combined.
Oh, I apologize.
I went all the way across.
Okay,
the
for
total
both.
of the sums of governmental and enterprise
I apologize.
is 1.267 billion. Mm-hmm. The interest is 9.21 million. That's about 40% or so, whatever it is, 40% or whatever. If we had any other ways of doing things, and I always try to think out of the box instead of getting in debt more and more. And I think that can be achieved when we discuss the CIT and different things later on. To start using something where you pay less interest by not borrowing money and using the money that you have coming in to buy. By getting smarter and doing things a little righter than we do now. I'm not saying we're wrong, but when you bond, and you're way below the standard where you can continue bonding. But what happens when we're not here and you're not here? And who knows what's going to happen? Things get tight, you want to borrow, you keep borrowing. Just like the feds do. But you got to pay it, or you're not going to have anything to do with. And that's what I'm bothered by. In fact, I said to other agencies that borrow money, and I don't vote for the bonds either. So I can just tell you that it's just a way of doing things. No matter, you say I'm gonna solve the problem with the public by solving a problem, but what the public doesn't understand, realistically, you're not told, is they're gonna pay for it anyway, whether you raise something to pay for it, or they're paying an interest. One way or the other, somebody's gotta pay it. Either you pay it direct, and we're doing that now with the PIPES program.
Yes,
That is a work in progress that we save the taxpayers a lot of money. Because we're doing 54% cash, if I remember, and 46% bonded out. And if they'd have listened to somebody 20 years ago, it would have been paid in full with no interest. But that's how you gotta think sometimes. And so I'm gonna stay quiet now and listen for a while.
All right. Councilman Beer.
Thank you, and I do want to jump on Councilman Hurtak's question, and I'm going to pierce that veil to the next item really fast without mentioning it. Councilman Clendenin, I think, talked about the $100 million that is all explained. That's been significantly reduced in terms of a plan that we have going forward by 60% to address some concerns. But for purposes of this question, take away fire, whatever. My question to you is, if we did another $100 million in bonding, which will never happen, there's a bunch of other things that are going to intervene, et cetera, would we still be in a healthy debt to budget ratio position?
It would depend, and again, I'll give my answer, and if you want more detail, again, we've got people who live and breathe this stuff. It depends on the credit, and of course, that's one of the reasons we go out and get a credit rating. You know, in most instances, all 3 ratings. We want to borrow this. What do you say? And again, you know, as you've heard me say before, all 3 credit agencies, they don't just set it and forget it. They keep up. What are we doing? They call it surveillance. They're serious about it. How is the city of Tampa doing generally? How is the city of Tampa doing and anticipated to do with this particular credit? So it's not as easy of an answer as this will hurt our credit. It is, what are the circumstances, how much are we asking to borrow, and what the credit rating agencies think. Again, there is a tipping point somewhere.
Sure.
I don't know that we'll be able to laser focus on it, but I think what many of us are trying to establish is, when is that too far? My words, when is that too far?
And again, that's a question, when we get to the fire issue, I'm going to ask you that question as it applies to the funds that we're potentially looking at forwarding, right? And we discussed that yesterday, because again, that has been significantly reduced. I'll discuss it at the next item, because I don't want to belabor the point.
Councilmember Carlson.
Yeah, I know we're only halfway through the presentation, so I look forward to you finishing it. This is a motion I made a while back, and I was working with Mr. Rajero, and I just want to say how much I appreciate you all putting all this detail in and the transparency. These are, I know it's late, but these are exactly the kinds of conversations we need to have, and I think we all like this. We're all geeking out on it. So I want to thank you and your team for doing that. Could you go back to number 22, please? Just to point out for everybody, especially the public, the purple line is the revenue budget or the income budget, and so where it's in green, where it says the percentage of principal to budget. One of the reasons why the percentage goes down is because the revenue has skyrocketed in the last few years, and we know why that's happened. But look at the end, 22 and 23, the debt has skyrocketed too, and so I just want to point that out. Now, second. In the green line, it starts in 2000. I think Pam Mauro took over like 2002, 2003. So a chunk of it was under Greco, and I think you all are going to show what might have happened to lead to that. But I think the most significant part of it was under Pam Mauro, which is a miracle because it was during the Great Recession. Great Recession ended in 2009. Even with this, she left $150 million in the general fund reserve. It continued to go down, but I think the ad valorem tax increase was, what, 2015?
15 or 16, sir.
So.
Whew, time flies.
So that impact, that and other stormwater and other things affected the percentages at that point. And you see what happened around 2013, the revenue starts to go up because of fees and eventually taxes and other things. One of the things, and I would love to have a long discussion about all these, but I'm just going to throw out some ideas real fast. One of the things I think we need to manage too is 2027. I'm termed out in 2027, so whatever impact I'm going to have here is going to end in 2027. Maybe the decisions will last 30 years, but this mayor leaves, this council as it sits right now will be gone. We need to understand what it looks like at least through the time that we hand off to whoever's in the future. And I think we have an obligation not to hand massive debt and massive fees going forward. Yeah, Charlie will be the only one. Another thing that I talked to you offline about, another factor in all this that we haven't talked about, and we can talk about this later, is cash flow. Yeah. And to the argument that Chair Maniscalco talked about, if you're comparing it to a mortgage, you might be able to borrow $1 million, but can you afford to pay it? And you have to include all the other things in there. So anything that we borrow now, including interest, is going to prevent us for the next few years and in future councils and mayors from spending their ongoing cash flow. And so we have to really think about that cash flow. To Councilmember Vieira's point, I'm okay bonding for fire because that's about saving people's lives. And we'll talk about that in a minute. My only concern about that is I want to make sure that whatever we're bonding, where the money is spent, where we can say it's going to be spent. But I want to make something clear, and I'll say this again maybe at the end. I'm not in favor of any new bonding over the next 3 years. We should not be bonding anymore. There are things that we bonded that in hindsight I would have voted against, but we can't keep bonding. What this shows is we might be able to add a few $100 million more, but the cash flow and other burden that we're going to put on the future is really horrible. We know that when CIT was passed, and if the same people ran Alford Transportation, it's not going to pass. Obviously, but as soon as CIT was passed 30 years ago, most of it was bonded out into the future, and future county commissions and city councils didn't have a chance to spend it the way the ones did when it was first there. So we have to be careful not to make decisions really far out in the future on this, and I think we need to be really careful. And other than fire, I'm going to most likely vote against every bond proposal going forward. I just want to throw that out there. And then I think we ought to let you finish your presentation.
Thank you. Thank you, sir.
Absolutely. Thank you. And I don't know how much further you have in your presentation, but can I say one last thing? I promise I'll be the last thing. And it's back to Charlie's point that there's the principal bond that we have out right now is 1.267, and the interest is 920. So 1,267,000,000, and the interest is $921 million. I mean, if you look at again, it's like 2/3 of the money going out is interest, and not to the principal. But it's still money. I mean, it's still money that's going out. I mean, even if you look at the government expenses, it's 533 to 190. I mean, it's almost what, 40% or something like that. I just want I'm kind of like where Councilman Carlson is. Pay as you go is I mean, clearly, just like in our own personal lives, you buy what you can afford to buy. You pay but there are certain things, houses, big expenses that we finance because that's it's cars, houses. Some of us buy RVs, but you pay as you go, and this is why I think we really have to I think people have to remember this slide next year when we talk about our budget and we talk about millage, of what is actually costing the people of Tampa. So every dollar that flows out of somebody's wallet, whether if we're borrowing the money to pay for it, or we're having a millage increase to pay for it, what's the true cost to the people that live in the city of Tampa? And I think this slide is very valuable when we consider that. And thank you, Mr. Continue with your presentation.
You're very welcome. You're very welcome. and this may be, I don't think anybody's got that, this impression, but I want to make sure, I want to clarify. You know, these are some of the finest debt financing professionals in the U.S. I have an absolutely fantastic internal team. But I do want to clarify that we're not advocating that you issue debt, and we're certainly not advocating that you issue debt just to issue debt. I think Councilman Vieira said it earlier, he used the word tool, and debt financing is a tool. It reminds me of that old saying, if the only tool you have is a hammer, then all the problems look like a nail, right? This is not the only tool we have, you know, as council knows, but it's worth reiterating that to the public. We have PAYGO, cash. PIPES program is a great example of both. You know, about 50-50 cash debt. We have grants, other people's money. We can defer projects and save up the money. But I will say this, and this is why it is a valuable tool. If you're, you know, what, the 50th-ish largest city in the U.S., you know, and we are, and we want to do big things, we want to invest a lot in the community, and it appears we do, and we want to do those big things fast or faster than saving up money. And if we want people using those things to pay for it now, and we want people using those things to pay for it later, that intergenerational equity that we've talked about, then debt can be a very, very valuable tool. It all depends on what the mayor and city council want to do, when they want to do it, and who they want to pay for it. But again, I just want to make sure this is their profession, and they're very good at it, but we're not advocating that you issue any debt. We just want, again, make sure everybody's got all the information. So thank you. And well, here is the slide we've been talking about. Where are we right now? We are, and I won't belabor it since we have talked about it, but again, you see the principal and interest for both components, the governmental and the enterprise, for a total right now obligation of under $2.2 billion. I will also say, again, this is a point in time. We have had the opportunity to refinance in the past, and we have taken advantage of those opportunities, again, based on the very, very good advice of the professionals behind me. And of course, we will always, there are calculations to say, is it worth it, is it worth it? But so the interest figure could change, and that's why we take advantage of refinancings. And here you see, here you see that $2.2 billion by fiscal year. You see our annual debt service payment. Now this is principal and interest. This is the whole kit and caboodle. About $100 million this year, split up between, you see, the governmental and enterprise. And you see it tapering off. Again, no balloon payments, no surprises, things like that. Whoops. And again, this is explaining the same information. This is in its entirety, and this, you see how it transitioned through 2057. Again, that outward-facing look of what our obligations are. And now that you've seen the big picture, as you heard Mr. Reed and Ms. Clark say, we're going to start getting more detailed in terms of the non-ad valorem debt and the enterprise debt, including the existing wastewater debt, the anticipated future water wastewater debt, and the anticipated solid waste debt. So again, there's more to come. We've got a very long runway in terms of what we think council wants in the future. So having said that, ma'am, and you know how to just advance this.
Okay.
The rightmost button.
Great, thank you.
Thank you.
Okay. Again, Molly Clark with Bragg, and I will go ahead and speak to the city's non-ad valorem revenue-backed financings. We worked with the city on this credit, and as Dennis showed in this slide earlier, the current outstanding principal backed by non-ad valorem revenues is approximately $385 million, making up about 30% of the city's total debt portfolio. Here now, as Dennis showed in aggregate for the governmental and enterprise debt on the previous slide, this slide shows annual debt service payments from fiscal year '24 through fiscal year 2051 on all of the governmental debt, on all of the non-ad valorem revenue-backed debt. So as you can see, the debt service is what we call front-end loaded. From years fiscal year '24 through fiscal 2029, your annual payments on the governmental debt are up around $38 million a year. After fiscal year 2029, it drops off significantly, and from 30 through 51, you're paying about $11 million per year. So we see a substantial drop off after year 2029. Moving forward, this is just principal. This excludes interest. And so as you can see in this slide, in fiscal 2023, we're at this total of approximately $385 million, which we pay off over time, with the final year of the currently outstanding debt being in fiscal 2051. Now, the city at this point in time has identified approximately $287 million in new proposed debt projects under the non-ad valorem credit. And this, what we would envision structuring this debt with level debt service after that drop-off has occurred. So moving from 2031 through all the way out to 2060, we would issue new 30-year debt structured with level debt service annually to sort of fill in that space from 2030 forward with new level debt service for these projects. Now, I'll go into a little more detail about what those projects are in a couple of slides from now, but this slide here presents our currently outstanding debt in blue, the annual debt service payments on the current outstanding debt, with the new debt built on top of it. So we're showing what our current plus proposed future debt would look like. The current debt, as you recall, goes out to 2051. The new debt, if we're talking issuing this debt in 2030, we can go out all the way to 2060. So we're sort of layering the new debt on top of the existing where there is capacity. You have capacity under your non-ad valorem revenues to pay the current debt at $38 million. So even layering in some additional debt starting in 2030, we still have substantial capacity based on current legally available non-ad valorem revenues. This slide sort of takes a look at what we're looking at from amended fiscal year 23 through fiscal year 27 is how are we allocating this proposed new $287 million each year, and we'll talk project-wise what's happening year by year. This sheet looks at the amended fiscal year 2023 budget and breaks down, I'll slide back to the prior, you can see in the fiscal year 2023 amended column, we're at 77.9. This following slide details what projects are making up that 77.9 million. You can see the larger line items under the project budget column are the Hannah Avenue relocation. Construction there is near completion. The East Tampa Recreational Complex and Public Safety Training Facilities. Those are sort of the three largest line items. East Tampa and the Public Safety Training Facilities are in the design phase, but again, those are three of the larger line items making up the amended fiscal year 23 project budgets. This slide goes into what we're looking at for fiscal years 24 through 28. Largely, fiscal year 2024 is housing. Fiscal years 25 through 2027 is largely made up of fire department needs. And again, referring back to the previous slide of our 2023 needs are the recreation complex and public safety. So again, this CIP proposed to be, the debt issuance is proposed within this CIP are largely critical public needs. These are needs that are appropriately financed with long-term bonds. This slide presents grants that have been awarded and grants that are pending. The Tampa Multimodal Network and Safety Improvements, that grant has been awarded and accepted by the city. The Safe Streets, Reconnecting Communities, and the Palmetto Brick, those are pending. The city has not yet received the grant agreements. So the numbers here may may change, they're not yet final, but basically this is making the point that to the extent these grants have a required match by city funding, there is certain debt proposed to be issued to match some of those grant funding needs. There's 4 categories of grants here totaling $52.3 million. The required match preliminarily is 34.4 million, some of which, approximately 7.2 million, would be matched using PAYGO funds. The balance, approximately 27.2, will be debt financed. So here, that wraps up the comments on the governmental funds / non-ad valorem revenue-backed proposed debt issuances. I'm happy to take any questions you have now, or I can also pass it off to Will to discuss the water and wastewater.
We'll go, I have to leave at 5:45, and I really want to vote on 44, but go ahead, sir.
All right, so I'm passing it off to Will.
Thank you very much.
All right. All right.
Thank you.
Okay, go ahead, sir.
Dennis O'Hara, Chief Financial Officer. Again, we have more of the presentation, but I want what you want. If it's tight and you need to vote on number 44, then we can certainly come back to a presentation.
Yeah, and I know, I mean, we do want to, at least I want to vote on the next one. And if you share that sentiment, just. Can you just go through it quickly? That's what I was going to suggest.
Council's pleasure. Council's pleasure.
Yeah, go ahead, sir.
Thank you. Will Reed with Ford & Associates, and I'll try to go through this as quickly as I can. Going through, as you can see here, the water and wastewater system makes up the vast majority of the enterprise, or virtually all of the enterprise debt that you have outstanding currently. That is your single largest source of debt that you have out there. That has not always been the case. As I said, that's used solely for the water and wastewater system. I'd like to talk a little bit first about how we got to where we are with that being the largest source of debt. In the 2010s, the city went through and first reviewed the existing water and wastewater infrastructure that underlaid the city and the system as a whole. Then went through and looked at those projects that were absolutely essential to go through and modernize that system and go through and work to reduce things like water infiltration and other problems that we were seeing throughout the city, because realistically those pipes had been in the ground for an awful long time. Once the evaluation was done on the existing system and the needs, then we went through and looked at the rate system that was in place to go through and say, what is the minimum that we would need to go through and look to increase rates to accomplish those projects that are absolutely essential to modernize the water and wastewater system throughout the city. The end result of that process is the pipe system that we go through and see today. That is made up of a blend of pay-as-you-go projects and debt financing, with a heavy emphasis there being on the pay-as-you-go. At the conclusion of the rate increases, I do want to go through and point out that the city's rates are still going to be significantly below those rates of any of your peers, not just in those contiguous counties, but anywhere throughout the state and country broadly. Going through, I do want to go through and make sure I highlight the ratings again, because that is something that we are incredibly proud of. I particularly want to go through and highlight that that upgrade came after you went through and dedicated the city to going through and moving forward with a multi-billion-dollar capital improvement program. And that was a piece that was evaluated and viewed very positively by the rating agencies. I'd also like to go through and highlight that when you went through and got that rating increase, 3 years later, you saw the federal government go through and get downgraded. So at that point, when you got upgraded to the AAA status, you saw Fitch go through and knock the U.S. government down to a AA+. And personally, I really love the fact that your offering documents now have to have a paragraph in there that explains to investors why you as a city can have a higher credit rating than the sovereign that goes through and controls the country. We've currently gone through and issued two issues. The 2020 A's, there was also a B's that was a refunding, and then a series 2022 A and B, one of which was issued as green bonds, one of which was not. Those are the first two planned issuances of a multi-year series. I do want to go through and highlight that this, when we were originally looking at this program, it was planned to be an annual debt issue. In 2021, looking at where the rates were in 2020, those projects were accelerated into the 2020 issue because where rates were at that point was advantageous, and it worked out in the city's best interest to go through and lock in the lower rates that we were seeing in 2020 to go through and ensure that we could go through and accomplish those projects for the least amount of money needed. I'd also like to go through and highlight that in 2023, there was a planned issue, but based on what we were seeing with construction costs, with cost of borrowing, and the ability to go through and actually expend those dollars, the city elected to go through and postpone that issue because at that point we didn't need those dollars at that point, and it didn't make sense to go through and incur that additional debt at that time. So your staff has done an exceptional job going through and being very strong and good stewards of the taxpayer dollars there, and really looking to make sure that you are only borrowing that amount that you need and not more than you need.
If I may, point of order, sir, if I may, and I apologize, sir, I sincerely do for interrupting. I just found out Chief Tripp also needs to leave at 5:45. Is there any way that this presentation can be finished after the next one? And I ask that to all of council. I wouldn't want the fire chief to not be able to opine.
Thank you, sir.
Councilman
Yeah,
Carlson,
council's
I don't
pleasure.
wanna- It's your motion, sir, I don't wanna.
We'll just come back to this after 44.
Is that okay?
But you're gonna be gone. I'm okay with that, but we also have 2 or 3 other things that are long that we should continue.
How much discussion is 44 going to involve? I mean, it's substantive changes to it though, right?
Yeah, I mean, I can very briefly go over it in 45 seconds. I just wouldn't want the fire chief to miss it because she's pivotal to this, obviously.
I move that we halt this and go to 44.
Okay.
Second.
All in favor? Aye. All right.
And if you don't mind, Brandon, Chief Tripp. Oh, I'm sorry. I thought she was outside. I'm sorry. Yes, and thank you. So very, very briefly, if I may, just in 45 seconds, we heard council on, committing ourselves on paper at least to a great deal of spending. So long story short, what I did was I went to Chief Tripp, from whom we'll hear. I went to the union, from whom we'll hear, and asked them, what are your 2 biggest priorities from this list? They chose, and I'll let them speak to this, fleet maintenance and fire station 24. I'll go into that later on, potentially, if I need to. But that cuts down the first year, by the first year, and again, and gosh, there's a lot to condense here, but it reduces things by about 60%, and then we can wait on CIT. So I don't want to talk, Chief Tripp, if you don't clear, sir.
Go ahead. Yes, ma'am.
Chief Tripp.
Good afternoon, Barbara Tripp, Fire Chief for Temp Fire Rescue. And just to speak on the latest conversation that we've been having about, what's priority, what the fire department needs. This is something I have been working on for the last 2 years, and it actually has been fleet maintenance and Station 24. So if I had to pick and choose, those are my top 2 priorities. Fleet maintenance is definitely number 1. Currently, we have the resources operating out of Station 13, but I would like to give them a house where they should be in the area that they need to be, so we can, revamp our fire department and our resources back in the positions that they need to be in.
Yes, ma'am. Councilmember Hurton.
A very quick question.
Yes, ma'am.
How are we on that? Do we have a site yet? Do we have a
So for the
plan?
site for 24, we've been looking at right off of Whiteway, and we've actually done a survey, the whole 9 yards, and pretty much we're ready to start with the design package, which was submitted. That is something I've been working on for the last 2 years, and as far as the fleet maintenance, we have been looking for property. We're going to keep our fingers crossed. We actually have something out there right now that I've been working with real estate, and it looks like it's going to be a positive go with the land size that we need for fleet.
Thank you.
Councilman Vera.
Yes, and Chief Tripp, thank you so much. We had a long discussion yesterday. I really want to thank you for all your hard work and just your perseverance in this issue. I know you've been a big advocate for 24 as well as the fleet maintenance station, and I thank you for giving me the two priorities that are there. That's all, but you would say that these are core, critical, pressing issues for public safety in the city of Tampa. Would you agree?
I agree. I definitely agree, especially with the fleet maintenance. That's long overdue. I mean, the conditions that they're working in and with the amount of vehicles that they see, we have quadrupled the amount of apparatuses. And of course, that station was built in 78, or that facility was built in, not 78, I'm sorry, 58. And it was probably for like maybe 12 trucks citywide. Now we have over 100 vehicles that, you know, with reserve and frontline that facility maintenance shop sees on a daily basis.
Yes, ma'am, and also by moving fleet maintenance away from 9, we can open up 9 for more expansion to better serve the good people of West Tampa.
Yes, because currently Station 9 is, the way it's operating is not efficient.
No.
You know, with the units backing up to each other, they need to go forward, and of course space and limited as far as storms, and you know, we're growing, so we just definitely need the fire stations to be larger.
Thank you, ma'am.
Councilmember Clendenin, Councilmember Carlson.
You said Whiteway, and that actually rang a bell because it's up there by Mosey, correct?
Yes, sir.
Isn't that on the very edge of the city?
It's pretty much close to the edge. It's 4,800 block of Whiteway.
Does that make sense to put a fire station where basically everything's just one direction? And
No,
you're not
because-
centrally located somewhere where you're doing a response radius in a 360-degree circle?
So if you look where Station 13 is at now, it's not too far over from it because we run all up in USF. We run a lot of calls up on the north side, which is USF, which is Fowler. We run all the way up to 52nd Street. So with that being said, if you look at the Station 13 now, I have 2 units in there running in both directions. Station 13 area is very large. So that would cut down on engine 13 running more to the west, where 24 would run more to the east.
Somewhere in the back of my mind, I remember we were talking more, trying to find locations along, Nebraska, Linebaugh, somewhere in that area, around somewhere like the interstate south of Fowler, in that block. Because isn't that where we have kind of a void?
No.
I remember seeing a map somewhere in like a previous conference that seemed to be where we had a void.
So 3 years ago, when Councilman Vieira said he wanted help for Station 13 for the North Tampa area, he wants it now. So the goal was to see how we can help Station 13 with the amount of calls they ran. We moved some resources. We added the same level of service, another apparatus in there. If you take that apparatus and put it to the west, now you're going to be back to where you were 3 years ago when he came and said we need help. So basically, the unit is there. If I had a place to put them in, that's where they would have went before I even put them in 13. But because we didn't have a facility to put them in. But if you take that resource is there and move it to the west, the Linebaugh in Nebraska, you're going to be back to square one again. You're going to have a problem over there on the east side.
But don't we have a problem in that area, like as far as response times?
No, actually, the call volume has decreased since we put Station 25 there with the 2 rescue cars. The call volume has decreased, and that'll be part of my presentation when I come back.
Okay, so I want to be clear about what the ask is today. This is where I'm at in the bonding situation, and I think I've said this before. I'm okay with bonding for this generational debt for the construction of these sites, like fleet maintenance, building a fire station, as long as we're bonding those that construction. But when we start talking about maintenance, and I looked on that one list, I don't know where that list came from, but man, I saw some stuff on that list I'd absolutely be screaming opposed to, because that stuff should be pay as you go. It should be bonded. So I fully support you building these fire stations. I fully support you building the fleet maintenance. I think it's a great way to go, and I think it's a good service for the city of Tampa. And I get that people for the next 30 years that are going to be living in these areas are going to reap the rewards of building that station. So I'm good there. But I want to make sure what are you doing as far as this proposal? I know you said you're amending the proposal to.
Yes, so let me.
Can I just throw out one thing before?
Yes, sir. Councilor Carlson.
Just, that was going to be my point real fast. A lot of things changed in the agenda the last 24, 48 hours. The last I looked at it, the resolution had not been changed. So what I hear is we're only approving these. I would vote for, I'm in favor of this in general, but I would like to see a resolution that says that we're only going to spend on these two things, and that we're only going to spend a certain amount of money, which is less than was originally proposed. And then I would like to see very strict limits so that we don't see what happened last time where the money was spent on something else.
Right, yeah,
This money can only be spent on these things. And with those three, I would definitely support it.
Councilmember Moran.
Very quickly, I know you got places to go, Mr. Chairman. Why don't we get a short-term loan to get us to start this, get us to when the CIT kicks in? If we can sell it, we gotta sell it, Public safety is the paramount. If fire and police and fire, however we wanna look at it, is paramount in everybody's mind, in the whole city and the whole America. But if we do that, you can save all the money you're gonna do by going out and getting your legal staff and the 1%, this, that, and the other. And that may buy you an ambulance or a fire engine, I don't know. So these are the things that you have to look at, how you manage your money. That's all I'm saying. I'm not against it, but I don't like the bond right now. If we're gonna have the CIT tax in November, get a short-term loan from a bank, pay the interest like you're gonna pay anybody else now. You bought it the other way, several pay the interest. And let's work it out. We only have one thing on the floor, funding. But there's no other programs that have been brought up. The CIT tax should not be for 30 years, it should be for 10 years, so you have transparency every 10 years with the public to see what you're doing with their money. But I'll go further, I'm gonna quit right here. Thank you.
Councilmember Hurtak.
I absolutely do not agree with that, in that we did this before with All for Transportation. We hung our hat on something and it didn't happen. So because we're making this smaller on focusing on these two issues, we can still use the CIT for this extra that we really need. We need 9, we need 10, we need to relocate 6, we need then to start a system of renovating or rebuilding every single fire station in the city. So we have to start somewhere. I believe this is a great place to start because I don't want to wait one more day.
But I don't want a blank check, so how much are we talking about?
Yes, sir, Mr. O'Hara.
Thank you, and again, if I can, again, just level set, I want council and the public to be very aware of what's actually being asked. We're not asking council to approve any issuance of debt. Okay. As Councilman Carlson said, the resolution and the motion have not changed. What this authorizes staff to do is to begin spending money on 1, 2, 3, 4, or 5 of these stations and basically float that expense and pay ourselves back from a future debt issuance, whether it's a short-term instrument, bank loan, line of credit, or a 30-year bond, for instance. If I had to predict, we're probably going to do, as I said earlier, and as you alluded to earlier, Mr. Chair, and as you just said, Councilman Miranda, we will issue a short-term debt because we only want to go into debt for the money we need in the very, very near future. Okay, if time goes by and this plan in its entirety is successful and pursued, then it'll probably end in a long-term debt issuance. But I want council, there are federal tax laws that we have to adhere to make sure we can recoup that funding, and that's what this resolution is set up for. It doesn't issue any debt, and I'd be uncomfortable altering the existing resolution at this time.
Councilman Vera, did you have a substitute resolution?
I don't think we're ready to vote tonight if the resolution has not been edited.
Well, can I also, if I may, I think what council wants to accomplish can be done with the resolution council has before you.
Oh, I don't think
This
so.
seems like bait and switch to me. I just.
And if I may, so how about this, council? Because again, I want as many people who support this to be on board. Would this council be willing to, because I don't want to waste another day on this. And I spoke to Mr. O'Hara about this issue in case if it came up yesterday. I do believe, by the way, if we passed a resolution as this today, we could still, and I had some motions to this, keep a tight grip of that. However,
Agreed.
I would want this, if it comes back to us for an amended resolution for these 2 items, to come back to us next week as item number 1, yes, at night, council. And I know that's frowned upon.
No, I'm just, I see, I'm sorry to interrupt.
Yes.
Mr. Vasky is here.
Yes.
And he's the attorney for the.
No, and I already spoke to Mr. O'Hara on this, and we can have you come up. But to have this come up, this should not be a long discussion. I would not take the time of night council. I know we have a long agenda, but I just don't want to make our firefighters wait another week, if council's amenable to that as a compromise.
Well, can't we
just do it?
Can't we just amend this I mean,
Yeah.
I make a motion to amend this resolution.
Second.
By,
Can we do that?
okay, so this, it would read this: administration to present a reimbursement resolution for costs related to land acquisition, design, construction, improvements, and equipping of the following fire rescue projects as approved in the fiscal year 24 to 28 capital improvement program. Fire Station 24, fire maintenance and supply facility, period. And then further to include the item, and then continue with the rest. So we strike the other language for the other facilities, and we can deal with that at another time.
What's the amount of money?
And I was gonna get to that, it's about 45 to $50 million at worst case scenario, but I was told, because I went over this yesterday, that staff would need another week to do that, is that not correct?
And here is why I'm uncomfortable with amending it right
see.
now. This is a reimbursement resolution crafted in consultation with our financial advisors and our bond counsel, because we want this resolution to hold up to scrutiny by the IRS in order to recoup this funding. Council can make a motion. I can't guarantee you that it will allow us to pay ourselves back from future debt unless we provide you with a revised resolution.
Those other items, we need to figure out a way of pay-go. The construction of these stations, I'm all about the fire maintenance, Fire Station 24, but it's our responsibility to maintain our stuff.
Understood. I want, I'm sorry, I thought you were finished.
Yeah, no, and I think as we take up with these other issues, but I agree with Councilman Hurtak, the fleet maintenance obviously is step one, because Chief Tripp and Nick Sacco has told us time and time again, we have to do this before we can start do these other things. So surely there is a way for us to move forward with, if we're only moving forward with the fleet maintenance in fiscal year 24, if we're only moving with fleet maintenance in Fire Station 24, then let's go with that.
I think we should take a chance. Let's just do what you proposed.
Yeah.
Well, what I would suggest is we proceed with with your motion, but also ask council to ask us to come back to you with a reimbursement resolution confining that reimbursement only to those two facilities.
And to a budget limit.
Yeah.
That'll end up being a second motion, but right now, so I've got a motion, but I don't have a second yet.
Wait, there's a motion from Councilmember Clendenin, second Councilman Miranda.
What exactly is the motion? The motion is to amend the resolution?
Correct.
Yes.
For those,
For Station 24 and then for the.
Fleet
and to
maintenance.
strike the rest?
Right.
Yes.
For only 50.
What did you attach a dollar?
So,
Did you attach a dollar amount to that?
I will accept that as a friendly amendment.
Yes,
We have a motion and a second from Councilman Miranda.
Bonding, well, no, with the idea that it will be bonded somewhere down the future. Well, with construction of the fire station, construction of fleet maintenance.
And if I
Yes.
may,
Yes, sir.
just really fast for Mr. O'Hara, because I just want to make sure, 50 million, when we discussed this at length yesterday, that takes care of these two projects, correct?
Yes, if I could direct your attention to the Elmo, we did a pro forma issuance for just those two.
The
Okay, that is I need the Elmo, please.
Activate the wolf vision. The wolf.
Yes, the Wolf Vision, yes.
It's doing it.
It's going green.
All right.
I'm having a stroke.
So we don't,
joke.
we don't call it the Elmo anymore. Okay, the Wolf Vision, I got you. There we are. This gives you a rough estimate.
Start building the station we need now, and then
But that's bonding, that's short-term bonding.
But I think it doesn't commit us to bonding, right? It just commits us to short-term debt.
Exactly. You're
Short-term
reading
debt,
it does
right.
not commit you to any debt service. It merely
You have to come back to us
allows
for
you
debt
to
services,
recoup the
correct?
funding if you issue debt.
You have to come back to us for debt
Yes, we do.
services. Okay, thank you.
We absolutely do.
Yeah.
All right.
And again, if you look at the Wolf Vision, it does sound better than the Elmo. Again, this gives you, again, a big picture idea, and you'll see at the bottom, assumes a single bond issue, but we do not think that is going to happen, but this gives you the big picture. As Councilman Vieira said, the project proceeds will be under $50 million. You will recall it was much more than that. And it's confined, if you see here, Fire Station 24 and the maintenance and supply facility. The anticipated interest estimates, the total cost, and if we did a 30-year bond, annual payments of $3 million. But again, This gives you the big picture. What we'll do is, or what we anticipate we'll do, because conditions do change, is do a short-term debt issuance, bring it to council, that may eventually be rolled up into a bond. That's if council decides to finance these projects with debt. This does not obligate you to do that.
Councilman Beer.
Thank you very much. Couple of things, Chief Tripp, I mean, we thank you. I mean, I don't think, because I know you gotta run, God bless you. Couple of things, just two quick things, if I may, Mr. Rajero. So by approving this thing today, this gets us shovel-ready, boots on the ground, starting as soon as possible for these projects, correct?
It does, and again, but I would recommend that we follow up with a revised reimbursement resolution. So should council want to take advantage of that tool,
yes,
we can recoup our expenses.
And we will make that motion. Secondly, I will make a motion as well. I want to have biannual updates on this, starting in June, then in December, because Councilman Carlson's points are well taken, which is we want to trust but verify.
Can we make it quarterly?
Yeah, I was gonna do a friendly.
Wait, very friendly. We have a motion on the floor from Councilmember Clendenin with the second Councilman Miranda and Mr. Shelby.
A question.
Yes.
The question is to amend the motion, that's the first one. And then there would be a if I hear it correctly, there has to be a follow-up directing staff to come back to a certain date and time.
Yes.
Okay.
Let's take a roll call vote.
I'll support it now to get to the point where a bond is. Then from there on, I'm a different guy. Gotcha.
We have a motion from Councilmember Clendenin, second from Councilmember Miranda. Roll call vote.
Henderson is absent. Vieira.
Hell yes.
Miranda.
At this point, yes.
Carlson.
Yes.
Hurtak.
Yes.
Clendenin.
Yes.
And Maniscalco.
Yes.
Motion carried unanimously.
Now we need another motion regarding that staff or the finance department come back with a
revised reimbursement resolution.
reflecting the changes.
Reflecting it, exactly.
Can we get a motion?
If I may move for, when do y'all want it back?
February 15th?
That's fine. Since we got it done today, February 15th to come back, if I may.
Second.
We have a motion from Councilmember Vieira for the updated revised motion to come back February 15th. Second from Councilmember Carlson. All in favor?
Aye. And then
yes,
sir. Yes, sir. And if I may, quarterly updates on this project so that the public and our firefighters and everyone can keep a close eye on it, beginning in April, May?
I'm gonna ask for a written report, so it's something that we can receive and file unless
Yes.
we have questions on it, because we're trying to streamline our processes, so if we talk about the word written report,
Yes, ma'am.
that way.
We have a motion from Councilmember Vieira. We have a second from Councilmember Hurtak. All in favor? Yes,
Is
ma'am?
April good?
April 18th.
Yes,
That's a great date.
please.
We have a motion and a second for April 18th. All in favor?
Aye.
Aye. Any opposed? Councilmember Clendenin, you have a motion.
I do. I'd like to make a motion that Chief Tripp, prior to committing money or committing the city on Fire Station 24, to report back to Tampa City Council on the site location.
All right, we have a motion from Councilmember Clendenin, second from Councilmember Miranda. All in favor?
Aye.
Any opposed?
Prior to her committing, so just bring it back to council before she commits to a site location. So, yeah, my goal is, because I don't have enough information with what she shared. From what I understand of that location on Whiting, again, the city boundary, where the fire station coverage is, I want to have more information so I understand that this is, if we're going to spend all this money, I want to make sure that we're spending it in the right place.
Yes? Yes, ma'am.
You do realize that if we continue to worry about a location, that's gonna set us back at least 6 months on building this.
Well, I just want her to come back and show me why it's a good place to spend all that money.
Okay?
Okay, I mean, it's a lot of money, and it's gonna be there for 30, 40, 50, or the way our fire station is now, 100 years. So, I mean, I think it's incumbent upon us to really take that serious of what that location is.
Mr. Stocco, are you good, or would you like to speak? Thank you for your patience today, sir.
Can I ask him a question?
Here you go, sir.
Nick, this proposed location on Whiting are you comfortable with that location?
We'd have to, Nick Stocco, President, Tampa Firefighters, we can have conversation with the chief about it on how the chief determined that to be the location.
Okay. I think I heard that.
What was
I think I
that?
read between those two lines. Thank you.
And can I, that $50 million baked in, by the way, assumes that land goes there, otherwise there's land acquisition. So just to put that out.
And that's gonna increase.
Yes, sir, Councilman Carlson.
I would just like to make a motion to ask staff to include language in that revised resolution that requires that the money could only be spent on those two projects.
Can you do that? All right. Motion from Councilmember Carlson to strictly dedicate that money for these projects. Second from Councilman Vieira. All in favor?
Aye.
Any opposed? Thank you, sir. Everything okay?
Yeah, I thought you wanted to hear something, but.
We just want to look at it.
Could I do is it possible to continue a couple more things?
Yes.
Can we finish the presentation we're in the middle of?
The problem is Guido's about to leave. 39 is a very controversial one for Harbor Island, and we're only going to have 5.
I was going to make a motion to continue that anyway.
Yeah, we need to, I think we need to, the neighborhoods are asking us to continue it. We should have continued this morning. It's my
You
fault.
want to do February 15th? Or do you want
No,
more?
it needs to be after the public hearing.
Yeah, we don't have enough time. I don't think we have enough space. If
Is
we're gonna
there-
adhere to our,
It's got to be after, it's got to
I'm
March
sorry,
something.
Madam
Is that-
March 9th is their meeting.
It's got to be after that.
Question.
Yes.
Is there, with regard to item number 39, is there something from the administration with regard to issues
Is Dick
about,
online by any
Mr.
chance?
Baird?
Mr. Baird is here.
about, they're choosing a date, Mr. Baird.
I'm sorry, say
They're
that
looking
again.
at continuing this.
Isn't the public hearing on March 9th?
Brad Baird, Deputy Administrator of Infrastructure, there's currently a public hearing for March 26th.
On 26th.
And also Vic is virtually online, I believe.
So I'm gonna re-register my opposition to waiting 2 months to meet with the community on this. I understand that that's when the convention center is available, but I do believe that we have a lot of other areas in the city. And I would say if there's any way at all possible for you to have a meeting within the next 2 weeks, because we continuously get, all we're getting is people giving us every type of information you can imagine. There is so much misinformation or unsure information going around. It's not going to get better until there's a meeting.
Yeah, I do want to remind City Council, those two signals are on pause, right now.
But
But-
can I just,
But the community is not comfortable with just the assertion of that.
Yeah.
That's why we're asking for the continuance. And again, we're still getting a volume of concern and misinformation, or just people are saying all sorts of things. So I think it would be best to try to stop the rumor mill and have an actual meeting as soon as possible. I talked about this on Tuesday with you all, and I'm just gonna reiterate it. As soon as you can possibly do it, and then bring this back.
if, Mr. Chair, if I know Harbor Island's been talking to staff, I've been talking to staff. If staff presented today a revised agreement that specifically did not include those lights, then I'm okay moving forward with it. But otherwise, the neighborhoods absolutely want us to vote against this. The better thing is to continue it. Staff is going to say, well, there's some costs or whatever. I just want to reiterate to staff, things should not be presented to us at the last minute. It's not our fault if it costs the city more because something was presented to us that can't be delayed by 2 weeks. That we have to hold the city fiscally accountable, and we have to make sure we drive the philosophy of the city, and we have to do what's in the best interest of the citizens, which is to continue this. So I'll make a motion to continue it to February 15th.
We already have 10 items on February 15th for staff reports.
Which
Oh,
one?
yeah. Yeah, so we need March
Yes.
7th.
I make a
And
motion to
maybe
move it
I'm
to March
sorry.
7th.
I'm sorry. I just want to make sure that council makes an informed decision. I'm not taking a position one way or the other, but there's something that involves a cost escalation at some point, depending on that.
Which
that they have
is what I just referred to, which is why the administration needs to learn not to present things to us at the last minute. We have to hold the administration fiscally accountable. We have to hold them accountable to the public. And if there's a cost, that's on the administration, not on us.
Well, ultimately, do you have the date that would cause something to change as to the number that's on the agenda today?
No, if it's not approved tonight, there would be a cost escalation, so I would have to modify that GMP.
And also, if the motion is to remove those two signals, we would have to modify it to do that as well. So I would say 2 weeks would be tight to do that, but March 7th would not.
March 7th is your motion to continue? Motion from Councilmember Carlson, do we have a second? Second from Councilmember Miranda, all in favor to continue to March 7th?
Aye. And just so you're clear, Mr. Baird, so March 7th would possibly include a cost escalation?
It would, yes. I talked to the contractor this afternoon, or earlier today.
As long as council makes an informed decision, that's council's
And we can put
motion.
it back out for bid too, right? I'd like to also move continue number 47 to maybe April 18th. There may be staff here, I apologize that they've been waiting all day, but I would rather have all of council if possible.
We have a motion from Councilmember Carlson, second from Councilmember Clendenin. This is about
The-
CIP.
Yes,
Do you want this to be a workshop instead where we can have a discussion about it, or do you just want to have, because this says a discussion.
I think leaving it in its present form is good.
I moved it to the same time as the 3-bid discussion.
Oh, okay,
That
yeah.
makes sense, yeah.
That does make sense then, yeah.
Motion from Councilmember Carlson, we have a second? From
Second,
Clendenin?
yes.
All in favor?
Aye.
Thank you.
Okay.
Thank you all.
I just want to reiterate, this is now the second project that we're having people come to us and are concerned about the cost of the project because of what comes next. And so maybe a good time to kind of take a look and see what we can do to front load some information so that when this stuff comes into the budget, people aren't surprised. I don't think we need a ton of information, but just a little more information for both this project and what's going on Howard Avenue, I think would have gone a tremendously long way to combat the misinformation that tends to start.
I understand, and that is what 47 is about, so we'll be coming back with that.
Great, great. Well, then
All
that's wonderful.
Thank
Thank
you
you
all.
so much.
All right, thank you.
Are we continuing with the bonding?
Yeah, I think we are continuing.
Is that the last item?
Dennis, I think we have one more. We're continuing with your presentation. Thank you for your patience.
No, thank you for your interest. Again, Mr. Reed.
All right.
All right, Will Reed again with Ford & Associates. Going through, on the screen now are the next proposed series of debt related to the water and wastewater system. I do want to go through and take a minute to discuss capacity as it relates to the water and wastewater system, because that was an item that came up. All of the numbers that we've been looking at here when we've been discussing capacity have all been with the mandate to go through and protect the AAA status. We've gone through and evaluated the rating criteria at all three rating agencies and have endeavored to go through and maintain the days cash on hand and the coverage levels dictated by the rating agencies when it comes to maintaining those AAA ratings. So going through and looking at this, the numbers that we're going through and showing you are numbers that are realistic, that maintain your current high level of ratings and the broad market acceptance of your fiscal conservancy. As you can see here, this is the current plan. That doesn't mean that that's actually what's going to happen, because again, as I said, we are continually evaluating the ability to go through and spend dollars, to look at the projects as they come up and as they are required and as they are needed, and are perfectly happy to go through and postpone this as the projects go through and dictate, or accelerate them if the market demands and the system needs that. So I do want to go through and just make sure that I mentioned that these are fluid, the plans here are fluid, but these are all numbers that were baked into the original evaluations of the PIPES program and are evaluated on a yearly basis by the financial feasibility consultants going through looking at this, looking at the revenue projections and the ability to go through and manage the debt service that comes along with that. We've got a couple of charts here that will mirror some of the charts that you saw earlier. This first one is going through discussing the annual payments. This is both principal and interest as they go through and extend out. You do have some SRF loans, state revolving fund loans. Those are issued on a subordinate basis. So those show up in the red there. The orange are your senior lien water and wastewater bond debt service. Going through to show the pay down of principal. As you can see here, you do have a fair amount of principal outstanding because you did just have two pretty significantly sized issues that went through and were priced. But those will pay down over that 34 years or 33 years at this point. And in the same way that your home mortgage would go through and the principal amount there would go through and reduce. With that, I'd like to go through and show the proposed future financing. This gets you to the...
Hold on one second. Councilman Miranda?
Turn your mic on.
Slide before, it goes down to 2058, and yeah, at that time, you almost have no bonding. That's providing there are nothing else added to that.
Correct. This is your current...
I know it looks nice when you look at it, oh, I'm gonna be out, or you're not.
Yep. No, absolutely. This is based on what you currently have outstanding.
Make sure.
Charlie, in 2058, you need to hold them accountable to that.
I'll be here, somewhere in Newport City.
Betting on horses.
Going through, this next piece here goes through and shows the proposed future financing. Again, this is based on the projections that were done when pipes was initially looked at, and based on the capital improvement program that came to the city and has been sort of continually refined as it goes through. Again, this is done to protect your AAA status. This is not going through getting you out over your skis. This is what you are able to go through and afford as judged by all three rating agencies when they go through and evaluate the program that you have. So with that, to go through and show the proposed future laid on top of what you currently have outstanding here. One thing I will go through and highlight is some of the earlier issues you did, particularly the 2020. We did go through and extend that out a few years beyond the 30 years, and that was done because rates were at an all-time historic low, which allowed us to go through and preserve some capacity at very little expense, because the yield curve at that point was incredibly flat, and the added cost there was nominal compared to the savings that you're seeing, particularly now with us being in a higher rate environment. So that was foresight that your financing team and your staff had to go through and look to try to preserve the maximum amount of flexibility and leave the city in the strongest financial position possible.
Excuse me one second, Councilman Hurtak?
Well, he's finished, that's what
Okay.
I wanted to. Just because these are kind of scary looking numbers, I really
Absolutely.
wanted to reiterate the differences here. The general fund that we're borrowing is paid through the general fund. This water and wastewater is paid through water and wastewater
Yes.
fees and enterprises. So while this all looks like it goes together, this is in fact not part of the general fund at all.
Correct, and this is why when it came to the question on capacity and the ability to go through and borrow, we wanted to go through and split that up by the borrowing type, because they're both separate pieces. This is only secured by your water and wastewater revenues. This does not have a pledge on your general fund revenues. It doesn't have a pledge on your CIT or anything of that nature. The bonds that are issued on the water and wastewater side are secured solely by the revenues that are generated from your water and wastewater side.
And just to reiterate, these current bonds have the highest rating of any other bonds within the city.
They have the highest ratings of any bonds in the world.
Okay, and we're about to do solid waste, and that's the same thing. It is also an enterprise fund, and that same thing comes to pass where it's going to be paid for within.
Correct, and I'll
Okay.
hand that off But those are, the enterprise funds are secured by the revenues that those systems go through and generate. Some other entities will call that business type activities because it basically is run as a business within the government.
Yeah, I just wanted to reiterate that for people who are watching this. I think it's very important when you see this is a scary slide, but knowing where that money is coming from, we're not pulling that from the general fund. So just wanted to reiterate. Thank you.
Councilman Carlson.
Yeah, and Mr. O'Hara, again, outstanding job by your team. As you all come back on pipes and stormwater, I think it would be helpful to show the covenants from the bond agreements and the plan that was presented at the time, because the public bought into those plans over a 20, 30-year period that included a certain budget and included getting certain things done. And so as I said before, I'm against new bonding. If there was a commitment that we made years ago to continue a program and we're obligated to do that, otherwise, as you said, it would negatively affect our bond rating, I probably am okay with that, but I think we need to show that. And then the other thing that would be good at that time is to show cash flow. Like she said, these are scary numbers. If it's $90 million a year, that means there's excess cash flow to at least pay this. What cash flow is on top of it? So it would be interesting to look at that because that affects rates, and we need to make sure that we're not bonding everything out with an unstated anticipation that somebody wants to raise rates. We need to look at it to make sure that we're not going to have to raise rates, or we need to try to get consensus from the public on it.
Yes, sir, will do.
That is coming back to us on March 7th, by the way.
Which one?
The pipes project. So if you would like to amend that to include, on the March 7th staff report, to amend it to include some of the financing that you asked for from.
Can we hold that till after the presentation?
Okay.
Yeah.
Maybe you can tell us if that's too short, maybe tell us when you'd like to come back on.
Yeah, I don't, off the top of my head, I don't know what the March 7th is. I'm relatively certain we're not coming to you asking for a debt issuance on March 7th.
No, they're simply coming to present a report on the review of the pipes projects, including how far along the city has gone, what the expectations were, what was accomplished, and what can be accomplished due to cost and other issues. So it kind of fits in, ties in nicely.
Yeah, it's a nice segue. Of course, I just wrote down what you asked for, Councilman. So by hook or by crook, we will provide it, especially when we come before you for the next pipes issuance. When you'd like to make the motion, yes, they seem to go together. You can make it now. It doesn't matter to us. We're going to give it.
Yeah, so I'll move that we add part or all of the bond discussion related to pipes to that item on what date?
March 7th.
March 7th.
We have a motion from Councilman Carlson, a second from Councilwoman Hurtak. All those in favor, aye?
Aye.
Opposed? Ayes have it. Okay, can you go to screen 42? Go back.
I just wanted to address Mr. Carson's comment quickly. The covenants within the bond documents on the water and wastewater side are less restrictive than the city is holding themselves to. The metrics that we're going through and looking at broadly here are maintaining revenues of more than 2 times coverage, revenues to debt service, and days cash on hand within the water and wastewater system of I believe it's over 250 days cash on hand, maintaining those revenues, maintaining those reserves.
So that means you have free cash of 180 million, or that's total revenue? How much?
Total revenue, and those are revenues that are going through, and our program to go through and continue maintaining the system and operating the system. But that's looking at the total revenues of the system when compared to the debt.
Yeah, thank you guys for being so open and transparent about this. When anybody hears me frustrated about transparency, this is the example of what I like to hear. I like to get in the numbers, and I think the public likes to get in the numbers because it gives them a level of confidence. So thank you all.
Yeah, and these questions are part of what helps your rating categories.
Don't go away from that screen.
The board.
Go back.
Well, I'm sorry. I thought you were finished.
Okay.
I was just going to add. If can you see this one? Our next issuance, again, on March 7th, we'll be coming before you to talk about more of an operational angle, and we can share with you those particular metrics associated with our last issuance. What I also think you're asking, and I want to clarify, and based on that ask, I want to provide it. Our next issuance, you see here, Series 2024, that'll be this year for $400+ million. We will also provide the same metrics based on this issuance: cash flow, debt service coverage, et cetera, et cetera. So I think what you'll see in March is somewhat of a retrospective, and then when we come before you asking for the next issuance, you'll see the prospective based on this issuance. So you will get a great deal of data regarding cash flow, debt service coverages, things like that.
And so, sorry, if you're showing cash flow, please include O&M so that we know what free cash flow is there.
Yes, sir.
So I just wanted to highlight a couple things. I mean, yeah, these are scary numbers. I do also see that it assumes a 5% interest rate, which I'm also assuming that we're probably going to be issuing less than 5%. Are we even issuing anything at 5% right now?
No, and thank you for bringing that up. I did want to reiterate that these are very, very conservative estimates.
Right.
The last thing I want to do, the last thing anybody wants to do is come in with lower numbers than we anticipate. And then you're looking at us like, so these are very conservative. I would anticipate they would be less. But again, if I knew for sure, I'd be talking about this from my island. But they are very, very conservative.
And again, I want to say that when you look at the principal and the interest, clearly pay as you go, if we're able to afford it, is the way to go. I mean, anybody in finance, whether you're a city or you're a family trying to run a tight household, it's better to pay as you go. What you're bringing in, you spend. I mean, that's clearly the best way to do this. Down on the bottom, it says $88.8 million in premiums. Please explain that to me.
Sure. When bonds are sold in the municipal market, they are not traditionally sold at face value.
Mm-hmm.
It's one of the peculiarities that you run into in our industry. You'll have a stated coupon rate, which oftentimes will be either a 5% or 4.5%. The investors, when they go through and lend you money, may lend you either 105 cents on the dollar, or they may lend you 98 cents on the dollar, depending on what their yield is that they're going through and looking for. The $88 million there in premium is, we're going through looking at borrowing for a project amount.
But isn't this kind of what I was alluding to earlier when we were talking about the paying the piper, paying the Wall Street folks, paying all these, this is kind of what, because now when you factor that in, what percentages are we talking about as far as overhead on bond issuance?
So when you look at premiums here, that is separate and apart, and from a mathematical standpoint, it actually doesn't really have any bearing on the actual amount that you're borrowing, because if you're paying a 5% coupon, the principal amount that you will have borrowed is going to be less than the amount that you're getting paid, because they'll pay you a premium for the higher coupon. And this gets into some of the bond math that goes through. The cost of issuance piece that
okay, let's break, because I may be stupid because I don't understand. So let's go to the easy numbers. Let's say $1 million in debt. So we're going to issue $1 million bond. What is the premium on $1 million bond?
And pardon me for taking this into a slightly different direction, but trying to get to the same place.
Okay.
Let's look at a $100 million project.
Okay.
If you're going through looking to finance a $100 million project, you may end up issuing $80 million in bonds, and the investors may pay you a premium for that $80 million in bonds because you'll have a little bit higher of an interest rate. Your effective yield will be lower at that, call it 3.5% instead of the 5% coupon. So if you're issuing $80 million in bonds and receiving $20 million in premium, they're paying you more than 100 cents to the dollar for each bond you're going through.
So it's kind of like buying down the...
Sort of. It's basically just trying to balance the interest versus the principal. And investors in our marketplace, because the interest is tax exempt, it has more value to the investors. So they'd rather receive a greater portion of what they're getting paid back in interest rather than in principal. Because principal, you get your principal back.
Dollar for dollar.
Yeah. So by going through and in allocating more of that return to the interest side, they're willing to pay more than 100 cents on the dollar because they're getting outsized benefit from the tax exempt interest component that they're receiving.
This is why I became an air traffic controller and not an accountant.
Yeah.
I would be sitting here lying to you if I wasn't like, I'm right now, I'm a dog watching TV. I mean, on that, I still don't understand it, but I'll do my homework and I'll figure it out on my own.
So and from the cost of issuance aspect, the cost that it takes to go through an issue, for example, your last water and wastewater issue, you paid, I believe it was 0.7% in cost of issuance, total.
So that's it?
Yeah, that's the between the underwriters, between your professionals, your rating agencies, your financial feasibility consultants, your, the rate consultants, all of that.
Councilman Miranda.
I just want to clear up, so a premium is not.
Put your mic on.
A premium is not a points on your loan, is that correct?
No, and this is one of the pieces that gets a little bit difficult in going through and laying it out because it really is just a math play. It is the amount that the investor is willing to pay you over and above face value of what they're going through and receiving in exchange for what may be a little bit higher of an interest rate.
And thank you.
So the money
Thank
comes
you.
this way, not that way?
Correct.
Yes,
Okay.
the upshot is it's a good thing based on the strength of our
Yep.
issuance.
Okay.
Yeah, not
Now
like
I
an
get
insurance
it.
premium.
Now I get it.
Yeah, that's a good point, yeah.
Yeah.
He said not like an insurance premium. So I can see how you may view it negatively because of the word premium, but it's a good thing.
Councilman Carlson.
Yeah, I mean, what you were kind of saying is you can, if your target is 100, you can borrow less than 100 because the premium will make up the difference, right? Is that-
Exactly.
And, but is Mr. Harrow, or either one of you, is the premium restricted in the way it can be spent? So it can only be spent on these projects,
Yes, sir.
right? It's not something that they can put back in the general fund?
No.
No, okay, thank you.
Very good.
Good question, no.
Thank you.
We gotta spend it on that.
Hey, I'm gonna change my business. I'm going into the bonding business after this meeting. You got competition. Very good.
But you got $10 a loan.
Exactly, yeah, exactly. And does that conclude your presentation?
That concludes our part. That concludes Mr. Reed's portion. What's that? Yeah, we got solid waste.
Mr. O'Hara?
1, 2. And then solid waste financing. Again, wanted to refresh council and the public's memory in terms of what is within the capital improvement plan for solid waste right now. The big ticket items, the waste to energy facility, which we've had many and much discussion on, and also the solid waste complex, which involves a number of activities, including relocation from the current Spruce Street site. We do not have the charts that you just saw, for instance, with water and wastewater, because we have no existing debt for solid waste. Okay, we'll be making an attempt to re-enter the market, as a matter of fact, and see what the market thinks about the strength of our credit and things of that nature. And you see under the sources, right before the total sources, the solid waste debt, all the way to the far right, you see a little under $290 million worth of anticipated debt for these projects. And then, of course, you see the uses that I referenced, at least the big ticket items that I referenced below that. And I can come back to this in just a moment. And I got a little ahead of myself on the slide. Again, no current outstanding debt. We've got to reestablish this credit. Further to what Councilwoman Hurtak was saying, this will be confined from a ratings perspective to how strong is our solid waste credit based on what we anticipate to happen with rates, things like that. And are very similar to our water, wastewater, our pipes program. How much confidence do they have in our ability to manage these projects? Of course, the pipes program has been very, very successful, and I'd view that as a very successful template to work from as we continue down the solid waste path. And so Again, I know there's a lot of information on one page, but right now, this is part of the capital improvement plan. And
Councilwoman Hurtak.
Sorry, yes.
I just want to say this was so interesting, and what a great presentation.
Well, thank
it was
you.
45 pages, but we had a lot of really good conversation, did a lot of understanding, and this is exactly what I wanted out of this.
Thank you.
So I really, really do appreciate it, and I do think that, as Councilmember Carlson said, as we look at reviewing some of these programs and procedures like the PIPES program and other things, I'm definitely looking forward to when you're coming for more bonding to have this historical record and then the preview. I just think this was just so well done, and it's just so very thorough, and I'm going to hold on to this presentation for a while, so I really do appreciate it.
I thank you on behalf of my team. If I could just interject, this is definitely the most comprehensive presentation review of our debt picture since I've been here for 15 years.
Councilman Carlson.
Yeah, and on the waste to energy, it would be helpful, I think, to go back to the 2019 or 2018 analysis that was done, the consultant analysis that talked about how much the facility would cost, and then bring that forward and talk about why it did or didn't cost more and what the reasons were. You've done a great historical perspective going to the future and the past on these things, which I think is really needed for context. On some of these projects, it's good to explain to the public, yeah, we started here, but then something happened and we changed. And hopefully the administration sees that by being transparent and having the numbers out, it doesn't mean that we're all going to get criticized. The numbers are what they are. If you get inside a waste to energy facility and you find out that something's broken that you didn't see on the beginning and it costs $10 million, we have to keep the thing running. So it's not that somebody's being frivolous at wasting money. It's just it costs that much. I really
absolutely include that. Yes, sir.
I really appreciate it, and I would, while you're here, I would just like to make a motion to ask the CFO to make this presentation annually every February. Is that okay with you?
Absolutely. No, absolutely. We enjoyed putting it together. I appreciate it.
My only question would be, is this a best time for this? Would we want to do it closer to the next budget cycle? That's my only question.
Remember when we went through the budget cycle, Councilmember Clendenin said, well, we need to start earlier. 4 years ago, I tried to start now, and we had hearings, we had discussions, but it's still crammed up. So this is, you're going to give us more updates on a lot of things, but if we could get, to me, the question is, should it go into a workshop or a city council meeting, because we see how long it lasts.
I think workshop, because we had a great conversation today, but I do believe it's a workshop. I'll agree with you.
And I'm sorry, and I do think this is good timing, because it is a lot of information to absorb, and it'll give you a nice long runway before we really enter into budget preparation and
So
discussion.
say the first week of February?
So we have a motion on the floor to repeat.
Or the first workshop of February.
We have a motion from Councilman Carlson to repeat this presentation in February of 2025, and a workshop. Is there a second?
On an annual basis.
On an annual basis.
Starting in February.
Second by Councilman Vieira. All those in favor, aye?
Aye.
Opposed?
Thank you.
Motion passes. Councilman Vieira.
Oh, yes, sir. I just wanted to, again, thank Mr. Rajero for, number one, just all the time that I took out of your schedule in the last week asking all these questions.
Not at all,
But for you and everybody who were here, this presentation, and obviously thank Councilman Carlson who made the motion for it, an important issue. And you know, it's funny because a lot of times on legislative bodies, everybody has their perspective or way of looking at things. And not just as everybody's perspective counts, but the strength that everybody brings allows other people to go, hey, that's a good point. Got a little something there, right? But you did a great job, and this was really one of the best. And also, by the way, a vast majority, all staff presentations, in my opinion, are wonderful. But this is one of the best.
Well,
so
very kind.
Yeah, if this was Al Pacino's filmography, this would be The Godfather.
Oh, geez.
Not Serpico, Godfather.
High praise. Thank you. And if I could just, I would be remiss if I didn't say thank you and credit to all the people you don't see here. These wonderful finance professionals, of course, continuing to guide the city, but also our professionals who aren't here, bond counsel, disclosure counsel, and then, of course, the revenue and finance staff, just absolutely wonderful finance professionals.
What is the impact on the proposed, because we're doing a rate evaluation for and waste, so what is the impact that would have on these numbers or projected?
Well, if I can go back, and if I can back up, you'll recall, and you heard Mr. Reed say, and of course everybody recalls, that we built quite the infrastructure, the rate infrastructure and planning infrastructure before we issued our first bonds under the water and wastewater pipes program. The decisions made about the solid waste rates will drive the impact of our solid waste credit rating and how the market perceives it. What we're committed to both operationally from a project perspective, but also what we're committed to from an anticipated rate perspective.
But so the numbers you're dealing, are you dealing with today's dollars or projected rate increase dollars?
Both.
Okay.
Both.
Okay. And the other thing I would say, I'd caution, because I look at the McKay waste to energy, I know this is only out to 28, but somewhere along this timeline, there's got to be some money factored into that we're going to have to replicate that facility and move it or rebuild it, or, you know, it's running out of juice. So there's going to be an expenditure there as well.
That's a very good point. I don't have the expertise to speak to how long that facility will keep going after this initial, but I think after this.
But we have to start spending money to plan it. I mean, yes, because it's something that takes a long time, from what I understand from talking to the subject matter experts.
It's my understanding also. That's
yeah.
a good point.
Is anybody any other discussion on this? Well, thank you, sir. Thank you to the whole team, and
thank you all.
You know, we obviously. Y'all couldn't be awarded more than you already are, so we'll hold off on giving you an award right now. But yeah, congratulations on a great presentation.
Thank you. Thank you, Council.
Yeah. I think we have one item left on our agenda, item 51. Councilwoman Hurtak?
Yes, so I'm here to take any of your input. We provided the meeting minutes and the most recent report that we had to file with the state. So what are the kinds of things that you would like AHAC to partner or to bring? What kind of information? How can AHAC help?
Councilman Vera.
I'll say if I may, and thank you, Councilwoman Hurtak. I mean, taking, you know, it's funny, there are certain positions on certain boards that if you really utilize them and accentuate them, you can have such a tremendous impact, and that's clearly one of them, I think. You know, one of them I would say is I brought up recently with our friends at the Hive. We were at their fundraiser, wonderful people, talking to advocates like Karen Clay, Tanya Whitlock, and others on accessible housing. I think that's very important. Another one would be housing for returning citizens. Just critically ignored issue in throughout our country. When people are leaving prison and all they want to do, many of them, is just to work hard to put food on the table for their families. You know, talk to Abraham Ministries and groups like that. So just off the top of my head. And thank you for asking.
No, but how do you want us to synthesize that? And what do you want out of that is really the question. What information can AHAC provide us as council members to, you know, do the job of housing better?
I would say what can we do for let's take returning citizens. You know, what can we do to provide these families with better housing opportunities? Many of them are obviously challenged economically. What unique efforts can we make as a city for those communities? Is it working with organizations like Abraham Ministries, Return to Work, other ones? What ideas can we have to better empower them, if that makes sense?
Cash.
I know.
No,
I hope that's responsive.
money for housing, but yes.
So, Councilman Miranda.
Turn your mic on. Turn your mic on.
Everything right now, because you can't afford it. I mean,
Yeah.
it's just a two-bedroom house. If you don't, it's $1,500, $1,800 a month, and the scale of pay is not keeping up, and it's just very difficult. Not only, you can't just pinpoint one area. I think housing is an area from returning, from those living here, from those born here, from those immigrants that are coming in, everything. It just, that's the number one thing right now in my mind that needs to be addressed. And I don't know how any city can solve all those problems. on the other side.
Which actually goes to my point, but I think what we're woefully lacking, I think that maybe the committee could help with, and that is accounting and numbers, and like you've heard me beat this drum. Okay, we're spending, I really don't like a lot of the stuff where we're saying we're spending like the 30%, I'll say it right now, the CRA, 30% of CRA funds. What does that get you? I would much rather see specific projects and let us fund those projects as they come up, because 30% doesn't get me anything. I don't know where that's going. I don't know what, I want to see, tell me what you want and let's figure out how to pay for it. So what I would like to see is the committee really go through our budgets, really go through line by line, department by department, initiative by initiative, and say, we are spending, this is what we're getting, this is how many people are being served, this is what, because something that came out, one of our nonprofits, we found out we're spending a lot of money, and basically that was under the auspice of affordable housing. We found out most of their work was just repairing credit, but it wasn't leading to housing.
But that does lead to housing.
But it didn't. It didn't. I mean, I think that's a supposition, but the numbers that they showed didn't. They had 14 people lead to housing, and most of the money was spent towards credit repair. And those people did not. The numbers they reported back, I think if you go back and look, and what she reported is they didn't get housing.
Well,
so they did the credit repair, but it didn't lead to housing. So that's what I kind of like to see. Is what I want to actually see. How many people are we getting rent assistance? How much is it costing us? How much housing are we building? It leads into that Tampa Bay Times article. I really want to see, what are we getting for the money?
Sure.
And I think everybody wants to know, what are we getting for the money? And I think the committee could do a really good job of doing that. And I think that would be something that would be worthwhile, because if for good investments, I'm all in.
Yeah,
For anything, and we need to weed it out, because I think clearly within this huge budget and the percentage of this budget we're spending these items, I imagine there's some probably areas that are problematic that we're not getting a good return on the investment. Maybe we need to cut bait on those things and double down on the stuff that's actually working.
I would agree. I also, though, would caution this council to realize how long it takes to both repair credit and to find a house to buy.
Well, maybe
so
you could track that over. Maybe you could go back.
Generally a 3 to 4 year process.
And maybe we could go back and track that and see. Yeah. Maybe it isn't just a fiscal year thing. Maybe it is going back 1, 2, 3, 4 years and seeing what actually it resulted. Because you're right, a lot of the social engineering stuff takes time. It's not something we can fix overnight. Well, Councilman Carlson.
Yeah. First of all, the committee is made up of the right people, the really smart people who know about this industry. So I have full faith in them. One question I would ask is, in the past, we've heard complaints that 1 or 2 developers were preferenced, that either by the housing authority or the city. And I think the only way we're going to hit the numbers is by doing a lot of small projects. And so how do we create more competition? How do we create lots of small projects instead of funding a couple huge projects? I think the huge projects go with the edifice complex so we can have big numbers. But if we have lots of small projects, then we can do that. Especially, as Carolyn Bennett says, up around the university area, around Busch Gardens, if there are areas that we could build, lower density. And then it's affordable there because of the land too. I think we should spend something like 70% on home ownership. And I would just like to ask the question of the committee, what percentage would you spend on home ownership versus rental assistance or some other program? During the buildup, we spent a huge amount on rental assistance, and that only helps somebody for a short time and then it's gone. So I would like to get their feedback on that, and also, what do they think are the most effective forms of developing home ownership, maybe in addition to the programs they look at every month. And then, most importantly, how do we be proactive in this? I call that putting out RFPs instead of responding to requests. When we respond to requests, it seems like there's a huge dollar amount that goes with it, and it feels like somebody wants us to subsidize their project. A subset of that question is, how much should we offer per unit? And that might be different by region, But if it was 375,000 per unit for 30 years of 80% AMI, is that a good amount or not? If we could instead offer 50,000 to help somebody buy a home, and so we could get 7 times as many people buying homes as we could renting, that would be great. Another thing is neighborhood lending partners. I hope that you all will meet with them. There's a way there that we can take our money and because of the way it works, you can only do it on single family homes, which I know you won't like, but that's got to be a piece of the mix. But the advantage of it is we can put money in and we get the same capital back at the end of the year. So we put in 10 million and the end of the year we have 20 million. And then the next year we have 30 million. So we can keep cycling that. The next question would be, what about the housing authority? Where are they and what are they doing?
Yes.
They're not even on the committee.
I think we should change the state legislation because I think it's a conflict of interest for a grant-making body to be a competitor to the private sector. So how do we deal with that? And the last thing is, and there's all this talk about zoning, to me the most basic form that we need to start with is neighborhood commercial district. So 2 to 3 blocks around a corner or a roundabout. This is not the same as a commercial corridor, but how do we build density, like where Jackson's Market is in East Tampa, there's a big piece of land. If the owners were willing, they could build affordable housing above that, and then we could build a coffee shop across the street because they're already a grocery store. We could build the kind of synergies there without trying to do it in big, long corridors. We just do it in a concentrated way so that we can build little pockets of density spread throughout the city. Thank you.
Okay, those are great. And then Mr. Vieira.
Yes, ma'am. And I wanted to bounce off something Councilman Carlson said, which was on a university area. And I'd actually made a motion. It got continued by the Planning Commission to look at an updated study for the university area for density, for housing, see how we can encourage that. So that is something as well. What areas can we build in that are being underutilized? And obviously the university area is one of them. And hopefully we can get something back good on that because folks from the community who talk about South Tampa without talking about any specific zoning case, obviously, have a point there. So that's it. Thank you.
Yes, and I appreciate that. And I would be remiss if I didn't say that right now the cost of building a house is around $350,000. Us giving $50,000 doesn't get people close to being able to buy a house. So there's a lot more to it. So absolutely, we have a lot more we can do, and this group is going to be really excited to hear about these questions and focus ideas. So thank you so much. If you have any future ideas, how can let me know through new business, and I'd be happy to bring them. And I will tell you now, I'm planning to, I will take this back, and then as we do our monthly report at new business, I will just go ahead and share what I've learned until we come up with a better system.
Okay, thank you.
Can I just add on to one thing that Councilmember Vieira said? If you remember, and just in case public's watching this late, if you remember the reason why it makes more sense in the university area, first of all, the land's cheaper, but also in South Tampa, where the affordable housing is, for whatever reason, the landlords during a hurricane shut off the power and the water. And we've had to fight every time to get it back on. This is not done by the utilities, it's done by the landlords. And the families don't have the money or resources to evacuate. And so it puts them at great risk by putting them way down on the peninsula. Thank you.
Okay, very good. And that actually concludes our agenda. And let's move on to new and old business.
I have one. I would like to make a motion to present a commendation to Susan Johnson, Urban Planner 2 with the Land Development Coordination Office. Ms. Johnson is retiring after 39 years of dedicated service to the city of Tampa and its citizens it serves. I will be presenting this commendation off-site. I believe her last day with the city will be Friday, February 9th, 2024.
We have a motion from Councilman Miranda, a second from Councilwoman Hurtak. All those in favor? Aye. Opposed? Ayes have it.
She's fantastic.
Councilman Vera?
Yes, sir, thank you. We had missed adding on the firefighter the quarter commendation, so I motion to have it put on the calendar for February 15th of this year, please.
We have a councilman, motion from, I'm gonna pause for a,
We have an incredibly busy calendar, including 2 different presentations already.
So how about this? I'll email my aide right now to see if we can work something out for the week after. And so I'll table that. I'll table that. Again,
Well,
'cause I can always make it.
We do have space on March 7th.
The problem is, I have to, because there's people who come present gifts. So I want to make sure that, including the
Well,
honoree, so we got.
But just so you know, the 7th is
So
also
read that.
Police Officer of the Month.
February 7th?
Mm-hmm. I'm sorry, March 7th.
Oh, okay, let me check.
Okay.
Because I gotta check with the fire chief and this and that. So again, I'll shoot over Brandon an email. 2 quick ones, if I may. I motion for, on the first week of April, a staff report. Let's do a written report, and if I need them to come in, I will. On safety and pedestrian improvements on 22nd Street and Fowler. Hearing some things from Copeland Park community on that area and what we can do to improve safety there for pedestrians.
there's a motion on the floor by Councilman Viera. Is there a second? There's a second by Councilman Carlson. All those in favor, aye? Aye, opposed?
Yes.
April 4th.
Yep, and if they need more time, that's fine. We always have Gold Star families come into City Council for like a 5-minute just presentation to remind everybody what Memorial Day is about. And I wanted to schedule for that to be on May 23rd. It's a workshop, but there's nothing on there. It's the closest date to Memorial Day, and it usually takes 5 minutes.
Yeah. On these things, as much as Gold Star families and all these great people, I'm glad you mentioned 5 minutes because we need to really limit it. So
And that was my point is, we did have that discussion about not having this. I mean, as good as these discussions are, these schedules are getting so crazy that, that we're just gonna have to kind of, I mean, I'm not gonna vote against Gold Star families. But I think in the future, we really do need to, because we've had this discussion, we've got to abbreviate these schedules, and this is one of those things it's got to give.
And obviously very well taken. I'm looking here, it's on the May, oh wait, this is June.
May 23rd is the workshop session.
So City Council regular
And then we have an
is on the
evening session.
16th. Would
Yeah.
council feel more comfortable if we did it on the 16th?
it's more about the length of it, I think.
Yeah, it's not the.
And it would be 5 minutes. I mean, it usually.
Well, I should point out, council, that as part of the processes, when you get to new business, I have some things that I'm going to ask for a continuance on. But on the subject of Councilwoman Councilwoman Henderson's motion, one of the suggestions would be to not have any presentations at all on workshop days.
That's why I asked that. Yeah, so, and obviously I understand, I always like to have something for Memorial Day, and obviously everybody supports that, I'm not, and so I would ask for this one thing, and I promise we will limit it, 5 minutes, I won't say anything, no Louis Vera specials. So.
And one thing that would help is if it's one person
Yes.
instead of a crowd of people, because then if everybody talks, and it's not that the topic is not fantastic, but we're reminding people of what Memorial Day means is a great idea. Just if it's 30 minutes, then it takes away from everything.
Well taken, absolutely.
Okay, so we have a motion on the floor by Councilman Vera, second by Councilman Carlson, I believe. Is it?
May
Councilman Carlson?
16th or 23rd?
23rd.
23rd.
23rd is the workshop, though.
If council's so amenable, if y'all want, I can do it on the 16th, whatever.
I would support the 16th only because we literally have nothing right now.
Okay.
Okay, we'll show us the 16th, okay. So all those in favor say aye. Aye, opposed?
Thank
Ayes
you,
have it.
council. And by the way, if I may, and thank you, everybody, for just all the hard work and digging in on that Tampa fire thing, because that was a long time coming, and just everybody put a lot of work towards this, so just thank you.
It needed to happen. Okay, Councilwoman Hurtak.
I just want to say that I'm really looking forward to a robust conversation about the difference of policy and code when we do this code rewrite. Now, I'm not gonna be I've been warned to not say more, so that's all I'm gonna say.
Thank you. Councilman Carlson.
But if you put a footnote and bring up a motion another time, that would be a good idea. We need to.
I agree, but I think that we can talk about that during the, since we now apparently have a group that's doing that. I do believe that we should highlight it and maybe insist that.
And maybe design exceptions too.
Yeah, I think we just need to, I'm really just looking forward to the whole overhaul.
On February 22nd, there's an item related to city ethics, and the staff is asking what that is. Apparently, I put that on, but I thought I had previously removed this from the agenda because we dealt with these issues a year or more ago, and so I would just like to make a motion to remove that from the agenda.
So we have a motion to strike that agenda item, a second from my Councilman Carlson, a second
From February 22nd.
from February 22nd, a second by Councilwoman Hurtak. All those in favor, aye?
Aye.
Opposed? Thank you. Okay, so I have one.
Can I just say real fast, that I won't make a motion, but I've heard a lot of rumors about residency of staff, and somehow we've got to figure out a way to confirm residency of folks and all the different levels that are required to have residency. So we'll bring that up another time. But the last thing real fast is Joe Lopano from Airport announced his departure today, and he's going to be here till 2025, so we can do something for him in 2025. But I just want to thank him for all his fantastic service in turning our airport around. Thank you.
We've had a lot of great leaders at the airport, and he's one of them, definitely. In front of you, I have, and this mostly will be for the public, because you guys all have written documents now, and I'll make sure that the council persons that are not here have got this. Some of it will be in your email. So we are in the midst of hiring our long-awaited budget analyst. The applications have been received, and just for the public's information, we had 33 applications were submitted. There were 12 applicants who met posted minimum qualifications. 21 applicants did not meet the minimum posted qualifications. HR has those applications now, and by sometime this evening, everyone here on council will receive a link to the applicants, all of the applicants, including the ones that did not meet qualifications, in your email. So this is what I'm proposing. That we are sending your pre-approved interview questions to the qualified applicants on February 12th, 2024. Currently, there's 12. Applicants will reply within 7 days by January 12th, 2024. And by the way, a lot of this is because this council had expressed a desire to onboard this. So a lot of this feels rushed. And by the way, we're already 2 weeks behind. So we're trying to catch up and compress the schedule and do as quickly as we can. Applicants will reply within 7 days by January 12th, 2024. I'm sorry, February 12th, 2024. That's a typo. I will talk to the person who typed this.
We're going to send it to them on February 12th. Oh, 19th. So it would be February 19th.
February 19th, yeah, okay. Tim, if you're listening. And answers will be distributed to council members. Council members will review the applications, including the resumes and the responses to the questions. So they're going to submit those. All the council persons will get their application, their resume, and the answers to all their questions. Council members will then rank the applicants from 1 to 12 in the order they support the applicants. We're doing ranked choice voting. Number 1 would be the council member's first choice in the position, and 12 would be the councilman's last choice. After the office receives all of the rankings from the council members, staff will tabulate the responses and rank the applicants based on the responses from council members' points. And they'll be awarded. So that what we're basically going to do, I'll abbreviate this, is we're going to weed this down via the applicant resume and answers to the questions and the ranking of all of the council persons. We're going to rank it down to the top 4 applicants. Those top 4 applicants will be informed, and then council will schedule a public hearing so that we can interview those top 4 applicants. And then when we interview those top 4 applicants, once again, we'll use ranked choice voting to rank the persons in accordance with your first pick down to your last pick. that won't work. We propose not using that as the absolute selecting factor because then we'll have discussion and we can use that as give it the weight that it deserves. No pun intended for the ranked choice voting. But that's the proposal. I've included in this as an updated draft timeline of what this is actually going to look like. And that is a tight timeline. Any questions? Councilman Carlson.
Yeah, excellent. Again, thank you to you and whoever worked on this. I would just, I couldn't email you back, I think, so I just want to add one question. And that is, do you have any familial or business relationship with the mayor, any city council member, or any senior official of the city? And if so, what?
Could that be included in the verbal interviews with the top 4 candidates?
I think it's good for, it's good to disclose it.
Okay.
That's, it's an ethical,
Can you or your aide email that to Tim so that he can include that in there?
Am I allowed to do that, Marty?
I also think, isn't that just a question period to be considered? Isn't that an HR question just to be considered for an application? Because I mean, we have to, when I was on the variance review board, when I was on charter review commission, they asked that for everyone.
For civil service board too.
So let's find out about that.
Well, it depends. For this position, it's not an elected position, it's an appointed position.
Quite honestly, it's a good question.
It is a good question.
It is a good question, but there are people in the city who are related, who work in the same departments. Maybe as long as they're not supervising their own employee, that's their own relative, that's nepotism. But short of that, you can have the same family working throughout the organization.
But they have to disclose it.
I'm sure Tim is listening to this. Tim, let's add that question to our questions. Councilman Hurtak.
First of all, I need a deadline, because if you don't give me a deadline, I'll work on it forever. There's no deadline for council members to respond. It just says.
I think we said 7 days, did we not?
No, we said 7 days for the applicants to respond, but when do you want us to have our tallies in? Because if you don't give me a date, I won't do it.
Well, Tim and I did discuss 7 days, so it was 7 days after you received.
So the 26th then of February? That's 7 days after the 19th.
You probably have to collate everything or put something in a form of fashion.
Oh,
that
that's
gets
a good
everything
point.
to council.
So it'll probably take a couple days just to get it to us.
Yeah.
So what about February 29th?
What we have is that the final 4 candidates will be announced on February 22nd. We had that we were going to distribute it on February 12th, so we actually built 10 days in there, but that was actually for us tabulating it all and announcing it.
Yeah, but we're going to send the questions to them on February 12th, so there's no way we're going to get them back and have them distributed by the 12th.
We are going to, I was looking to see if that is Tim. No, we are actually sending, okay, I should have actually read this before I started announcing qualified candidates on February 12th. No, I think that we were supposed to send the applicants questionnaires on February 5th.
See, I think that's too soon, because I'll be honest, 19 questions is way too many questions to ask, A, 12 people to answer in a week, and B, me to read. Like, I'll just be honest, 20 questions, I do not have the capacity to read 240 questions.
Well, so just whatever you do is just gonna add to the timeline, so we really did try to compress it. So why don't we propose, you propose a timeline and we can move with that? I think you're the one that was most sensitive with getting this thing on board
too. It's not
too.
the timeline, it's the number of questions. I think we need to reduce it to 5 to 7 really solid questions. Like, if we ask what your lowest point is, everyone's gonna say, I worked too hard. So I need, like, if
these are all, I'll be honest with you, I've done a lot of hiring, and this is kind of like standard assessment type of questions.
But I think they're good for asking maybe in public, but because all anyone's gonna say for that is, my biggest failure has been, I
accomplished too much.
Yeah, like number 6 is great. When have you been tested outside of your responsibilities, and describe how you handled the situation? I mean, just something like that, but there's multiple iterations of this question. So if we could just tighten it to 5 to 7 questions, I think you'll be able to get our responses, because otherwise after like application 5, I'll be done.
Councilman Vera.
Yes, sir. And I wanted to echo what others have said to just thank you, Councilman Clendenning, because this obviously, you and your aide, Tim Haberline, this obviously took a lot of time and everything, and this is something that we've just learned how important it is. And I always like to do mea culpas. When this was brought up by Councilman John Dingfelder in 2019, I think it is, I voted no on it, and I was wrong. So, just kudos to him and kudos to you and all that work, because this is necessary. Thank you.
Well, I mean, why don't we right here look at these questions? Can you pick like 4 questions you want to X out?
I emailed it to Tim. You want me to give you the email? Ms. Sharfy, if you wouldn't mind just trying to figure out, so just taking a quick look at them, like what specific skill set do you bring to this job? That's number 11. Like that would be in their resume, to me, in terms of like what kinds of things you've done.
Well, I think you're looking at very analytical, and a skill set is more than just analytical. I think that there's also things that are not, you express that are not in a resume. Like your verbal, other things that you have in your life that you bring to be able to function in this type of a government environment.
But I'm always thinking about how someone's going to answer that. And if I was an accountant, I would not add my soft skills. Just saying. It would be.
You failed my job interview.
Well, but I'm just saying that when we're looking at it, we have to look at who's responding and how they're going to respond, because written questions are always going to be answered differently than verbal questions.
I will say that these questions were also crafted with the help of the human HR.
Okay.
And I mean, so just so you know, these weren't done in a vacuum. Based on some, I actually did eliminate some, by the way.
Okay.
I mean, I eliminated quite a few actually, because trying to make them more applicable to city council function and not administration function.
Well, then how about this? Like number 2, how did you find your current or last job and why did they hire you? Because there's no way
I'm okay with
they're going to know why they were hired.
Yeah, I mean, I'm okay with that.
Could I just say, it seems to me that a lot of these questions are the kinds of questions that HR would use as an initial screen, and the purpose of this is just for us to evaluate after that.
As an initial screen.
Because you've already been through them and HR's been through it, right? So then the reason why this list would be shorter is not that somebody didn't ask these other questions. It's that
the list was short just on basic qualifications.
Yeah, we just have to we now have to try to rank the short list of candidates.
Yeah, so this is the initial screen of people. These questions are the initial screen of people that met basic qualifications. So this is the initial screen. I mean, we could have abbreviated, but I didn't. Everybody felt, and there was a meeting between a few folks that I wasn't involved in. Lisa was involved in that. They felt that council wanted this type of involvement.
Yeah, and so like I'll just go to continue.
Okay.
I would like to take number 18 out, what has been the lowest point, because someone's going to write a fluff answer to that.
Okay, that's fine.
And if we want to do, that's a more one-on-one. And then I think number 9 and number 15 are very similar. Tell us about a politically sensitive issue you encountered in your career. How did you balance the various competing voices involved, and what was the result? And then 15 is tell us about a time when politics had the potential to impact a project. What was your role in resolving the issue? So those are both about about politics. So I think if we could combine those two and ask one question about how you handle politics.
I mean, I think they're different questions, but I'm okay with eliminating one of them. I mean, we're not gonna live or die on either one of them.
May I make an unpopular suggestion?
Mm-hmm.
Yes.
You're missing 3 council members, and this process is supposed to be collaborative and have a buy-in. May I suggest that they have an opportunity to see these questions as well?
They do.
They do, but they have no opportunity to respond. So, and by the way, just from where I sit, politics is my third rail. If there's one thing that I think you all know about me is that when it comes to politics, you want, at least for me, I want to be apolitical. Because I don't play favorites and I don't want to get involved in the politics of the organization. So I'm just sharing that for what that's worth. What'd you say?
We all know I'm your favorite.
Then how about
Always
this?
favor Ally.
What's the date that you want us to reply to these questions? Because I replied to them once, but I'll do it again. When do you want to have the answer? No, if these are supposed to go out the 5th, and today is the 1st, when do you want
Well, I mean, I guess my question would be, when do you feel comfortable with it? Because this is not, I was trying to conform with the wishes and desires of council on what you guys were asking as far as onboarding this budget. Because as we're preparing to go into next fiscal year 25 budget, we're trying to onboard this person so that we could be prepared for that. So
Then,
that was,
how about this? I'm gonna look at this tomorrow and I will have it to you by end of business.
okay.
How do we do this without breaking sunshine?
Very difficultly.
Send it to Marty.
Well, can't they just send me, this is just questions for the applicant. This is not, these are just questions for the applicant. So they're just sending me suggested changes to this or strikes of questions for.
If I may, can't we, we send out memos all the time. I want this, I want that. Can't we just do it as a memo?
Sure, well, the thing is,
no
so what they're
responses
doing is they're going, you're just going to take council and you're going to take council suggestions and formulate it and then send that out.
Correct.
Okay, that's fine.
Okay. Because we're not debating policy or,
Anything that you're reasonably going to vote upon.
we're not gonna vote, yeah, exactly.
I'm not gonna send one because I only had one change
Okay,
in that. I
okay,
already
we're
sent.
adding that. Okay, is there anything else on it? Okay.
I'll send it to you tomorrow by close
Okay.
of business.
Sounds good, thank you. Okay, well, that is it on, is there any other new business? Are we done?
Oh, gosh, yes.
Oh, God, we have, okay, since I'm your favorite, we'll let you talk.
Okay, thank you. I have two requests. On the 15th of February, I have two items relating to, one is to report on setting up a council rule to limit walk-ons. The other was just made recently by Councilwoman Henderson to meet with council members individually and to return with recommendations to amend the rules and procedures to address the order of business, et cetera, et cetera. There's also something on March 7th that the legal department to present a draft ordinance to require agenda items to be automatically continued for a week if the full presentation is not. It's all related to your order of business and the running of meetings. I am going to request that the two items that I have on the 7th be continued to, on the 15th, be continued to the 7th to hook up with that item under staff reports. The legal department is also interested in having some suggestions, and part of the issue of, let's say, for instance, the discussion about the presentations for staff reports is what constitutes the sufficient backup material and background material necessary to satisfy council without having each one be a thesis. So the question is, and that is a work that I believe that the chief of staff is engaged in internally, and I think it would be better if this all is synergistically presented to council on March 7th.
Councilman Hurtak.
I will move both those items because you and I have already spoken, but I know it's gonna take a while to get all that stuff together. So it's the motion that council attorney to report on setting up a council rule to limit walk-ons and council attorney to meet with council members individually and return with recommendations.
And both?
Move both to March 7th.
Thank you.
To be heard with the others?
The legal department to return, that's a separate motion, to present a draft ordinance to require agenda items to be automatically continued if no full presentation.
So then before or after?
It doesn't make a difference, we'll work it out.
Okay.
Okay, we have a motion from Councilman Hurtak, a second from Councilman Fier. All those in favor say aye.
Aye.
Opposed? Ayes have it. Councilman Carlson?
Could I just say the one motion that I made about documentation being on base, what I mean by that is anything that they plan on presenting on Thursday. And so, like in the case of the budget one, there was a basic document, but the PowerPoint was not there by last Thursday, and now we got it in advance, and it was a great discussion. Nothing negative happened in it. And there are others like that. The 3-bid thing, there was a document that was still not included. But if all the documents are in there, then we can read them, and it gives us, it can help us shorten the meeting by not having to ask as many questions.
Absolutely. And I know the chief of staff is very interested in addressing these items.
Mr. Shelby, you had something else?
Yes, I do. The city's been contacted by the Planning Commission, and we have a member of City Council who is a member of the Hillsborough River Board, and Councilwoman Hurtak works with that board, works on that board with the Technical Advisory Council to the Hillsborough River Board, and the City Council's appointee a gentleman by the name of Mr. Richard Formica has been on city council, has been on that board for many years, and wishes to retire from that position. So the Hillsborough River Board Technical Advisory Council is looking for city council's appointee to replace Mr. Formica, and that could be done either by council, or that can just be a recommendation to the chair, and the chair can make that appointment per the special act. So what I'm informing you of is the need for somehow Chair Maniscalco to get a nominee or a recommendation for council's appointment or to be appointed to the Hillsborough River Board Technical Advisory Council. And we can do that at a later date, but I just wanted council to be able to please think about an appointment to that. And if you have any questions or anything you want to add about the Hillsborough River Board, the Technical Advisory Council, Councilwoman Hurtak, or you don't have to tonight.
Well, why don't we say that we will, if we have any suggestions, we'll provide the chair by March 7th.
If you could just provide it to
That's
me.
a great
If you
idea.
could just provide it, yes, thank you. By March 7th, if that could be?
Yeah.
Okay, if that, do we need that in the form of a motion? Yes?
Okay.
And to provide that to Lisa Edwards, please, in the
We
office
will
of the
provide
chair.
Lisa Edwards with, if we have a suggestion, by March 7th, we'll provide that name.
Thank you so much.
Okay. Any other new business? Oh, all those in favor, aye? Aye. Opposed? Okay, ayes have it. Any other, is that it? Okay, motion to receive and file? This is done.
Oh, but we have to, all in favor?
All in favor?
Aye.
Can I turn this off?
We are adjourned.